Only 1 week left.
May
Why mention now?
I play one analysis matter?
I'll start from that side. Yes, Mr. Bose. Suppose come after the vacation. I mean, 3 days left. What is the urgency?
Section 8 charitable section 8 that has gone into resolution plan application but result if it is passed given to a commercial
Where relief is granted to move the vacation bench. Yes. Hey, pond filling? No. Yes.
all prosecution will not be obtained an order to injunction under the bank guarantee.
Hand over. Non-prosecution to Didi.
That the work order will be issued on 18th of October 2026. Similar type of tender matter, your lordship has granted stay. On 18th of October, your lordship may take it or any dates more there.
We'll hand over it. Upgrade Didi. Yes.
My lord,
may have a lot
I'm the
for
qualified
release,
bidder.
for release, my lord, for want of determination.
No.
Yes. May I mention one item number 1046? The matter was taken up thrice, could not be taken up here because of the illness of Mr. Amit Banerjee, senior standing counsel.
Come after the vacation.
Your lordship, only this payment, your lordship can fix 17th of November. The urgency is there. Otherwise,
Come after the vacation.
My lord, application under section 14 is pending for 2 years.
Not before vacation.
17th 17th November.
No, nothing.
Madam,
Come after the vacation, I said.
Yes.
Invited you during the this week, my lord, and the our matter is pending before your lordship.
It upgraded Didi. We will hand over.
My lord, I am the qualified.
Yes. Appointment is given in favor of Emar Kaji. Come after the vacation. Appointment has been given. No. Come after. No. After the vacation. Yes.
From the very beginning, I have been mentioning. Let it appear, my lord.
Not before vacation. Yes.
After vacation.
Yes. Next. Mr. Ghosh. Yes. Yes, you. Where? Can't hear you. It is appearing in the list. Item number? Hand over. Yes,
My lord.
from that side. Non-prosecution at 375 upar diye dito. Please write in a slip of paper and give. Yes. Dekhen na to. Please hand over the slip. Yes, I'll go. This is the last time. Yes, Mr. Yes, what is your? Please come back after the vacation.
My lord,
After the vacation. Yes.
I am saying the urgent motion for permission of
Durga Puja, now it's already over. I mean, you cannot prepare during this period. No.
application on 12th, my lord.
এটা কালকে টপে দিয়ে দাও তো। Yes.
To mention one matter, one piece of your lordship. My client will be engaged.
In?
My client will be losing. He is working in there, and that matter has already been tendered as item number 2, serial number. I am not objecting to the tender to shut down, but only my work is to be deleted from that. But will kindly allow me.
Before vacation, why before vacation?
In the meantime,
No, there are so many matters. No. Come after the vacation.
trying my best from last week.
Please come after the vacation. Yes.
In the meantime, work order.
Next, please. Yes.
As per your last occasion.
Yes.
On the last occasion, Lordship has directed the other side to file the affidavit in opposition matter within 4 weeks, and within 2 weeks we have to file the application matter. They have not filed. We have not received any copy matter, and hence we filed this application.
Whenever it comes up.
The fact is that we are enjoying in the puja vacation matter, and the petitioner is suffering a lot. He deal with his day-to-day needs matter, as because the huge amount has been withheld by the bank authority.
This cannot wait till after the vacation.
No, my lord.
No. Next.
I am qualified bidder, not getting the work order. Social welfare scheme for weaker section of the society, my lord.
Qualified bidder for what
For
job?
tender relating to weaker section of the social welfare scheme being ran by the state government.
So what are you challenging?
I am not getting the work order. Huge
Come after vacation.
And
Yes.
for 134 of today's list, it says with regard to electricity connection, I will be out of electricity during this festive season.
Hand over. এটা টপে দিয়ে দিও।
I'm grateful.
Mention before the vacation. Vacation bench. Leave to move before the vacation bench. Yes.
Install electric meter, bring connection to the neighbor's house by installing a meter in my house.
Yes, Mr. Banerjee.
Tomorrow is the date of installation.
Sale was scheduled on Friday. But I've taken out the application, item number 75. But DRT is not come.
কালকে টপে দিয়ে দিও। Tomorrow top. Yes, Mr. Bhattacharya.
Some urgency there, like, I've been disqualified and the tender is like, open measure, the price bill and the work order is.
কালকে দিয়ে দিও এটা টপে।
Have been disqualified for the dealership and professional license has been.
Come after the vacation.
Put down showed by the private restaurant.
Come after the vacation. Yes. Hand over.
Not functional, 6th of November is the date of sale, Mother, Friday.
No.
It's property to sold, Mother.
No, it does not affect you directly. Yes. Section 14 come after the vacation. If enough section 14. Yes.
My decision has been cancelled with the matter itself.
Come after the vacation.
Similar item number 90, similar item number 92 is I am the so that if the urgency matter of that is an employee of the Kolkata Municipal Corporation and he withdrew his salary from SBI Bank, but SBI Bank kept for holding his bank account without any prior notice and without any prior reason. And the petitioner is suffering from very much financial trouble.
What is your occupation? What is the job? You are an employee in what capacity? Come back after the vacation.
Kindly
Next.
number 180 and 180.
Pardon? No. No.
Lordship, regarding item number 188 and 189, this is an application against the order passed by the DA. Actually, Lordship, appeal was preferred under section 7 of the Unauthorized Occupancy Act. That proceedings is pending. No order has been passed. Subsequently, another proceedings started against.
What is your immediate urgency?
Any day they will dispose of it.
No, no.
On 28th.
No. Yes.
In this matter, urgency is that this matter needs to be required to be heard by the court because 7 lakhs of money has been lying with the respondent. By taking advantage of this vacation period, at any point of time, this money can be forfeited by the respondent. My lord.
Next.
May I have your lordship kindly to mention a matter for extension of.
When does it expire?
It expires in this week, matter.
We have
Hand
to
over.
kindly, this matter is appearing under the heading upgraded. Now, 68, it is gradually coming down. Your lordship considering the.
It is? What is this? What is the matter regarding?
Regarding the award published by a bench, that has been completed by myself within a period of 16th of November.
Yes.
Now, I have to pay within that. The first installment has to be paid. That has been gone. If it is not completed, I am ready with the 1.70 crore rupees. Now, the
Not
kindly
before
appreciate.
vacation, sorry.
It is appearing.
Auction sale is on 18th. DRT2 is not functioning.
Hand over. এটা দিয়ে দিও আপনি।
I am praying for leave and hearing.
Similar with whom? So many mention.
Urgent hearing of the same.
What is the urgency?
The urgency is I took a loan, I couldn't repay. Account when NPA, notice was given. Again, the CJM Barashat passed the order to take the physical possession. My lord, I filed an application before the DRT2 manner. Here out my application. My lord, DRT2 is not.
Hand over. এটা leave দিয়ে দাও। কালকে থাক। Yes.
Urgent requisition, the sale notice has been given, the sale is scheduled to take place on 19th October. DRT2 is not functioning.
Hand over. এটা upgrade. Leave দিয়ে দাও কালকে থাক। Yes.
My lord,
The matter has been appearing in your lordship's list since the 11th. I'd also mentioned this matter on the.
What is the urgency, please?
Urgency is the auction, e-auction for coal has started from the 11th of October. And this is a similar matter, the company is blacklisted. And because of this, the company is unable to participate. In terms of the eligibility conditions set out, the company is entitled to participate in the auction. So the urgency is unless your lordship hears out the matter before the vacation, then the petitioner company would lose out on its opportunity to participate in the coal auction.
Mentioned before the vacation bench. No. Yes. You have already finished. Yes, Mr. Samant.
Matter I mentioned, but during the pendency of the matter, we have cancelled this Reduca certificate, my entire thing, because they will send the document and my MBBS and everything.
No, Mr. Samant, come back after the vacation.
I mentioned, Lord, your lordship.
Cannot take up so many minutes. No, Mr. Samant, no further upgradation. Yes. You have already mentioned. I told you no. Yes. Next.
Urgency lordship is crying.
No, please. Yes.
Lord, the matter may be listed as to be mentioned. It was to be mentioned. My lord, matter has become infructuous. My lord, nothing.
No, no. Yes. Is it a free for all, ma'am? Please stop it. Please stop it. You must know where to stop. You are an advocate of the court. Enough is enough. Your apology is lip service, ma'am. You are continuously disturbing the court. Because you are a junior member, I was not so harsh the last time. Don't continue this. Don't do it before any court of law. Stop it, please. Go and take a seat behind. Go behind. Don't stand in the queue. You are a junior member of the bar. You don't know how to speak, how to address a court. I told you no, it means no. Just because I am not being harsh, you are not stopping. You are going on and on and on. If this is the morning shows the day, ma'am. If this is your beginning, your practice is ruined, I'm telling you. What is your name, please? Yes? Please be louder. What's your name? Please take your seat. Yes.
This is for upgradation.
Why? What is urgency?
Urgency is that SDO has cancelled my ST certificate and the private respondent has already lodged a complaint against me regarding the ST Act.
Not an urgency. Yes.
Item number 119, my lord. Urgency, I'm seeking for upgradation, my lord. Urgency is the petitioner is a practicing advocate of this court, my lord. He has been suspended on frivolous grounds by the Bar Council of West Bengal. Palpably bad order. And suspended for 2 years, my lord. My lord kindly takes it up.
Hand over. It is upgrade.
My lord, I have mentioned 24 electricity matter. 4 and 5 has been in the list. Remaining matter will be listed in the before vacation, my lord. Electricity matter.
Hey, key matter.
And one day, my lord, one day must be electricity for
Let us see, sir.
Otherwise, it will be.
No, may not. Yes.
It's a mentioning for correction of an order, my lord.
Correction handover, yes.
Parkinson's matter, my lord. Already,
yes, please.
File has already.
925 of the combined list, my lord. The matter, it is upon the heading upon mentioning, my lord. If it can be taken up before vacation, I'm just.
What is the urgency?
My lord, urgency is a matter relates to a 10-year-old child who is residing in a home. He has lost his father. His paternal aunts used to visit them, but after the COVID
what are you wanting now? The relief?
My relief that only the visitation right, the paternal ones aunt wants. That is.
Is in adoption or something? I mean,
no,
why
my
read
lord.
petition? How can read petition be maintained?
My lord, the CWC and the home.
CWC already.
Yes.
It I put it. Yes,
Grateful
please
to your
give.
lordship. I'm giving this. Grateful to your lordship.
My lord, matter already mentioned, your lordship granted the mentioning. File has already come. It's a matter of circuit bench. Just only on typical errors in the order sheet. I'm deeply obliged.
This is a division bench matter. Ask for an assignment from the Chief Justice.
My lord, your lordship were pleased to pass the order.
Call list.
Do we mention item number 1 for non-prosecution?
My lord, I am appearing on behalf of the petitioner, my lord.
Lord, counsel for the petitioner submits that the petitioner does not want to proceed with the matter. Full stop written instruction filed today be kept on record Accordingly, WPA 21632 of 2022 is dismissed for non-prosecution without any orders to cause.
Obliged, Lordship. Madam,
Next.
Item 2 for non-prosecution.
Lordship, I'm appearing for the,
Same order. You are filing your written instruction? No.
no,
শুধু
Lordship.
written instruction টা বাদ দিয়ে বাকিটা এক থাকবে।
Lordship,
Affidavit of service filed today be kept on record. এটাও বোধহয় একই হবে।
Item 3.
3 same.
affidavit of service.
Same order. 2 or 3 same.
Item 4 for non-prosecution.
In this matter, I am appealing for petition. The client do not want to proceed with the matter, madam. Written instruction has been given.
ওয়ানটা যা অর্ডার হলো সেটাই।
I
One.
appear for the response.
Similar as one. Great. Thank you. এইটা দিদি।
Item 5.
What is the matter, please? Why to mention?
Lordship, this matter relates to police, my lordship.
Please use the microphone.
Lordship, this matter relates to police. And as I was submitting on the last occasion, my
Can't
lordship,
hear, please use the microphone. Relates to?
it relates to police authorities.
Police,
my
or
lordship.
police in action. In view of lack of
My
determination,
lordship, on the last occasion, my lordship pointed out that my lordship can also hear this out because this concerns, my lordship, may I say, if my lordship sees paragraph 6 once, my lordship. It concerns both BDO and the police. So if my lordship wants to hear it, I will be most happy if.
no.
My
What is the
lordship,
nature
who-
of your allegation?
My lordship, I am a person who has a land on lease, is running a hut with proper license. Now this BDO and the inspector in charge, my lordship, in connivance with my landlord are not allowing me to run my hut, my lordship. Now this puja season, my lordship, that's why.
Your effective order is against the police authority.
Yes, my lordship.
Since the effective police in action, effectively. Even if the BDO cooperates, the police does not cooperate, it won't happen.
If my lordship
But
passes
the other way
order-
around, it will happen. Need not. I mean, this objection will be raised later. The predominant prayer in the writ petition pertains to police in action. Full stop accordingly, due to lack of determination,
may it be
let the matter be released from my list with liberty to the petitioner to mention before the appropriate bench for inclusion.
Grateful.
Next.
Item 6 for non-prosecution.
Lordship, I'm appearing for
You're
the
filing
petition.
written instruction? No.
Lordship, you may record my submission that the matter has been settled. I have got this.
Learn counsel for the petitioner submits that the matter has been settled out of court and the petitioner does not want to proceed with the matter. Accordingly, WPA 22641 of 2023 is dismissed for non-prosecution without an orders to cause. Next.
Extension of interim order.
I appear for the
Item 7.
petitioner, my lord.
I appear for the response.
Interim order, my lord, was originally granted on
Puja-
20th March.
Before puja, I will not ask for hearing, my lord. Let the matter be placed for hearing after the vacation and.
What is the nature of interim order?
My lord, the interim order was that a letter by which, my lord, they sought for a refund of the money from the bank that was stayed, my lord. On 12th March, my lord.
The interim order granted earlier is extended till December 22, 2023 or until further order, whichever is earlier. Full stop. The matter be listed for hearing on November 28, 2023.
Great.
Top item. Item 8.
Yes, please, your lordship,
Yes.
I appear for the petitioner. Lordship, this was the matter where your lordship had asked us to find out whether the probate has been taken. Your lordship, I have gone through the records personally. It is imperative that your lordship looks at the will. It has nothing to do with the money. As kindly looks at the will for a moment. The will is only confined to Prachi Cinema. How is it to be run?
Do you have a copy of this? Of the will?
Lordship, I'll give him a copy.
Ajay, what was the matter pertaining to Ms. Victor?
Lordship,
Just please indicate.
it was a question where my client was a nominee in respect of a particular amount in the Public Provident Fund, PPF. There was an earlier order of the court that the money should be kept in a fixed deposit. My learned friend himself had said that the nomination part was over when the money was handed over to me by way of a court's order. Subsequently, we did not withdraw the money because there was an injunction of this honorable court that I should keep it in a fixed deposit. I kept the money in a fixed deposit. Now this suit where this order was passed has been dismissed. They have not taken any steps for getting the matter heard.
They means there was a rival claimant.
There was a rival claimant in that suit. That suit has been
Dismissed for
dismissed, long dismissed. No steps have been taken for restoration. I now say there was a question that there was a will. I should see the condition, whether probate has been taken, what is the steps. But I have gone through the will. The will has nothing to do with the money that was in the public provident fund. The will is confined to running a Prachi Cinema Hall. The manner it is to be run,
Does not have anything to do with the bank.
nothing to do. Therefore, my humble prayer now, Lordship, before anything else, now, in fact, the money is my money. I am saying a most innocuous prayer. I am aging. I have several ailments. Let my son's name be included. Otherwise, tomorrow the bank will say, nobody is the claimant of this money. The money goes. Therefore, I was just praying at the moment, Lordship hears out the matter, but at the moment, let my son's name be included in the, because in this particular fixed deposit, it is as if it is my money which has been put in a fixed deposit. I did
Who was the rival claimant?
rival claimant were
Related to the deceased.
Jiten Basu, some distant relative had come forward saying that they may have been, they were primarily interested in his property, particularly Prachi Cinema Hall, but also any other assets that he may have had.
So, Sina, if the
Page 22 of the order of the, I want to just show you that.
Lordship.
Last one. They are no way connected with the deceased person, but the
nominee
Nominee. Lordship.
nominee paid to them.
Yes.
receiving hands only.
Page 22 last Friday.
Yes.
I did not touch the money.
If there is no other claimant, then the
Lordship,
nominee has to take.
why is my learned friend so?
I am a bank, I can make the payment, but point is that, my lord,
No, you are fairly pointing out. Yes.
he's not nominee. He's not the nominee. Nominee originally in the PPF.
Yes, that part
money
is
was paid.
over.
That money was PPF.
Paid to her.
Account, she was a nominee. So nominee was paid.
She was a nominee.
There are court said,
Yes.
there are other years. So they have the claim. So you keep the money in separate account.
Nobody is coming up. It cannot lie.
Suit has been
indefinitely.
dismissed.
Then the court said you keep the money in a separate account
Mhm.
and it should be paid to him also.
No,
it also order captures that also. It should be paid to petition also. That is
Should be paid to petitioner also, means?
the claimant.
Where is that? Page 22. Yes. He was to put it in a fixed deposit.
23. Disbursement of money will not be made in any in favor of any person,
Yes.
including the first defendant.
Without the appropriate person obtaining such order as
Not
may
the
be
first
necessary.
defendant there.
So therefore, we thought it. Then court said there is a court said there is a will. Now we don't know what is the will.
I'm giving him a copy of the
No,
will.
no, I'll pass an order. This will be the appropriate order. They are the appropriate person. I'll pass that order.
Lordship.
Let it be on the court.
No, not a relative, my lord. Relatives are there and nobody is getting the money. And not nominee. Let us not forget the nominee. Money is standing in their name.
Lordship sees the will.
Money cannot go stale
Yes.
unnecessarily.
Yes, sir, there.
Money has to be used in the economy for the economy to thrive.
Not person no connected with that.
What is
That is
the
the relation.
Nominee.
what is the bank's
Nominee, my lord. That present no nominee. Originally there was a nominee PF account. Thereafter, amount of cash in a fixed deposit. In a
Fixed deposit
I
was
could
by
have put
virtue
it
of
in
order
any
of
bank.
court. Ms. Mitra, both of us cannot
sorry,
speak
I'm
together.
so sorry.
Nominee was in respect of a PPF account. He was the nominee. He received. Then it was put in a fixed deposit as per order of court.
And said that money should not
Court
be-
said what I have seen there.
Then, my lord, the money.
There is no further question of any nominee.
Payments came forward. They filed a suit.
Suit has been dismissed long back, not restored.
Not paid. Now, we thought it when the order itself captures there is a provisions, then propounded will. So therefore, proper order is to be brought. There is order it says that.
I'm giving him a copy.
Order
of the
just
will.
balance is order. I don't know what is the all asset or only Prachi. I don't know. So
I'm giving you a copy of the will. Please.
the thing is, I have no problem. I mean, the court order will make the payment. But later on, then the heir will come from. He is not a heir.
Lordship kindly sees their own letter to me.
Please come to page 6 of the will, the last paragraph.
I once again declare and direct.
This is only entirely relating to the Prachi cinema.
Lordship.
This account has no connection with Prachi cinema.
No, it has nothing to do with Prachi Cinema. It was a public provident fund, PPF. Lordship, this is entirely confined. I went through the will. It is entirely confined to Prachi Cinema. How it's to be done. In fact,
Cannot be owner of the money.
even
They are
there
the owner
also,
of the money.
even there also, my name is there as one of the trustees, but I'm not saying anything on that aspect.
The present writ petition is a prime example of the adage within double inverted, much ado about nothing, double inverted close, full stop. The petitioner was a nominee in the PPF account of one Jitendranath Bose, since deceased. Full stop. Upon the demise of the said Jitendranath Bose, the matter, the money lying in the account went to the petitioner in the capacity of nominee of the PPF account. Full stop. Subsequently, there were rival claims. Full stop. A suit was filed in that regard by a third party. Full stop. Ultimately, a VD order dated December 24, 2010, passed in GA 2671 of 2010 with CS 208 of 2010, a coordinate bench directed the first defendant therein, that is the present petitioner, to make a fixed deposit of the entire amount received on account of the public provident fund account of the deceased, together with any interest that may have accrued on the amount till that date with a nationalized bank. Full stop. Next para. The money was accordingly deposited by the petitioner with the respondent number 1 bank. Full stop. The said order further contained the rider that the disbursement of such money will not be made in favor of any person, including the first defendant and the plaintiffs, without the appropriate person obtaining such order as may be necessary for receiving such payment in accordance with law. Full stop. Subsequently, the suit filed by the rival claimants was dismissed for default and never restored till date. Full stop. Next para. When the matter was last taken up, learned counsel for the bank had pointed out that apparently there is a will executed by the deceased Jitendranath Bose, which might have a bearing in the instant matter. Full stop. A copy of the said will is handed over in court today by learned counsel for the petitioner and is kept on record. Full stop. It transpires from a complete reading of the said will that the same pertains solely to the Prachi Cinema and the Prachi Cinema Welfare Association and the property pertaining to the cinema business, and has nothing to do with the present account of the deceased Jitendranath Bose. Full stop. Next para. Thus, the said will, probated or not, does not have any bearing whatsoever on the instant PPF account. Full stop. Next para. Insofar as the order dated December 24, 2010, passed by the coordinate bench was concerned, about 13 years have elapsed thereafter, and till date, no rival claimant have come up to claim the money lying in the PPF account. Full stop. As mentioned earlier, the suit filed by the rival claimants has stands dismissed for default and never restored. Full stop. Thus, in the capacity of the nominee, the petitioner is fully entitled to the sum left by late Jitendranath Bose in his PPF account. Full stop. Next para. The money, unless disbursed to someone, would become stale and unnecessarily remain blocked, not enjoyed by anybody at all. Full stop. Since the deceased Jitendranath Bose had the intention of nominating the petitioner, in deference to the wishes of the deceased, it would only be appropriate that in the absence of any proper rival claim, the petitioner should be considered to be the appropriate person, and the order being passed now, the appropriate order permitting the petitioner to uh, utilize the said amount. Full stop. Next para. Accordingly, WPA 3747 of 2023 is allowed, comma, directing the respondent number 1 bank to release the entire amount lying in the fixed deposit, which was created by the with the amount and amount received on account of the PPF account of the deceased Jitendranath Bose and the interest thereon, comma, along with all interest accrued till date, comma, in favor of the petitioner. Full stop. Such disbursal shall be made to the petitioner at the earliest, comma, positively within 4 weeks from date. Full stop. Next para. It is made clear that in the event any subsequent claim is made by a third party, comma, subject to an order of any competent court, comma, further orders may be passed regarding the money. Full stop. However, comma, nothing in this order shall prevent the petitioner from using the money as indicated above. No orders to cause certain certificate.
Lordship would want me to file the order where the suit was dismissed. That
Yes, please. প্রথম লাইনে একটা করে দাও।
oh, I understand it's part of the writ petition also.
Then no. Wait. Thank you.
No, no.
Follow.
Item 9.
I'm grateful to you,
Thank
Lordship.
you.
Yes, my lord.
Yes,
I'm the
Doctor.
petitioner in this case.
Mukesh,
May it pleases my lord, I appear for the medical council. My lord, I'm led by Mr. Sen. My lord, may I pay for short passover?
No. Yes, Dr. Shah, what is that?
Yes, my lord, before I make my submission,
You read. Yes.
my lord, if your lordship kindly allow, I have filed a rejoinder affidavit, given it to the opposite party, and I have a power of attorney holder in the standing in the court, may be allowed to hand you over the rejoinder affidavit.
Shah, can this be taken up immediately after the vacation? Because the difficulty is before the vacation, it's very difficult. Other urgent motions are there. Only 3 days are left before the vacation. I appreciate that you have been waiting for this matter for a long time. But even then.
My lord, may I just indicate
At
one?
least the interim order, if your lordship, the only thing I said, the interim order, because the election of the president is patently unlawful and is continuing.
What sort of order, Dr. Shah, are you expecting?
That the president should not take any decision, major decision, until this writ petition is disposed of. At least that much.
Major
Because
decision will be vague, Dr. Shah. The difficulty is the moment I pass it, you will say this is a major decision, they will say this is a minor decision. And they
okay,
will
then all decisions.
another year probably. That is the difficulty. I'm being very candid to you.
And I appreciate, my lord, but look, I mean, I have been waiting, I came back here. Now, I mean, something should be done.
This
You see
requires a
how-
full-fledged hearing, I'm telling you.
My lord,
Yes,
The
yes.
opposition yesterday, my lord, we have received the reply, my lord, practically a day before. My lord, they scheduled hearing. They were direction to my lord, file the reply by 8th of my lord, October.
When did you get it?
Just my lord, technically, my lord, yesterday because we received the email.
Without the technique?
My lord, 8:11 p.m. on Saturday.
My lord, the problem is
But
that
That is
this,
sufficiently prior, but
My lord, the government office, my lord, taking in.
But Dr. Shah, I'll fix it on 17th of November at the top of the list. Immediately after reopening, 1 day after reopening. Dr. Shah, please come back on 17th November.
at top of the list, my lord, at least it will be
Although the
taken.
petitioner appearing in person alleges serious illegalities and irregularities in the functioning of the medical council, comma, due to paucity of time immediately prior to the oncoming puja vacation, comma, the hearing of the writ petition cannot be taken up, full stop. Hence, comma, let the matter be placed at the top of the list on November 17, 2023, after the reopening of court.
My lord, one thing, can my rejoinder affidavit be taken on record, my lord? Mr. Ranjit Sarkar
Yes.
is waiting with it.
Yes, please. This is the opposition.
My lord, opposition is mine, my lord. He has filed the reply to my opposition.
What is this?
Affidavit in my lord, reply.
Acha, the affidavits in opposition and reply filed today be kept on record.
My lord, may I just indicate one thing, my lord? There are allegations against the state. My lord, I'm not sure, my lord, whether the state is served or not, my lord, because the allegation that
It has been served.
against me, my lord, I have
Dr.
replied.
Shah, look into that. If necessary, you have to do the necessary. Yes.
It is
I
a
have filed service affidavit.
Dr. Shah, you have to file at least a notarized copy.
It is notarized copy, my
No,
lord.
No. What has
From
been
here.
handed over is not a notarized copy.
This is
My
notarized
lord.
copy
The front page and the
State of Ohio, my lord.
the state of Ohio.
আচ্ছা
কি বলছো?
Original.
No, it has to be notarized through our stamp reporter. Ohio notary can do it, but it has to be affirmed before the stamp reporter. Please do that.
so okay, in the High Court, okay. I will do that.
Respondent, my lord, may be served because allegations are against them also.
তাহলে একটা যেটা বললাম যে affidavit in opposition reply, affidavit in opposition file to be kept on record. Full liberty is granted to the petitioner to have the affidavit in reply affirmed before the commissioner of oaths of this court and to file the same on the next date of hearing.
My lord, respondent number 2 may be served, my lord. Allegations are against them also, my lord.
Whatever.
But they have
Dr.
not
Shah,
been
please
served.
take care that
I have served. Affidavit of service is there.
Thank you, Dr. Shah. Thank you so much. Yes.
Item 10.
10.
I beg to appear on behalf of the petitioner.
Yes.
In this
The
matter,
matter pertains to the issuance of 4 certificates, duplicate certificates of Kishan Bikash Patro and National Scheme certificates. On the last occasion, your lordship is pleased to direct the respondent authorities to file a report on who shall be liable to disperse the certificates. Lordship.
my fault, my lord. I could not get hold
Report.
of them. I could not get hold of them, my lord. My lord, will kindly either take up the matter after the vacations, my lord. I'll find because my lord, Barwipur division there. This is actually a
Come back after the vacation. Learned counsel for the petitioner, learned counsel for the respondent submits that due to unavoidable reasons, the report as directed earlier could not be prepared. Full stop. The time for filing the same is extended till November 17, 2023, when the matter shall be listed under the same heading. Full stop. An advance copy of the report shall be handed over to the learned counsel for the petitioner prior to the next returnable date. Please come.
11.
I am for the petition.
Puja permission.
Yes. What is the matter?
I have applied for before the authority, the school authority giving no objection
For what?
for puja.
Puja.
Problem is not made online.
Not made online.
Online, the difficulties is if
You are the first timer. You are a
yes,
first
yes,
time.
yes, yes, yes.
The petitioner submits that the petitioner is eager to organize a puja on a school compound.
No. Since 2011. Kindly since
No,
20.
no. The first time
This is page
I have
20.
no-
Kindly see page
also,
20.
this is the first time, but I have not getting any
And this is
permission
page 20.
previously. That is why the online application is not received.
Why are you not taking the online application?
The
I
provision-
think there is some provision that last
Yes,
year
yes, last year
permission has to
permission,
be uploaded, then only they will take
They'll-
that. I have not gone through
That is why
that.
the
Last time permission was not.
not given. That I am saying.
So I think
Ki
that's why
bolam
they
bolo to?
can't get access to it, I think.
Eager to? A Durga Puja festival on the grounds of a school, which of the school has given permission, but no online application could be made on the concerned web portal of the government. Full stop. Next parallel council for the state submits that as per the declared policy of the state, the applications are accepted online only upon uploading the permission granted on a last occasion. Full stop. Next para. In the present case, the petitioner submits that the petitioner has been conducting the puja but never had the occasion to take any permission. Full stop. As such, the petitioner is unable to produce copy of previous permission. Full stop. Next para. There cannot be a blanket ban on new organizers performing Durga Puja, of course, subject to the convenience and inconvenience and other exigencies of the respondent authorities. Full stop. Such consideration has to be on a case-to-case basis, and there cannot be a blanket bar. Full stop. Accordingly, WPA 22697 of 2023 is allowed, thereby granting liberty to the petitioners to apply manually for holding for permission to hold Durga Puja
I have already applied my.
for this year. If such an application is made or has been made, comma, the same shall be processed by the respondent authorities at the earliest and, comma, subject to compliance of all formalities otherwise by the petitioners, comma, the respondent shall grant such permission within after the Durga Puja. Within October 18, 2023. Do it as early as possible.
No, Lordship, definitely.
Yes, Mr. Datta.
Kindly hear me 2 minutes, my lord.
Yes, I'll not give you more than 2 minutes in any event. Yes, Mr. Datta, what is that?
Now, your lordship know the Calcutta bench to the recovery tribunal is not sitting.
Calcutta?
The recovery tribunal
State's Recovery Tribunal, yes.
is not sitting from 1st September.
Bench 2 is not sitting.
Now, my lord, I filed an application challenging the notice under 613 board. Essay was filed in April 2023. Now, my lord, immediately during the pendency of the essay, a cell notice was given date by fixing a date 29th August 2020 cell by violating section 13(8) and rule 86 because 30 days time was not given for redemption. Now, my lord, this notice was challenged also by filing I and with the put up petitions. Date was fixed on 1st September. Since the bench was not available, adjourned. Second date was fixed on 19th September, adjourned.
When did you file your application? 17 application?
April 2023.
April
2023. Thereafter, my lord, cell notice was issued on 14th July.
Why didn't you obtain any order till September?
I tried my level, but Siliguri bench was in charge. And regular bench was not
Siliguri bench was in charge since when?
since 1st March 2023.
Now Siliguri bench is also not functioning.
Not functioning. Now what happened? Now, my lord, sale was affected. Auction purchaser, my lord, had given the, my lord, the amount. Now, my lord, this is only by secure asset. There is no other essential accommodation. I will be ousted by the auction purchase.
Auction sale has been carried out.
Auction sale is carried out.
Then what is your relief now?
Really, my lord, the inspector, my lord, the sale notice is under challenge. Because sale notice is totally violation.
Who is for the purchaser? The purchaser is a party here.
Yes, I will serve notice.
I'll direct status code to be mentioned regarding the property. Yes.
They filed a section 17 application that was pending. There's a sale notice that was issued on 14th of July. Should we kindly mark the date slightly relevant, my lord. Sale notice was issued on the 14th of July 2023. The sale was to be effected on 29th of August 2023. So number one, 30-day clear notice is already there, ex vici. Second, my lord, this notice was served on 27th of July. According to their own pleadings in the writ application, they have received the notice on 27th of July. So again, clear 30-day notice. The sale was to be conducted on 29th. So there is a period of close to 30 days. 1 month, there was a bench which was sitting. They failed to get a stay order. For 30 days, there were several urgent matters. I understand there is no bench today. But for those 30 days, there was a bench. They failed to get an order. Number one. This is the first leg of my argument, my lord. Second is that there is a sale certificate that has already been issued.
There is sale I cannot interfere with now. At this stage, section 17 will take care of that.
There is no section 14 order. So the question of status quo is premature. There is no section for order. We cannot take.
Sale certificate has been issued. If the property is divested by the purchaser, what happens then?
They'll
be without remedy.
There is no requirement of a registration of an instrument once the sale certificate is issued.
Yes, that's why
the
sale certificate itself is the transfer.
But there, the physical possession of the property cannot.
You're not getting my point. I'm directing status quo regarding the property. It cannot be transferred or alienated in the meantime before the challenge is heard out before the tribunal. Otherwise, if the third party transfers it, sale certificate has already conveyed the title in the property to a third party. If the third party transfers, he'll have no remedy then, even if he wins the section 17.
I understand. But
for a particular period, I'll give you.
I get it. No, that is for physical possession.
Not physical person. I'll do nothing regarding.
I am not on that. I'm only saying that.
Take your physical person.
I'll rest my case with only one last submission.
You are for the purchaser.
I'm for the bank.
Yes.
Only one small submission. I'll not argue.
Yeah, definitely. Yes.
The only submission, my lord, is their right, which is being violated according to their allegation, is that they have a right of redemption. The right of redemption only remains till the date of sale. Today, they will have to demonstrate
No,
that
they are
have a-
not only claiming redemption, they are also challenging the process of the sale. Apart from 30 days, they are saying rule 8 or something.
so that they would have their challenge.
1 month was there, they failed.
I'm not even on that. I'm saying if they bypass that particular forum because that forum is not sitting, they come before writ court, they will have to demonstrate that they have a right. Today, they don't have a right because they did not participate in the sale despite notice. Their right of redemption expired the moment the sale was conducted.
He was the borrower.
He was the borrower. His right of redemption is only till the date of the sale. He
He's
can
not claiming on the basis of redemption alone. Redemption is a different right.
on the basis of the which
You
the
know
notice-
what?
My lord.
You know what? Why are you asking me?
No, I'm saying, my lord, that
redemption is one of the rights.
One of, but
Learned counsel for the petitioner contends that the provisions of law, including Rule 8 of the SARFAESI rules, were squarely violated. Full stop. Next para. It is submitted that since the Siliguri bench was taking up the matters of the Kolkata Debts Recovery Tribunal bench 2 on an urgent basis, but was under extreme pressure, the matter could not be moved by the petitioner, despite the pendency of a challenge under Section 17 of the SARFAESI Act. Next para, it is contended that as of now, there is no bench whatsoever which is taking up the matters of the second bench of the Kolkata DRT. Next para, learned counsel appearing for the bank contends that clear 30 days notice was given before the sale. Admittedly, the sale notice was issued on July 14, 2023, and the petitioner received the same on July 27, 2023. The date of sale was August 29, 2023, and as such, there was no violation of the provisions of law or rules. It is contended that in the meantime, sales certificate has been issued in favor of a third party, and as such, nothing remains in the challenge of the petitioner. Next para. It is also argued by the bank that the right of redemption of the petitioner is long closed, since the petitioner did not participate in the auction sale. Next para. However, even apart from the right of redemption, the petitioner stroke borrower has a right under the law to challenge the process under which the sale took place. Next para. Since the petitioner alleges violation of provisions of law, it would not be appropriate if the petitioner is ousted from such challenge altogether by the third party purchaser, before the cause of the petitioner is ventilated before the Debts Recovery Tribunal. Such a situation would be UB jus IB remedium. Next para. Hence, to enable the petitioner to ventilate the petitioner's challenge before the appropriate forum, which may be empowered to take up the matters of the Kolkata Debts Recovery Tribunal bench 2, the respondents are directed to maintain status quo with regard to the subject matter of the sale stroke secured assets till December 22, 2023, or until further order passed by the concerned bench of the Debts Recovery Tribunal. Next para. WPA 23307 of 2023 is accordingly disposed of with the above direction. Next para. It is made clear that this court has not entered into the merits of the rival contentions of the parties, and it will be open to the tribunal or the bench taking up its matters to decide all questions on merits without being influenced by the observations above. It is further clarified that it will be also open to the tribunal to vary, modify, vacate, and or extend the order passed by this court before December 22, 2023. Next para. No address to cost agency.
Deeply. Also, my lord, will it be your lordship's pleasure to direct them to assign it in the absence that there is any
At the line at
for them, because they'll also
since it is the judicial notice শেষ করার আগে একটা line add করে judicial notice is taken of the fact that at present there is no designated bench to take up
even urgent matters of the Kolkata Debts Recovery Tribunal bench 2, it is expected that the administration shall take immediate steps for assigning the urgent matters of the said bench to some other bench, and or ensure that a presiding officer is assigned to the second bench of the Kolkata Debt Recovery Tribunal at the earliest.
This
Please
will
communicate this to whoever. I mean.
This will be beneficial for all sides. Right?
Yes, it's necessary because what's happening, I don't know. And before at this time, I mean, before the puja and all.
True, my lord.
Yes, next.
13.
Your Lordship,
Yes,
this is the
Mr.
affidavit of service.
Right. Affected, service affected.
Affected.
Yes, what is the matter?
Your Lordship, it's a grave circumstances I mentioned the other day also.
Mhm.
What has happened is there was a ship which tilted and capsized in the Kolkata port area. In that, it was a Bangladeshi ship. 15 crew members were there. Immediately on 24th, it happened on 24th of March 2022, Your Lordship, we will remember that day, 2022. What happens is the passports of these 15 crew members are impounded immediately. Now they can't impound, that is a different question. I will go into that later on. Thereafter, what happens? There are a lot of talks. The ship is thereafter salvaged in sometime in September with some of the containers. There's an order of arrest for the ship arrest, which is passed by this court in September. That matter is still being fought out. The appeals have been filed. Appeals have been filed. Appeals are being heard. Those things are going on. During this period, what has happened is first 9 of these crew members, the petty officers and other crew members, have been allowed to return. Thereafter, 4 of them were also allowed to return. But the ship captain, the master of the ship, as well as the chief engineer, are still being held here because their passports are not being returned. There is no criminal charge against them. There is no formal charge under 10A of the Passports Act. Nothing has happened against them, but they are being held here by the port. And I will show letters where the port is asking, send 2 people in lieu of them, then we will let you go. This is exactly the situation.
Have you annexed the arrest order? Have you annexed the arrest order?
Yes, I have.
Is there anything there which can be argued against you?
No. With all due respect, but I will.
Can we pass interim orders on this?
No, Your Lordship has to release them, because I'll tell you, Your Lordship, there is nothing, and I will show a Supreme Court judgment on this also.
But the other side has to be.
Your Lordship, that is there's a ploy, and I'll tell you why. The reason is, Your Lordship, there was an order which I have annexed. Your Lordship will come to. This is Moshe Bhattacharya's order.
In Admiralty?
Yes. In which, Your Lordship will see, we raised this point that these people have been held for 1.5 years in Calcutta. For 1.5 years now. Your Lordship will come to page 30.
Have they disclosed any ground whatsoever?
No.
I mean, argue against yourself. What
No, I am absolutely with for the benefit of
their best ground?
Their best ground is their cross-examination of these witnesses have not completed. Can be the best ground. Cross-examination, if not completed in a civil proceeding, will go against the person who is using that affidavit. That is my affidavit. I'm trying to say that the sale is bad. So Your Lordship will see that order. We mentioned it before, Justice Bhattacharya. She gave an order that it has to be completed by 9th. Your Lordship will come to page 31. Learned counsel appearing for the owners, however, submits that the owners are still to file their so and so. Before that, the minutes of the meeting pertaining to the commission also records that the master and chief engineer would file their respective affidavits disclosing the documents in support of their case. It is not any defense. It's my case. If I don't want to pursue it, it will go against me.
There is nothing, no criminal charge or anything.
Nothing, Your Lordship. No criminal charge, nothing. Your Lordship will also come to government of Bangladesh rights to them.
For the purpose of cross-examination, obviously somebody cannot be detained.
Yes. Your Lordship now comes to...
You're right. Adverse inference will be drawn.
No, adverse
the evidence
inference
will go.
Yes. Page 28. Your Lordship will come to page 28. The government of Bangladesh is writing and giving an undertaking. If you need them ever, we'll bring them here.
They'll need them for themselves. Because
whoever-
unless they
whoever-
expose themselves to cross-examination.
Not anything for any.
Stated anywhere, Mr. Sinha, that you have filed your affidavits in chief. Have you?
I have filed. Yes, yes. The document is also there.
So the cross-examination is left.
Cross-examination, and your lordship, today and tomorrow also was fixed for the cross-examination. That also they have given a letter saying that they don't have instruction on what to ask us. That is why.
A copy of that letter.
Your lordship, I can show that letter, but I can just show the letter right now.
So they are taking time.
They are going on taking time. The court has not even tried to cross-examine. The plaintiff has tried to
What is the relief you are wanting, Mr. Sinha, in this?
Your lordship, I want their passports to be returned. There is a provision under 10A that the government can retain.
In the Passports Act.
Under the Passports Act.
Those grounds are not made out here, bro.
Your lordship, may I just submit?
Let me check. Passports Act.
None of the grounds are met. Your lordship will see 10 and 10A. Grounds for impounding not the passport per se, but travel documents. Here it will be travel documents. It includes. So because they are aliens, so that's why travel documents. That has not been made out. Because 10(3)E, which is basically criminal proceedings or anything that.
Copy of the Passport Act.
Yes.
Or otherwise,
I'll.
Thank you. Just check it. Thank you.
And your lordship will note 10A, which says that the maximum period for which a person government can hold the passport or travel document is also 4 weeks.
No, Mr. Sinha, I don't get this. This speaks about the Indian passport of the person.
Indian passport or travel documents of someone. And that's your lordship, the case
Does not
also.
speak about foreign nationals' passports. I don't think so.
May I just
check up.
show this? Your lordship, the Passports Act and those provisions were also used.
2A, section 2B says passport means a passport issued or deemed to have been issued under this act. So Bangladeshi citizens' passports
or your lordship, travel documents which have been issued.
travel documents has to be read, use them generous with passport and all. I'll read that into. No, you're right. Learned counsel for the petition, despite service none.
And your lordship will have a look at this letter. I'm just showing that letter. They are writing that.
If they are taking time, I'll just record they are taking examination.
Yes.
I can write.
Yes, your lordship.
Learned, despite service none appears for the respondent authorities, footstep the affidavit of service filed today be kept on record. Footstep, in view of the extreme exigency pleaded, comma, the matter is taken up for hearing. Footstep, 2 crew of a Bangladeshi vessel, comma, being the master and the chief engineer respectively, comma, have been of a Bangladeshi vessel have been detained in India. Footstep, next paragraph.
Lordship, may I just submit? They have not been detained. Their passports have been impounded. That's why they are stuck.
Have been detained কথাটা যেখানে বলেছি ওটা কেটে দাও are before this court. Footstep, next paragraph. The Bangladeshi vessel capsized sometime in March 2022. Footstep, the ship was salvaged subsequently in or about September 2022. Footstep, an order of arrest of the ship has been passed and is subsisting. Footstep, the suit going on in the Admiralty jurisdiction is at the stage of evidence. Footstep, although the present petitioners, comma, the master and the chief engineer of the said vessels have not been detained in India, comma, their passports have been seized by the Indian authorities. Footstep, next para. It is contended that in the Admiralty suit, comma, the petitioners have already filed their affidavits in chief and are yet to be cross-examined. Footstep, learned counsel contends that on several occasions, comma, the respondents have taken adjournment.
Your lordship, respondent, not respondent. The plaintiff in that suit.
Plaintiff in that suit must be.
Yes.
The plaintiff, right? The plaintiff in the suit have taken adjournments for the purpose of cross-examining the petitioners, full stop. Hence, there is no fault on the part of the petitioners in the admiralty suit being delayed. Full stop. The petitioners' passports are already withheld for about 1.5 years, and being mariners, the petitioners' livelihood is at jeopardy. Full stop. Next para. Learned counsel for the petitioner contends that Section 10 and 10 capital A of the Passports Act 1967 do not in any manner prevent the passports of the petitioners being released. Full stop. Next para. It is also argued that even if the petitioners do not turn up for being cross-examined, the affidavits in chief of the petitioners may be disregarded and or adverse inference may be drawn against the petitioners. Full stop. However, such civil consequences cannot deter the petitioners from getting back their passports. Full stop. Next para. A perusal of sections 10 and 10 capital A of the 1967 Act indicates that those speak about variation, impounding, revocation and suspension of passports and travel documents. Full stop. In view of the language of the said two sections, travel documents have to be read in similar perspective as passport. Full stop. Next para. Section 2 within bracket small b of the 1967 Act defines passport as a passport issued or deemed to have been issued under the said Act. Full stop. Section 2 within bracket small e defines within travel document close to mean a travel document issued or deemed to have been issued under the said Act as well. Full stop. Next para. Since the passport / travel documents of the present petitioners, who are Bangladeshi citizens, are not passports or travel documents issued under the 1967 Act, the provisions of Section 10 and or Section 10 capital A of the said Act are not applicable to the petitioners in the present context at all. Full stop. Next para. Insofar as the admiralty suit is concerned, learned counsel for the petitioners is absolutely justified in arguing that consequences befitting a civil action would follow in the event the petitioners do not turn up for cross-examination. Full stop. It is well settled that if witnesses do not turn up for cross-examination after filing their examinations in chief, the examination in chief shall not be taken cognizance of or may be ignored by the court. Full stop. Even otherwise, adverse inference may or may not be drawn by the civil court / admiralty court against the witnesses. Full stop. That apart, it is submitted that the Bangladesh authorities themselves have repeatedly written to the Indian counterparts expressing their intention to produce the petitioners for cross-examination if and when required in the admiralty suit. Full stop. Next para. In view of the above, there is no plausible reason for further withholding the passports and travel documents of the present petitioners. Full stop. Next para. Accordingly, WPA 23773 of 2023 is allowed, thereby directing the respondent authorities to immediately release the passports, the Bangladeshi passports and travel documents of the petitioners in favor of the petitioners, preferably within 4 weeks, 3 weeks.
Your Lordship, it is just there with them. It's a port trust. They will, by that time, what will they do is that they will do something else.
They're waiting for so long, 1.5 years.
Your Lordship, they need to go back for Durga Puja. Everybody is there.
What Durga Puja in Bangladesh?
Bangladesh, biggest Durga Puja after Calcutta is in Chittagong. The maximum number.
You are serious, Mr. Sinha?
I am very serious, Your Lordship.
Mr. A.K. Musa and Mr. Fahim.
Yes, Your Lordship. It's a Bengali festival, no longer a religious festival.
In our country, yes.
In every country,
yes.
It is the second. But Your Lordship will shorten the time. 4 weeks is the entire length of 4.
No,
so
3 weeks, I say.
Your Lordship, you will give it 1 week. Within 1 week, at least 2 weeks. We'll not make it to 3 weeks. Your lordship, because
Very well. Within a fortnight from the date of communication of this order to the respondent authorities. Full stop. The authorities, the respondents shall act on the written communication of the learned advocate on record for the petitioners, coupled with a server copy of this order, without insisting upon prior production of a certified copy for the purpose of complaint.
March.
Yeah.
Mr. 14.
Yes.
I have mentioned this matter. This relates to my lord the permission.
So Ahmed
of
had
the-
to be invited for this matter.
Lord?
He had to be invited for this matter.
Yes, obviously. He is one of my
Invited. Yes, what is the matter?
my lord, the permission for new puja, my lord, Durga Puja. Durga Puja. This is the situation, my lord. I do not want to, my lord.
Get the time to prepare.
My lord, this is small puja, not a big such. My lord, I have annexed the place, my lord, the photograph. This is a small
Whose
puja.
property?
My lord, this is in front of one house, my lord, the petitioner. In the front of the petitioner, my lord, kindly come to page 23. My lord,
Yes, I've seen it. Yes.
just my lord, this is the road, my lord. This is the
No, you're encroaching a road.
no, my lord. This is not the case. Their case is that, my lord, the law and order problem. There is other puja. My lord, the locally people.
There has to be a limit somewhere.
My lord.
I mean, other puja, yes, there are other pujas. That
My
doesn't.
lord, the fact, my lord,
Article 14 has a limit.
my lord, fact remains that, my lord, I have other
Classification.
other
There's
yes,
a
other allegations.
But I'll not direct them to subject to complaints of formalities. I'll not pass that.
Yes,
Direction.
obviously.
I'll not pass that direction.
Obviously, my lord.
I'll say that they'll consider and dispose of within
that
2
has been
days.
custom. My lord, I have
2
the
weeks, my lord.
my lord, I have the
2
report.
days, 2 weeks.
My lord, I have the report.
What is this?
My lord, the report.
My lord, the main
Puja.
My lord,
What is this?
no, this is a report, police report.
police report, my
My
lord.
lord, the police, my lord, kindly go through the photographs, my lord. It's a very narrow alley, 5 feet wide. And moreover, my lord, if any emergency service is required,
My lord,
It connects to the main road.
this connection.
No.
And there's also a boundary wall for the Muslim burial ground.
This is not the case, my lord. My case is, my lord, I'm saying, my lord. This person who is petitioner before your lordship, he was a candidate of a particular party. This is the main vengeance, my lord.
This is not the case in the Brit, my lord.
That, my lord, that's why, my lord, I am not want to say, my lord, but these are the
You are the member of a particular party. That is the reason you are wanting to hold a puja immediately adjacent to the Muslim burial ground.
No, there is no, just my lord, just my lord, bear me for a second. There is
You have an agenda.
there is a puja beside the burial ground. There is a Sitola Mandir in the wall of the same burial ground, my lord. Nothing has been happened. Now, my lord, this is far away from the burial ground. Now they have took the plea. If I understand, there is in the same wall, there is a Sitola Mandir.
Well, consider this
My lord,
application.
kindly, this is a small puja. I am saying that there is not a
No,
big
no, I'll not
pandal and
direct.
others, my lord. In front of my house, my lord.
Learned counsel for the petitioner contends that the petitioner's application for organizing a small puja has not been responded to by the respondent authorities. Full stop. Learned counsel for the state hands over written instruction report by the concerned inspector of police, which indicates that the proposed site of the puja is near the wall of a Muslim burial ground. Full stop. That apart, the puja is proposed to be held in a narrow alley, which might prevent ingress and egress to the main road. Full stop. Next para. Such contentions are disputed by the petitioner. Full stop. Be that as it may, since the petitioner has sought to organize a puja, it is for the respondent authorities to consider the said application in accordance with law and give a proper consideration to the same. For sub next para, accordingly, WPA 24451 of 2023 is disposed of by directing the respondent authorities to consider and dispose of the application of the petitioner for organizing a Durga Puja this year in accordance with law and upon adverting to the same to intimate the reasoned outcome of the same to the petitioner. Full stop. The entire exercise shall be completed by October 18, 2023.
Under this
Do it by tomorrow.
consideration directed by the honorable court shall not come into the way, my lord, for to get influenced by the order, my lord.
Will not do.
Might be they might come up with a plea before the concerned authority that the High Court has asked you to consider it.
After line at it is made clear that the merits of the petitioner's rights to hold the rights now. The merits of the petitioner's application to organize such puja have not been entered into by this court.
My lord. Great. Grateful.
15.
Well, I appear for the petitioner in this matter.
Yes, Mr.
An SC/ST certificate was the subject matter of challenge before this honorable High
Good
Court.
service on all. Good service
All
on
service, all service.
Great,
Service is good. Dekhe na, tu dekhe nahi. The government of only against the state the allegation is there.
Yes, what is the allegation?
Malad, the order was passed by Justice Moushumi Bhattacharya at page 48, directing that you go to the DM regarding the legality of the or validity of the certificate of SC/ST. That is an appellate authority matter where the SDO's order was subject matter of appeal, and appeal was preferred. The DM has passed an order. It starts from page 52 at the penultimate page 67. Lordship will kindly come. The operative part of the order, straightway.
Appellate authority's order?
Appellate authority's order.
DM, your certificate has been
My certificate is subject matter of challenge. It was SDO has well done nullified the same, and accordingly, when I moved the read said no, go for the appeal. And appeal court malad is giving the final order part. Kindly come to the third paragraph.
Yes.
The PO cum DWO Murshidabad is further directed to refer the matter in accordance with the principles and spirit as invited on the paragraph so and so, dated so and so to the scrutiny committee for proper direction subject to para 11. If the scrutiny committee is satisfied that the certificate under the said act has been obtained by any person by furnishing any false information or by representing any fact or any suppression of any material information by the producing any document.
What is the wrong in this?
I'm not challenging it. It is in my favor.
Yes.
It kindly come to the next paragraph.
Yes.
Until then there shall be a stay of order over the execution impugned before this court, before the dated so and so of the subdivisional officer, and that next paragraph that with this observation the appeal petition is accordingly disposed of, and the solemn order dated so and so of the Honorable High Court dated so and so is a matter of so and so is complied with, that this order does not suffer from any legal infirmity warranting any interference and shall have the effect from the date of communication of the order. Malad, before your lordship goes to this matter further, kindly malad come for once at the very first page at page 51 of the said petition. Kindly look at my lord, page 51 for once. This was a notice for hearing under Rule 7G4. Has the lordship got it?
Yes.
Now kindly skip over at the impugned page 70. Again the DM is wanting me to come at 2 o'clock today before him in 7.4G, not 7G4. A date of hearing in connection with the above mentioned subject matter has been fixed on 16/10.
You say no further hearing is necessary.
Hearing over. He has disposed of the appeal.
Go to the scrutiny committee. After that, whatever has
scrutiny committee is already in session, and you have referred it and disposed of matter. And he said, I have not committed any illegality.
No further hearing.
My lord,
No time to take your breath.
Since Friday, my lord, afternoon we got this, my lord. I have no opportunity to, my lord, talk with the authority. Since, my lord, Saturday, my lord, I called the.
Now you'll get the opportunity to talk
My
with
lord,
the
only-
authority with my order.
Yes.
No, only I'm telling you. Please come to page 67. This page 67 only they went up in appeal against their cancellation of SC/ST certificate.
My lord.
That was referred to the scrutiny committee. Whatever happens after the scrutiny committee, it will take effect. So there is no scope of hearing. You are relieved of your this further burden.
My lord.
I'll dispose of the writ petition. I'll record that.
My lord.
There is no scope of any further hearing. Scrutiny. This order will be complied with appellate authorities.
Yes, my lord.
Learned counsel for the petitioner contends that the petitioner's SC certificate, Mr. Bhattacharya, SC in your case? ST within bracket scheduled tribe certificate was cancelled by the SDO. Full stop. Being aggrieved, writ petition was preferred, where an order was passed granting liberty to the petitioner to approach the appellate authority, which was done by the petitioner. Full stop.
Subsequently, the appellate authority directed that the PO cum DWO dot BCW and TD, Murshidabad was directed to refer the matter in accordance with principles and spirit as envisaged in the provisions quoted therein. Full stop. If the scrutiny, to the scrutiny committee, sorry, sentence cholche, to the scrutiny committee for proper direction. Full stop. If the scrutiny committee is satisfied that a certificate under said act has been obtained by any persons by furnishing any false information or representation of any fact or suppression of material information or producing any document which is an act of forgery, comma, it may issue a direction to the certificate issuing authority to cancel, impound or revoke such certificate, and on receipt of such direction, the certificate issuing authority shall, comma, by order in writing, comma, cancel, comma, impound or revoke such certificate. Full stop. The appellate authority further observed that until then, there shall be stay order over the execution of the impugned order of the subdivisional officer, cancelling the petitioner's ST certificate. Full stop. Next para. However, comma, subsequently, a fresh notice of hearing dated October 6, 2023 has been issued to the petitioner by the Additional District Magistrate, BCW bracket Murshidabad. Full stop. It is argued that such further hearing is completely unnecessary and dehots the directions of the appellate authority. Full stop. Heard learned counsel for the parties. Full stop. The petitioner is justified in contending that no further hearing is necessary in view of the nature of the order of the appellate authority. Full stop. The only exercise which remains is for the scrutiny committee to be satisfied in terms of the directions passed by the appellate authority and thereafter take appropriate steps in consonance therewith. Full stop. Next para. Hence, comma, WPA 24876 of 2023 is allowed, comma, setting aside the notice of hearing dated October 6, 2023, bracket, annexure P13 at page 70 of the writ petition, bracket closed, and directing the scrutiny committee to act in terms of the order of the appellate authority.
Well, that direction may not be required by lordship today. Do not go for that.
And take a chair though. Setting aside the full
set
stop,
aside.
it is made clear that the order of the appellate authority shall now be complied with duly. No rest to cost.
ছেড়ে দাও, ঠিক আছে।
এবার অন্যগুলো সেম আছে
আস-
কিন্তু লাস্ট অ্যানেক্সারটা ঠিক করতে হবে।
Yes.
হ্যাঁ পরে
Connection name.
6 তারিখে ডেটটা আছে কিন্তু
16.
মানে same matter.
Yes.
but my lord,
Date of
date of notice same but annexure here kindly see whether same or not.
annexure number may be different.
Number may be different.
Annexure, এটা কত নাম? মনীন্দ্র?
Same. সব এক,
Date
শুধু
same.
annexure P13, page 69.
Can kindly consider whether all are P30. Another two is there.
মানে এটা 280
It's a cottage industry.
Several complain more than 80 or 90.
ছেড়ে দে
hearing is going
হয়ে
on
গেছে। সময় নষ্ট করো না যশ সাহেবের কাছে।
there. Can be
17.
Same.
Up to which item, Mr. Bhattacharya?
18.
আচ্ছা 17 টা দাও, শুধু ডেট গুলো দেখে। 17 টা দাও, 18 টা রেডি করে রাখো, 18 টা 17 এ চলে এসো। 17 এ সিমিলার অর্ডার, শুধু ইয়েটা I cannot decipher the date. Page 90, what is the date? October
6. October 6.
6 is not very clear.
It's 6. I know what October
6.
6. Yes. 6. All are 6. Date of hearing 16.
তাহলে একই থাকবে, শুধু অ্যানেক্সারটা হয়ে যাবে P17 at page 90.
Yes.
18 টা দাও, বললাম দিয়ে রাখো।
18.
P18, page 96. বাকি সব সেম।
Great.
Thank you very much.
Deep blue,
Yes.
Inshallah.
Nineteen.
19 one for the petitioner, my lord.
Petitioner, yes.
This is the victim.
But the victim.
You're for the state. Affidavit of service.
My lord, it's
Can you
very-
file it during the course of the
But
day?
it's a very
Yes, sir.
unfortunate case. A
Yes, sir.
14-year-old exploited
Yes, sir.
sexually and she has become pregnant. So a medical board has to formed.
What is the period, I mean, tenure of
But I
pregnancy?
could not find it.
But
I
that-
also
but-
could
but
not
4
find it in
months.
the
4 months.
But-
It's going 4 months, my lord. I have annexed the.
14-year-old, very unfortunate one.
Yes, my lord.
Definitely.
But give us 4 weeks time, puja vacation, just to form the board thereafter.
No.
But that will.
That will be crucial.
delay.
What is the age of the victim?
14 months.
14 years, my lord.
14 years.
Yes,
9 plus 9.
The present case pertains to an unfortunate victim. This is a rape.
my lord.
An unfortunate victim of rape and sexual abuse. Full stop. The petitioner, comma, the being the survivor is merely 14 years of age and has become pregnant due to the aforesaid sexual abuse. Full stop. Next para. The petitioner thus seeks to have an abortion in view of the trauma which is being suffered by the petitioner and would be suffered in the event the pregnancy goes ahead. Full stop. Next para. Have you mentioned anywhere what is the period of pregnancy?
Yes, my lord. The annexure I have given the.
In this, it is there.
Yes, my lord. It's there inside. I have given the medical certificate, my lord.
Can you give me the exact date? I mean, the exact period. And it is required under the Act. 24 weeks or 22 weeks is the outer limit.
For the 16 weeks, my lord. Well, it will be 16 weeks within
Could be
24
16 weeks, exactly 4 months.
4 months, my lord. She's running 4 months, my lord.
So then why do you require an order of court? In any event, you can.
But without the order of the court, my lord, will not be allowed to terminate the pregnancy.
কি বললাম ছাড়লাম কোথায় জন্মে?
4 weeks, নেই 60.
এই যে এখানে আছে।
আমার পেজটা তাহলে দিলে মানে kindly see page 20 possibly, but I could not get it. My learned friend says the period is there. There is no pleading to that I have checked, man.
No, from the materials please check up. I don't want to enter into the envelopes. I mean, just
তোমার তো মনে হয়
তুমি করতে শুরু করে দাও, অর্ডারটা করতে শুরু করো। Please check up in the meantime. I'm passing my order. Please check up.
এই তো আমার here for 4 months. 4 months is the page 20.
The petitioner is pregnant for about 4 months. That is around 16 weeks as of now. Full stop. Next para. Keeping in view the trauma which is being undergone by the 14-year-old survivor and the further adverse consequences which the petitioner shall face, comma, both physically and mentally, comma, in the event the pregnancy goes ahead, comma, WPA 24941 of 2023 is disposed of by directing the respondent 1 state to immediately form a medical board consisting of what is the full form of the act, Mr. Chakraborty?
Difficult. I'm not equipped with the brief today. That's my difficult.
Have you referred to the act anywhere?
Yes, ma'am.
Just give me the name of the full name of the act has to be.
A tender apology, man. I should have come up. Medical Termination of Pregnancy Act 1971.
Yes. Directing necessary to form a medical board in consonance with the provisions of the Medical Termination of Pregnancy Act, comma, 1971 within a fortnight from date. Full stop. The said committee shall, comma, within a further week thereafter, comma,
section
thoroughly check up the petitioner and come to a conclusion as to whether a medical termination of pregnancy procedure is possible to terminate the pregnancy of the petitioner. Full stop. Upon taking such decision, comma, appropriate steps shall be taken, comma, if necessary, admitting the petitioner, comma, in the which hospital do you prefer? Government hospital, Mr. Chakraborty, which will be a better?
But
it's a scheme.
Raiganj Government Hospital will do. It's in Raiganj, bringing her from
It
Raiganj.
has to be in Uttar Dinajpur.
Raiganj.
I'll leave it on the state.
Yes,
On any recognized state hospital having the facility to terminate pregnancy and to take care of the petitioner. Full stop, such procedure, comma, it is expected that such procedure shall positively be concluded within a week after coming to such conclusion. Full stop. Next para. It is made clear that in the event, comma, despite all steps being taken by the respondents, comma, the fetus takes birth, comma, it will be open to the respondents to take appropriate steps for placing the newborn in adoption, comma, upon following due procedure of law. No response.
I've given the every service, my lord. Every service I've given, my lord.
You will file during the you have
I
filed.
have filed, my lord. The
ठीक है,
act
ठीक
is
है।
required, my lord, for you, lord. My lord. Great field, your lord.
Upgraded matter, item 20.
I am applying for the petition of my lord.
But appeal for the pollution control. Well, I'll try my best to assist your lordship. I was not aware that the matter will be upgraded.
Oh,
Yes,
what is the matter about?
No, this matter is, my lord, I was running a business in the year 2018, my lord, and I have been prevented from carrying on business by the State Pollution Control Board, saying that there's been untreated effluent, my lord.
Pardon?
Untreated effluent, my lord. There is no ETP, effluent treatment plant. That's why I cannot run it. My lord, may I just draw your lordship's attention to page number 28 of my application? The closure order, which is passed by the Pollution Control Board, my lord. Your lordship may kindly have a look at the paragraph 4, my lord. And whereas the industry was inspected by the officials of the West Bengal Pollution Control Board on 27/2/2018. During inspection, the industry was in operation without having any effluent treatment plant and air pollution control system. It is observed that the industry discharges untreated effluent directly into a nearby pond and a well. Hazardous waste was found to be dumped on ground. Now, my lord, the fact remains is that, my lord, thereafter, my lord, I have taken.
Why didn't you reply to the show cause?
My lord, I have replied to this is the closure order, my lord. Show cause has already been given. I replied to the show cause, and thereafter this closure order has been passed. Now, thereafter, my lord, I have complied.
No, the next paragraph says industry was show caused by the state board on such and such for operating without
page
valid.
27. Page 27.
No, page 28, carrying on.
Page 28 is the closure order.
Stipulated time period has elapsed and the state board has not received any
Operating
reply to
without-
the show cause letter.
Without valid consent to operate, by memo number stipulated time period has elapsed and the state board has not received any reply to the show cause letter. But if your lordship may kindly have a look at page 27. I've already.
Acha, what is your ground? Tell me.
My ground is, my lord, I have complied with all the formalities. As per the instruction and the direction, my lord, I've paid the area fees, my lord. I've paid the advance fees, my lord. I have actually submitted each and every document, my lord, which I have annexed. What are the documents which I have submitted, my lord? That is
Give me the page numbers.
Annexure P6, my lord. It's at page 30.
Where is the ETP, this certificate?
ETP. My lord, if your lordship.
Give me the page numbers. I'll write down the corresponding page numbers.
If your lordship may kindly have a look at page 58 to 60, the bill for.
Mr. Bihani, please take instruction if all have been submitted. Because
I will. Definitely I will.
Take instruction.
But
Come back day after
or
tomorrow.
one or two things I'm from the repetition itself.
Yes.
So there are two aspects. One is the primary effluent treatment plant, primary ATP. As per the order of the Honorable Supreme Court, a primary working ATP has to be there.
Yes.
One. Two is more importantly in this case, the citing policy of the board. This unit falls into, if your lordship find from page 28 also red category. Number cutoff date is 1996 as per the policy. After 1996 in Kolkata metropolitan area, no unit or rate can be set up or consent can be given.
Only issue
Without
is, my lord,
affidavit,
whether
you
there has been ETP or not.
The petitioner has raised a valid question as to whether the petitioner's industry was shut down for non-compliance of pollution procedures. Full next para, learned counsel for the Pollution Control Board seeks to controvert the allegations made herein. Full stop. The respondents, accordingly shall file their affidavits in opposition within November 24, 2023. Reply, if any, shall be filed by December 1, 2023. the matters shall be listed on December 5, 2023 for hearing.
May the affidavit of service.
Affidavit size filed today. This has to be decided on facts.
Yes. But there are plenty of facts, man, that we have.
Obviously, there are plenty. Yes. I'll come back in 10 minutes for the next matter.
21.
21, my lord, I am for the petitioner. My lord, in essence, this has become infructuous because, my lord, these matters 21 and 23 are similar. Lord, 21, but 23 has not become infructuous. 21, my lord, we were seeking direction upon the district magistrate. The usual orders, my lord, under section 14. Section 14.
Well,
This, my lord, he has already acted upon. I have received instructions.
Learned counsel for the petitioner submits that the petition has become infructuous in view of the relief sought having already been mitigated. Accordingly, WPA 3653 of 2023 is disposed of as infructuous. First up, the affidavit of service filed today be kept on record. No orders to cost.
23 is also similar. I'll wait.
22.
In this matter, I appear for the petition. But
Copy has been served.
But it has been served, but it wrongly filed before lordship. It is police inaction matter.
Oh, Learned counsel for the petitioner submits that the matter pertains to police inaction. Puts up hence, comma, due to lack of determination, let the matter stand released from my list with liberty to the petitioner to mention for inclusion before the appropriate bench having determination. Thank you.
23.
23, I'm for the petitioner. My lord, this is the affidavit of service.
No section 17 pending?
No, my lord. Section 14 filed on 3rd of August 2022. My lord, it was last heard on 18th of April 2023. Since then, it has been pending for orders, my lord.
Can I record your submission? No section 17 is pending.
Yes, my lord. My instructions as on date.
Learned counsel for the petitioner bank submits that no application under section 17 of the SARFAESI Act 2002 is pending at the behest of the borrower. Full However, comma, the petitioner stroke bank's application under section 14 of the SARFAESI Act 2002 has been kept pending beyond the statutory period. Full stop, next para. There being substance in such contention, comma, WPA 3657 of 2023 is allowed, comma, thereby directing the respondent number 2, comma, that is the district magistrate, comma, Barashat, to dispose of the pending application under section 14 of the SARFAESI Act 2002 of the bank, of the petitioner bank, as expeditiously as possible, comma, positively within November 24, 2023. Full stop. Next para. Affidavit of service filed to be kept on record. No orders to cause urgency.
One more indulgence. My lord, there are similar matters which are appearing in your lordship's list today. 136, 138, 139, 142 and 140.
Please give on a slip of paper.
Yes, my lord. If you take it up tomorrow, as my lord.
হ্যাঁ কালকে তাহলে টপে দিয়ে দিও এগুলো 2 মিনিটের অর্ডার
I'm deeply aware. নামটা
24.
24.
Yes.
My lord,
Mukherjee, what is the matter?
my lord, though, my lord, I am not challenging, my lord, the order regarding the bid, but, my lord, the process, my lord, in the portal, my lord, the petitioners sort of file these applications for, my lord, that is all application regarding tender. My lord, and they, my lord, rejected, my lord, they thereafter, my lord, they disable the portal. My lord, this is my grievance.
Disable the portal after the scheduled time.
After the scheduled time, my lord, they, after rejection, my lord, they communicated, rejected without any reason, and my lord, the portal, disable the portal. As such, my lord, I am not looking the allowing the tender who, my lord, accepted, my lord.
If yours is rejected, you have no right.
No, but my lord, that is reason why, my lord, that our bid.
Frivolous application.
No, why, my lord, our bid is rejected. But that reason should be, my lord, the portal. If, my lord, the portal is disabled, why the disable the portal?
You are saying no. The rejection was uploaded.
My prayer,
Where is the rejection was uploaded?
No, they disable the portal. But I read in the nature.
So how do you know your bid was rejected?
But I communicated that your bid is rejected.
That is sufficient.
But, my lord, the portal, my lord, I can see, my lord, there is page 18, my lord.
Page 18.
But technical, but technical bids, grounds of the technical reasons. But they have rejected on ground of technical. But they are rejected.
Enable the download option of the documents of other bidders.
And all reason, and also, my lord, the other bidders. The portal can be, my lord, why the disable, but the portal.
Yes, portal has to be available to the public.
My lord, kindly, my lord, Mr. Raja Satyajit Banerjee is appearing for the respondents, my lord. He is not able to come today. my lord.
Portal is download option has been closed.
Closed.
Download option may be closed. Their choice. These are not matters of interference. But the portal has to be kept open for your perusal.
Yes, yes, Malad, that, but I,
You have not alleged that you are not having access. You are saying you want to download the documents.
download as well as access. Malad, access, Malad,
Don't have
without access, Malad, download cannot be possible. Malad,
You
without
have not
access-
alleged that there is no access. You have alleged that you cannot download others documents. Why will you be entitled to download?
But the technical bit, if Malad, the authority Malad, allows certain persons,
No.
Malad, the technical bit, Malad, that reason should
No,
be
Mr.
Malad, that
For this, it does not like.
Malad, allow Malad to access the portal, Malad. If
The
Malad, download-
petitioner participated in a tender process floated by the respondent authorities. Full stop. Subsequently, the technical bit of the petitioner was rejected. Full stop. The petitioner's grievance is that the petitioner sought to download the documents of other bidders, comma, if necessary for the purpose of challenging those, comma, but found to the petitioner's dismay that the download option was closed. Full stop. Next para, heard learned counsel for the parties. Full stop. There is no allegation in the writ petition that the portal itself has been taken down. Full stop. Next para, the only grievance of the petitioner is that the petitioner is not being able to download the documents uploaded by other bidders. Full stop. Next para, after having participated and the technical bit of the petitioner having been rejected, comma, the petitioner does not have any further option or choice to does not have any right to have access for download of the documents furnished by the other bidders. Full stop. Next para, no right, comma, either statutory or constitutional has been infringed in the present case to furnish a cause of action for the petitioner. Full stop. Accordingly, WPA 5081 of 2023 is dismissed without any orders to cost. Every exercise file to be kept on. Where do you get these matters? Yes,
25.
25.
I am for the petition.
Yes.
Lordship, there was a direction to exchange affidavits. This is my affidavit in reply. Lordship, petitioner applied. New electricity connection was applied by the petitioner for domestic connection, but during process they have demanded some outstanding dues of different persons with whom petitioner have no nexus. Lordship, under
Yes, what is the nexus?
Kindly come to page 11. We haven't directly said there is a nexus.
What is the opposition?
My brief has been, my lordship,
brief has been what?
It is in the word, I have missed the list. Just now I have been said that this matter I am taking, but so far I am not on that. I am ready to, your lordship kindly dispose of this matter. If your lordship kindly to come to page 11 for a moment.
Yes.
In page 11, a letter has been written where it has been specified to contact them and to come with a specific documents. So if he goes there, the matter can be resolved. We haven't said that directly that there is a nexus, we will not give the connection. Kindly see the letter.
Why should you go to somebody? I'll direct you to give the connection.
So far, kindly take a note on that.
Nexus, it's your duty, your onus, your burden.
But that's true.
If you don't show any nexus, then I'll direct current to you.
If we can show the nexus,
You have not shown. You are directed to file affidavits. It's not there.
Then kindly keep it for a short passover, lordship. Then I will file the affidavit in opposition. Kindly make a short passover. Only.
Lordship,
keep your reply with you. File it when they bring their opposition.
They have stated in their opposition that
Let us not waste time. Come back at 2 p.m. today.
Lordship, yes. I'm sorry for that.
No, it's all right. 2 p.m. Please come back.
26.
In this matter, my lord, I am appearing for the petitioner. The
affidavit of service.
This is has been sent for affirmation. I am just sent for affirmation.
No, good service has been effected.
Yes.
How can I affirm without this?
No.
This has to be a part of the affidavit of service. You said sent for affirmation?
It is being typed.
Ajay, what is the matter?
But the matter relates to correction in the passport. Last page is the passport issued. Though issued, my lord, the authority has said that don't use this unless the date of birth is corrected. Now, date of birth is here 5/1/1999.
Yes.
It should be 5/1/19.
You have formally applied for.
Yes. That is that.
You want that correction to be done?
Yes, page 21. And all documents, my lord, I have produced, that is annexure P2. My lord, it can be disposed of with direction. But otherwise, my lord, the petitioner is not in a position.
If I give you, if I direct you to file the affidavit of service during the course of the day, can you do it? Can you file the affidavit of service later this day?
Yes, I will file it.
Leave is granted on the prayer of learned counsel for the petitioner to file affidavit of service
Within an hour, my lord, I will
during the course of the day. Full stop. The prayer of the petitioner is innocuous. Full stop. The petitioner obtained a passport. Full stop. However, subsequently the petitioner applied for correction of the date of birth of the petitioner as depicted in the passport. Full stop. All necessary materials in that regard have already been furnished by the petitioner.
Annexure P2.
As annexed to the writ petition. Full stop. However, the correction has not yet been effected by the respondent authorities. Full stop. Next para. WPA 11546 of 2023 is, accordingly, disposed of, directing the respondent number 2 or 3. Directing the respondent number 2 to process the application for correction of the passport of the petitioner immediately and to carry out the necessary correction, subject to satisfaction of the said authority at the earliest, positively within 3 weeks from the date of communication of this order to the respondent number 2 authority. Full stop. No orders to cause.
Obliged to Lord.
Thank you. Please ensure that the affidavit of service.
Within an hour, my lord, it will be.
Thank you. Yes. Next.
27.
None appears at the time of call. Let the matter stand adjourned till after the vacation. Next.
Lordship, 28, I was to file the affidavit in opposition, Lordship. It has been processed, gone for, I mean, it's waited, Lordship. I just, if you, it be sent by post, I mean, by tomorrow, Lordship. If your Lordship keeps it on the reopening, I'll be able to give it.
I'll give it.
It's done. But
the counsel for the Union of India seeks a short extension to file the affidavit in opposition. Full stop. Accordingly, the time for filing opposition is extended till 19th October.
Lordship, it might not reach. It's going to come by post. That is the
Very well.
problem.
By November 16, 2023, full stop reply, if any, shall be filed by November 23, 2023. The matter shall be listed for hearing on November 24, 2023.
At the same position.
Same position, I cannot assure, Mr. You convince your learned junior. Yes. Yes. Next.
29.
Here is the evidence.
Yes, please. Mr. Vandod.
Waiting for the respondent.
Right. Yes, Mr. Vandod, what is it?
My lord,
Bank is the main contesting.
My lord, the petitioner took some loan subsequently because of COVID.
So, Vandod, please come closer to the microphone.
He became a defaulter, my lord. And subsequently, your lordship kindly come to page 16. That is the e-auction notice that is dated 15 December 2022. And the price for recovery was 5,05,373.17. Now, the proposed e-auction sale was within 1 month, that is in January. In January, the petitioner went to the bank and deposited 4,56,000 out of this. And in the meantime, some more amounts were deposited. Ultimately, 27,000 is due. Now, my lord, when the petitioner went to deposit that 27,000 by cash, bank refused to accept that money, and they are not agreeing to issue no objection after getting that money. So a demand of justice was made. That
Sale has not been effected as yet.
No.
No, Mala, sale affected. Sale affected. Sale confirmation certificate, no, sale certificate has also been issued.
Mala, then how bank
Dates are very important in this matter, Mala.
So, Bandhavata, what remedy remains for you?
My lord, your lordship kindly.
There is no scope of redemption after the sale certificate.
My lord, your
Even if
lordship
they have
kindly
done some.
kindly ask them the date of sale.
Mr. Bandhavata, for argument's sake, let us take that they have failed to deal with your request for redemption and all. Now what relief can we get? That is what I'm thinking about.
Then, my lord,
The sale certificate, if the sale certificate has been issued, you know the law. I mean, title has passed. We cannot reopen that. It has become infructuous.
then my lord, that amount, rest amount should be repaid to the petitioner. Because the reserve price was 21 lakhs and I guess, my lord, the sale price.
Yes,
is
yes,
more than-
definitely. After deducting
And-
that they'll have to do.
And my lord, the 4,56,000 which I deposited by cash for getting back my property, that amount should be also be refunded.
Mr. Bandhavata, whatever was the loan amount, whatever was the bank's due, that will be deducted from the sale
Yes,
price and
yes,
the
yes.
rest will be given to you.
Lordship.
The petitioner's challenge was initially to alleged inaction by the bank in not acting upon the request of the petitioner to redeem the mortgage. Full stop, next para, learned counsel for the bank submits that in the meantime, the sale has been effected and sale certificate issued. Full stop, next para, thus, comma, the writ petition has become infructuous. Full stop, next para. Accordingly, WPA 14311 of 2023 is disposed of by directing the bank to deduct the amount due to the bank in lieu of the loan and to refund the balance amount in consonance with law to the petitioner at the earliest thereafter. Full stop. It is expected that the entire exercise shall be concluded by November 30, 2023.
My lord, the amount which I deposited 4,56,000 kindly mention, my lord. Otherwise, they will.
No, Mr. Bandhavata, the difficulty is if I mention an amount,
My lord,
and
that
interest
is,
may be that may be a disputed sum.
No, my lord, through RTGS.
I've said in accordance with law, whatever is due to you, the deduction they'll do that. If you have a further cause of action, Mr. Bandhavata, you can always come up. I mean, that's a separate cause of action.
Grateful
If
to
you
your
put in
lordship.
something that will create further complication. Thank you.
Grateful to your
Thank you. Next.
30.
30, my lord, I beg to appear for the petitioner,
Yes.
my lord.
Service.
It's a very short matter, my lord. Yes, my lord. It's a good service.
Good service.
Yes.
Yes. What is that?
Last occasion, the matter was taken up on 21st July, but however, state was not appeared on that. That usual matter has adjourned. My lord, the case of the petitioner is that petitioner, being in society, carried out a work that is installation of individual household latrine under the total sanitation campaign scheme.
Not disbursing money.
Not disbursing money, my lord. I am admitted position because in the RTI reply, whatever amount they have stated, I am claiming that. My lord, kindly come to page 54. They are documents, my lord. The outstanding amount is around 17 lakhs. I am claiming that money. No disputed facts, my lord, and not the money is being disputed by the petitioner. My lord, kindly come to page 54. Whatever reply they have stated in their in their RTI reply. That amount. And the next page, my lord, it starts with page 55, the April letter dated 25th.
No, total outstanding is admittedly
17 lakhs
35.
35. We are claiming that in our demand.
Yes, what do you say?
Demand justice, my lord, we have stated.
Lordship, Mr. Abhishek Prasad is appearing for the state respondent. He is engaged in court number 14, Lordship.
I'll direct them to release this admitted amount immediately and direct affidavits to file.
My demand letter is also speaks about the same thing. We demanded the same amount, my lord.
This amount only.
This amount. My lord, kindly come to page 55. Our demand letter. Page, my lord, 58, the relevant part.
When will Mr. Abhishek Prasad be able to come?
Lordship, after he can appear today or if your Lordship grants.
This will be that কালকে topic কিছু fix করেছি অরিত্র কাল topic দুটো রেখেছি অনেকগুলো আছে 2 p.m. I have already fixed up one matter. After that, this will be the second matter. After this,
at 2 p.m.
At 2 p.m. the second matter.
Yes, Lordship.
And we have also demanded the same amount.
Please keep the affidavit of service with you for the time being. I'll take it up at 2 and then take. Please ask Mr. Prasad to be present, or you take instruction. Giving the page number, it's an admitted amount. Apparently, you gave information that this amount is due to him.
Yes.
So why shouldn't you pay that? Take instruction.
Great.
Thank you. Next.
31.
My lord, appear for the CESC. My lord, July 17th, my lord, directions given to file the report, my lord. May I just hand over a copy?
Feasible to shift the location.
Yes, it is, because there is another meter room which has been constructed by the developer. My lord, we've said so, my lord.
So then I'll dispose of the writ petition.
Yes, paragraph 2. They have to take connection from that particular meter room, because my lord, the present meter room from which they want
You have got a copy of this report.
is, my lord,
Stand it over, my lord.
Just now handed over.
I've sent.
You're so fast, Ms. Rao.
my lord, paragraph 3, my lord.
Come back, take instruction, come back tomorrow. It will retain its position. The affidavit of service.
My lord, may I only say one thing?
Yes.
Present meter room will not be feasible, my lord, because it is exposed to nature, worn and torn. So there is an alternative place, my lord. If she has to take it from there only.
My lord, we are
Whatever be
suffering
the
from
dispute
July,
with the
lordship.
promoter.
This is an emergency service, my lord. I am a school going and college going children. I have
No, no.
resides.
There you have sought a shifting. They are willing to shift at your cost, but that will be to
Lordship, last
their
occasion,
chosen location.
Lordship, to inspect the place.
They have
of
inspected.
the-
Please look into the report.
Lordship,
Read
lordship,
it right now.
Lordship, I send him a letter.
Not lordship.
Husband,
Lordship.
her husband.
There's a difference in meaning between the two. Yes.
I apologize, my
Huge difference. And I'm wearing black. So please read the report. Right now, read the report or dispose of the writ petition. What's the use of pending?
Petitioner's husband was present at the time of inspection, my lord.
Now there will be a strained relationship between them.
My lord directed them to give me a new connection, my lord.
Read the report, ma'am. Read from para 2.
Niche.
No, what is the dispute? They sought for this shifting.
A meter room from which she wants to take connection. That is, my lord, totally in a worn and dilapidated condition.
She wants a new connection.
New connection. We'll
You
give
want
it.
a new connection? They'll give a new connection from the that.
Meter room constructed by the promoter.
They'll have to pay the shifting charges
Yes.
extra.
Necessary charges for shifting and installation of meter. Paragraph 4.
No, Ms. Rao, why should they pay the shifting charges? They'll pay
Because
only.
there is a meter which she's using from the dilapidated portion.
Yes. Reply.
Should kindly direct them. We will pay this.
Then at council for the CSC Limited files a report which indicates that due to the worn out condition of the existing meter room, a new electricity connection cannot be given to the petitioner there. However, the CSC Limited is willing and agreeable to give a new connection to the petitioner subject to the petitioner paying shifting charges for shifting the existing arrangement to another meter room, which is in serviceable condition. Next para. In such view of the matter, WPA 16305 of 2023 is disposed of by directing the CSC Limited to raise a quotation intimating the petitioner as to the necessary costs to be borne by the petitioner for having a new meter, new electricity connection, including shifting charges. Such quotation shall be issued within a week from date, upon the petitioner complying with all formalities and paying the due charges, the electricity connection shall be given to the petitioner accordingly by the CSC Limited, positively within a fortnight from the date of compliance of such formalities by the petitioner. No address to cause, urgent settlement. What?
32.
Yes,
I
Mr. Dhar.
appear for
Yes.
the petitioner. I shall try to be pre-vacation as short as possible.
Thank you. Yes.
Lordship need not see any of the things.
Yes.
My lord,
You're for the respondent.
My lord, actually, Mr. Somnath Ganguly, learned AGP is for the respondent. He is engaged in courtroom number 7.
You are there. You're also on the panel.
My lord, I am not engaged in this matter, my lord.
I'll engage you. Yes. What is
My
it?
lord, some
Let
other
us see if
reason-
the relief can be granted. Then only I'll. Yes.
my lord, since it's a pre-vacations, otherwise I would not have. But it was an NIT for drugs and food for the animals. Now requirement, there is a technical, financial, then selection.
Then
Selection. I was successful in the technical. Valid drug license, manufacturing license has to be there, and there are 2 other conditions for a period. How much period?
Hmm.
I have given all my documents.
Hmm.
They are selected in the technical. Thereafter, I could go to the financial. I was the L1. Thereafter I started supplying. That is working. After about 6 months, now they issued a show cause notice. They said in one of the documents, you have made an incorrect statement. And that incorrect statement is that
You are 6 months into the work.
yes.
Okay.
And that they say that you should have had 5 years of that drug license. The documents that you have given, that shows 4 years something.
What is the requirement?
According to me, requirement is a valid drug license in one position. Other position, there is a little hazy. One way of looking at it, 5 years. Otherwise, now it could be financial 5 years or it could be exact 5 years, calendar wise. Whatever that is, point that I'm taking 2. They have cancelled everything, but I'm seeking a relief that they have debarred me. I won't be able to work anywhere else. That can be done only by the principal secretary and also after hearing.
No show cause.
They have given a show cause, but the
Hearing is not essential, Mr. Dhar.
well, I'm not on the hearing part. I said that the director has no power. It is the power of the principal secretary. May I show page 48?
You are seeking a stay of the
On the
debarment.
department. Because, my lord, I won't be able to participate for any other places. Kindly see, my lord, the irreversible effect. Assume I have a good case after 3 months. During these 3 months,
You are challenging the termination also. Yeah.
Yes.
I'll direct affidavit shall pass an order of stay regarding the debarment. Termination remains for the time being.
Because as far as they and their money, my lord, that may be decided. But because
I'll not decide anything.
Yes,
I
yes,
just
yes, yes.
Learned Senior Counsel appearing for the petitioner contends that the petitioner, after turning out successful in a tender, started work after the petitioner was about 6 months into the said work, the contract was terminated on the allegation that the drug license furnished by the petitioner was marginally short of the tenure for which it was to be furnished. Consequentially, the petitioner has also been debarred from participating in future contracts. Next para. Learned Senior Counsel argues that apart from the fact that the tenure of the drug license being arguable, which vitiates the termination itself, the show cause notice issued by the show cause notice for the debarment and the hearing and the decision were taken by an authority which did not, in terms of the contract, had the authority to do so. Since such arguable questions have been made out for hearing the writ petition on merits, the respondents are directed to file their affidavits in opposition by November 30, 2023. Reply, if any, shall be filed by December 7, 2023. The matter shall be listed on December 11, 2023 for hearing. There shall be stay of operation of the order of debarment of the petitioner in future tenders till January 31, 2023 or until further order, whichever is earlier.
2024.
Deeply obliged.
30th January
24.
2024.
Yes.
That will take some time.
Thank you.
That's deeply
Next.
obliged.
33.
Lord, I prefer to respond.
It's my application, my lord.
You are for the petitioner, you are for the respondent.
Yes.
Yes.
My lord, before your lordship goes through the brief, my lord, in short, the facts, my lord. My lord, I had appeared in similar other matters, my lord. So leveraging that knowledge of the facts, my lord.
Yes.
This petitioner, my lord, has entered into an agreement by way of a tender process with the respondent. The petitioner is a MSME. Now, my lord, the oil company requests, directs us that you give a certificate in their own format, saying that particulars are to be stated that I am a MSME so and so, my investment is so and so, so and so, so and so.
This is a scheme or a tender?
It's a tender. During the currency of the tender, this requirement is given to us that you need to give us a certificate from the MSME authority in the oil company's format. We approached the MSME authority several times and also write back to them saying that we have already approached the MSME authorities. But the MSME authorities, my lord, refuse to give a certificate in their format. They say we'll act, but in terms of our statute, which governs us and not in terms of their format. My lord, this deadlock continues, a show cause is given to me. Now, my lord, this show cause we challenged in an earlier round of litigation. My lord, matter was taken up by a concurrent bench, my lord.
Show cause regarding what?
My lord, show cause regarding the fact that I could not furnish them the certificate which they wanted from me in
But
their
the
prescribed format.
tender is still on.
My work was continuing.
Oh, you are successful and
I was successful.
that's
During the currency, my lord, they asked
Great.
us that this is one of the additional requirements.
right.
Now, my
Then-
lord, we challenge it, my lord. This show cause notice is set aside by the concurrent bench, my lord, and with certain directions upon the state to issue a certificate within a particular time. Now, my lord, state files a recalling in that writ petition. We file an application, this petitioner files an application for modification of that order because the time had already expired. Now, my lord, this petitioner was not the only one. There were several other similar MSME entities, my lord, who preferred similar writ petitions, consequently similar modification applications. And in all those writ petitions, my lord, state had filed a recalling application of my lord Justice Sinha's order, Oindam Sinha's order, my lord. Now, my lord, these applications, as far as this petitioner is concerned, my lord, both the applications remain pending. Now, my lord, after certain gap, many writ petitions were disposed of. Some went up in appeal at the when the orders of the single judges were challenged by the oil company before the division bench. My lord, with regard to all those petitioners, my lord, similar orders have been passed. In fact, sitting singly, my lord, your lordship has also been pleased to dispose of certain batches, my lord. That order I have brought, and all those orders I have annexed. Now, my lord, when my application and the state's application remain pending with them, they again started giving us show cause notices that you have not been able to take any steps with regard to your pending writ petition, and therefore we will terminate you. Now, my lord, we mentioned the matter before various benches having determination, and some, my lord, misfired. We mentioned it, it was listed, but the honorable single judge said that I do not have determination, so it was released. My lord, that point of release was also, my lord, it was arguable point, but however, it was released because, my lord Justice Rajarshi Bharadwaj said that my lord was having a determination of irrespective of classification hearing matters. Now, my lord said that this is a application in a disposed of matter, so per se it is not a hearing matter, so I don't have determination. My lord, so in this way, the writ petition remained pending. During the pendency of those applications, my lord, they have now given a termination to me.
So what is the last position? They have sought for a recalling of what order? By that
Not
order?
them. My lord, state has sought
Sorry,
for a
state.
recalling.
Yes.
And recalling of that part where the honorable court directed them to issue a certificate.
Them means whom?
The
MSME Council.
The MSME authority.
In the format of IOCL.
Yes. They have, state said that I cannot do that, kindly recall the order.
But that order still remains.
That order still remains.
Right.
That order still remains, and my application, the writ petitioner's application and state application remains pending in that writ petition. Now, my lord, when that applications are pending, they terminate me, saying that you have not been able to give us the certificate, though we have waited for you for a very long time. Now, my lord, the petitioners are before your lordship, my lord, for a stay of that termination, number one, and secondly, my lord, an interim order upon them, so that they do not invoke my bank guarantee. Because, my lord, I was always before this honorable court. My lord, the matters remain pending, my lord, for no fault of ours. We have also annexed all the mentioning slips, the emails we have sent giving the mentioning notice, everything we have annexed. We have annexed the orders also by which the matter came up
What
before
happened to
various
their work?
benches.
You have done your work.
My lord, my work was continuing up to the date of termination. Now, my lord, if your lordship kindly takes one by one, my lord, the documents, page 34 is the initial order.
So let us see what your learned friend says prima facie.
Thereafter, my lord, kindly allows me to place a few documents.
I will. If
Yes.
necessary.
First of all, my lord, the first order was passed in December.
No, the last position is that state has been directed to issue, MSME Council has been directed to issue as per your format.
My lord, this
State-
was in December 2019, my lord.
Right.
Thereafter, my lord, the division bench has intervened in this
But that
matter.
order still remains.
That order
If
still
the state
remains.
does not comply with, I mean,
My
what
lord.
can they do? Why should
They
they?
have
tell?
filed an application, my lord, for extension of time for compliance. That application, that was an infructuous application. They only prayed for
No,
one.
they cannot comply. If the state does not comply, then what can they
have
do?
to comply to us, my lord, by submitting the certificate of
Isn't
their
it a bit
investment.
unreasonable if the state does not do it? There's a specific direction on the state to give. Then
Then, my
act
lord,
on the basis of the MSME Council
my lord, the
format.
order was modified by the division bench in all the matters, my lord.
What was the modified?
All
state?
other matters.
Well, kindly seize, my lord.
No,
The-
this matter, it was not
No,
modified.
that is why they have
They
terminated.
did not prefer any appeal. Well, that remains.
After modification, what is the order?
Yes, yes.
State was directed to furnish the certificate. They did not approach the state after that, my lord. After the division bench order, Not
This
a
person
single-
did not have that.
No, they have not furnished, they have not approached this.
No, but it's not their fault. I mean, it's the state's fault if the state does not do it.
Well, they have not complied with the direction of the Honorable Court by submitting the certificate. Well, in order to remain,
What was the occasion for insisting upon this this
my lord,
particular
they are
format
claiming to
after
be-
they started the work?
they are claiming to be under MSME
Right.
provision. Now, my lord, we have found that in some cases, this particular provision is abused. In order to remain under MSME, your investment has to remain under a certain amount there, my lord. So they were directed to furnish certificate that their investment is within that parameter, my lord. So that they have not complied with it. Now, in the meantime,
But once the work is given to them, can we do it midway?
my lord, my lord, the MSME investment has to be shown. If the authority wants,
After ensuring that they are MSMEs, you
it was,
awarded the work.
it is one of the conditions of the tender, my lord.
Please show me that condition first.
That
They have to be continue to
not-
be MSME.
They have not annexed the tender document.
How do you say? Because once you grant the work to them,
my
issue the work order to them. I mean, you are admitting that they are MSME. You issue
It
the
is
work.
subject to that those conditions, my lord. Whatever the contract has been given, which
Then
subject
don't.
to that.
I'll grant
No,
a stay. You use a affidavit.
my
You
lord,
don't act upon this termination.
My lord, the contract has already come to an end, my lord. It was valid for 5 years. 2018 started. It has come to an end in August 2008, 30th August 2023, my lord. It is already terminated by efflux of time. No.
No.
I have the kindly cease.
No, the work is terminated means you will give it to somebody else.
No. The contract with me was for 5 years.
What was the nature of the job under the contract?
Transportation of LPG, my lord.
That period is over. You are
That
saying.
period is over. Kindly cease the contract.
And Mr. Bandapati, you have
It is
challenged.
over after termination. Termination is in August.
No, you have challenged what?
Termination is in
The
July.
termination, my
My lord, termination is in
termination
July.
at page 81. But something needs to be pointed out, my lord, in the termination, my lord. Kindly see second paragraph how it starts. This has reference to our show cause notice, letter number so and so, wherein it is stated that vide even number dated so and so, you were advised to get UAM certificate number. So, my lord, this termination is a follow-up of a show cause. Now, my lord, kindly sees, going by their own stance, kindly
No,
take
but
page
you
35.
you don't take any action on the basis of the termination because termination has other fallouts also. They may be charged penalty and all these things are there.
Penalty.
So I'll stay the operation of the termination or I'll record your submission that the tenure of the work is already over. This will be subject to the result of the
And
written
bank
petition.
guarantee,
My lord,
kindly.
kindly keeps the because there is an arbitration clause between the parties, my lord.
I'll keep the maintainability question open.
My lord, kindly sees, my lord,
Mr. Bandapati, your purpose will be served in the meantime. The termination
is state and they should not, my lord, invoke the bank guarantee, my lord.
My lord,
But
it's a July
no,
order.
no, don't invoke the ban because
I do not know, my lord, whether it has been invoked.
if not already very.
No, they are
My lord,
supposed to bring
kindly-
that
my lord,
instruction.
kindly
You will
appreciate-
not take any steps on the basis of the
my lord, kindly
termination order.
appreciate
That is the order.
My
I'll
lord,
pass.
kindly see,
My
my
lord-
lord, at least 20 writ petition decided by your lordship on the same point.
But my lord, he has not availed that
No,
opportunity. my
I
lord.
cannot, my lord.
He has been complacent, my lord, all along.
No, my lord, kindly.
Not a single communication that after the division bench
How
order,
soon can you file your opposition?
but I can file it up 2 weeks after reopening, my lord.
We are reopening on 16th. Then
16th.
you will file it by 30th. Learned counsel for the petitioner contents raises certain arguable issues. Full stop. Apparently, comma, after the petitioner commenced work in terms of a tender for the IOCL, comma, the IOCL insisted upon furnishing of a certificate by the petitioner in the format as chosen by the IOCL. Full stop. However, comma, there was a dispute on the part of the MSME authorities in issuance of such certificate, which led to litigation. Full stop. A learned single judge passed an order directing the state to issue an MSME certificate in the format as insisted upon by the IOCL. Full stop. However, comma, in certain similar matters, comma, an appeals were preferred where a modification was also granted by the appellate court. Full stop. In the case of the petitioner, comma, the recall application filed by the state is still pending. Full stop. During pendency of the said litigation, comma, the IOCL issued fresh termination notice and terminated the contract of the petitioner. Full stop. The petitioner apprehends that the IOCL may invoke bank guarantee and not take any further consequential steps following such termination. Full stop, next para. Learned counsel appearing for the IOCL opposes the contentions of the petitioner and submits that a set of litigants on similar footing as the petitioner preferred appeals against the order of the learned single judge.
No,
They
the
preferred
oil company preferred.
Sorry. Learned counsel for the IOCL থেকে শুরু করা। Learned counsel for the IOCL submits learned counsel for the IOCL controverts the submissions of the petitioner and contends that the petitioner was duty bound to produce documents to satisfy the IOCL that the petitioner remained MSME units during the entire period. Full stop, having failed to do so, comma, the termination notice is justified. Full stop, next para. It is also submitted that the tenure of the work assigned allocated to the petitioner has in the meantime come to an end. Full stop. Moreover, comma, learned counsel for the IOCL submits that he is required to take instruction as to whether the bank guarantee has already been invoked. Full stop, next para. Having made out a prima facie case, comma, the petitioners are entitled to an interim order of stay. Full stop. Accordingly, the respondents shall remain restrained from acting upon the impugned termination notices issued to the petitioner till January 15, 2023 or until further order, whichever is earlier. Full stop. Next para. No consequential action shall be taken on the basis of the said termination notice by the IOCL during such period. Full stop. The respondents shall file their affidavits in opposition by November 30, 2023. Reply, if any, shall be filed by December 8, 2023. The matter be listed on December 11, 2023 for hearing.
May I pray this, my lord? The pending writ petition, your lordship is having jurisdiction. May it appear together, my lord. Then, if that is decided, my lord, this is in any.
I'll do that.
My lord, may I give the WP now? WP
Please
number.
give that. যেখানে বললাম যে be listed on such and such along with the connected matters bearing WPA this. Please give a list of the numbers to your learned friend also so that he can come.
Yes, my lord, it is already in the mentioning slips, my lord. It's already mentioned, my learned friend.
My lord, kindly keeps that mandate because there is an arbitration clause.
Oh, yeah, right. আরেকটা লাইন অ্যাড করে দেবেন. Since the respondents have raised an issue of maintainability of the writ petition in view of existence of an arbitration clause, comma, the question of maintainability of the writ petition is kept open for being argued and decided at the final hearing of the writ petition.
Perhaps, my lord, the interim order is gone down till 15 January 2023.
2024. Yes, thank you.
34.
My lord, I beg to appear on behalf of the petitioner.
Yes,
Respondents have been served, my lord.
Right.
My lord, just before the outset of pujas, my lord, there is a drive to evict persons who are authorizedly occupying northern portion of the Chandanagar railway station just before the pujas, my lord. They served us a notice that they are going to carry on with the eviction drive on 26th October, my lord. Matter was mentioned therefore before your lordship.
What is the capacity in which you are occupying?
My lord, I am a registered society, my lord. The members have been occupying since 1985. My lord, in 2005, pursuant to circular of the railways, my lord, they have applied and they have now constituted a cooperative society. Thereafter also they have applied stating that they are willing to pay the license fees, they may be regularized. Thereafter, my lord, recently under the Amrit scheme of the railways, my lord, where beautifications of several railway stations all over India is taking place, the Chandanagar railway station is also included. Now, pursuant to the scheme, we have applied saying that we have been occupying lawfully a portion of the
Why do you say lawfully?
Lawfully because, my lord, when I was granted the permission to operate as a society, my lord, no objection certificate was granted by the railways itself. And only upon the grant
No,
of
there has to be a license to operate in that.
That is
your creation of a cooperative society is your headache.
My lord, prior to grant of license to operate as a cooperative society, my lord, no objection certificate from the railways is required. That was granted, and only after that we have stated that.
That's a no objection for your formation of cooperative society. Show me something to indicate that the railway is acquiesced to your position.
My lord, we are there since 1985. Now, my lord, now we have given several.
In any event, they are to take due process of law to.
Yes, my lord, due process of law, my lord. At least before the railway, my lord, before the pujas, my lord, we have been occupying.
What are you doing there? I mean, you are.
My lord, we are vending various articles.
Vendors,
my
your
lord. Yes, my
vendors.
lord, vendors, 50
You have
vendors.
stalls
We have stalls
on the
over there.
platform.
No, outside the platform in a vacant area. That is the reason why, my lord, since 1985 and thereafter since 2004, we have been constantly pursuing with the railway authorities to regularize our stalls in lieu of payment of monthly license fees. My lord, now, my lord, what has happened?
You have never paid any license fee.
Yes, my lord, we are always willing to pay so, my lord. They are not
Willing to
accepting.
pay. I'm not asking whether you are willing to pay.
My lord, may kindly have
You
a
have
look
never paid any license fees.
My lord, kindly have a look at page 31, my lord.
Yes or no?
No. No, my lord, we have not yet.
Page 30?
Page, kindly have a look at page 31. My lord, this is the representation, my lord.
No, this is the.
My lord, this is a.
You have sought for a leave license. That does not ipso facto mean that you have got that license.
My lord, they are not even responding.
1985.
Since 1985, that we have stated, my lord, this is a representation. My lord, we'll find that the representation starts from page 22.
Mr. Bhattacharya, don't evict them without due process.
Your lordship, kindly peruse page several representations for your lordship.
They have given representations. There is nothing to show that they have been granted license, but they have formed a cooperative society with
Cooperative
your no objection.
cooperative society does not give
Does not.
right,
But with your no objection, why did you give the no objection?
Your lordship, kindly peruse once, my lord. They are page 25.
My lord, before that, my lord, only one document, my lord. May I show? Page 31, their internal memo, my lord. My lord, that they have no objection if we form a cooperative society. And that is the reason why the cooperative society was formed from a trade union. Kindly have a look at page 31. It is a document dated 11th April 2005.
To the existing
Reference to the above, this is to inform you that the railway land for commercial purpose on lease license basis is not possible as per railway circular such and such. In this connection, it is also mentioned that the railway land may be leased, licensed out for development of planned shopping complex through cooperative society amongst the existing shopkeepers. Existing shopkeepers, my lord.
They are not the existing shopkeepers.
Yes, my lord. Kindly have a look.
Very well, Mr. Bhattacharya, what do you say? I got to get
Your
you.
lordship, kindly peruse page 25.
Yes, 25.
25 minute, third paragraph. This is also to inform you that we are running our small business since 1985 by arranging temporary without causing hindrance to the passengers, and whenever the authority asks us to vacate the place, we have all along. They are admitting it is their case that they have nothing to show, nothing to prove that they are authorizedly there. They on their own they are saying whenever you say we'll evict. There is a drive, my lord, your lordship now peruse page 71.
They are running stalls without taking resort to public premises unauthorized eviction. How can you do this?
They are encroachers. They are encroachers.
From 1985.
Yes,
that is not admitted, man. They have, this is their statement. Man, your lordship, kindly, there's a huge development program and beautification program. Your lordship, kindly peruse page 71. Press release Amrit Bharat station scheme for development of modernization of the stations over the eastern region. In the first paragraph, your lordship, the middle portion, presently the scheme covers 1275 stations for upgradation, modernization over Indian Railway under the scheme, 94 stations in West Bengal, 86 in Bihar, and these and
well, no, Mr. Bhattacharya, at page 31, you have indicated to them that the shopping complex, it's not possible to give it commercially to individual stall owners, but they may form a cooperative society on
existing, those are who are existing shopkeepers. They are those are who are existing. They are agreement with this railway authority. License is there. There are different.
They are this Hawkers Cooperative Society.
They have formed. They have formed for the purpose of moving this, and for
they have formed. Please, they have formed on the basis of your impression. Page 31.
That is for the existing shop owners, not for the encroachers. They are the.
That will be decided in a proper proceeding, Mr. Bhattacharya. You have to initiate a proceeding, and you cannot. This in the garb of encroachment, you cannot just this drive of yours. I mean,
your lordship kindly
drive cannot be a substitute of legal procedure.
anybody come and build start selling item, they cannot claim any right over the railway property. You logically consider these cannot be, this should not be permitted to continue. They should.
You are the Hawkers Association.
We are the,
Who are the specific people who are there?
They have also,
They have prepared a list, my lord, according to their own, those who are the encroachers, they have formed a cooperative, and on the forming that cooperative, they are saying, but they are not the existing
So
shopkeepers.
they have formed the cooperative society.
But because anybody, we can also form a cooperative society, but that does not give, my lord,
That will be decided in a procedure in accordance with law.
but your lordship kindly consider, they are not the existing shop owners. That
That's a Bhattacharya, they have made out a prima facie case, page 31.
Your lordship, once again.
Page 27,
Please go on.
Your lordship, kindly consider, this is, in this connection, it is also mentioned that the railway land may be leased and licensed put for development of planned shopping complex through cooperative society among the existing shopkeepers. Well, I am putting emphasis on the word, well, if the existing shopkeepers form the cooperative society, they will be given. Not, my lord, anybody comes, the encroachers. There is a difference between the
No,
existing.
definitely, Mr. Bhattacharya. But since they have formed a
And
cooperative
the
society,
huge development program is going on. By this process, everything would be stalled. Your logically consider, everything would be stalled. Unauthorized
you cannot evict like this. Huge development process is very well. Public project I can appreciate, but Mr. Bhattacharya, you have to, this is not the way. You have to evict them in due process of law. Take summary procedure. Public premises act is there.
Your lordship, they have made representation, your lordship, in that even direct. Your lordship, kindly.
The representation is at page 27.
No,
the last representation is at page 77.
77, yes.
Your lordship, kindly peruse, my lord. But they are showing as if, paragraph 5, accordingly, the existing vendors hawkers applied for forming a registered railway hawkers cooperative society. These existing, they have brought the word, my lord, here. They are the existing encroachers, my lord. They are not the existing shopkeepers. Your lordship, kindly consider this part. The entire.
File your affidavits, Mr. Bhattacharya, grant stays in there. Learned counsel for the.
Your lordship, kindly, in that even direct, my lord, railway authority to consider this and dispose of within certain time, my lord. And
Nothing in my stay order will prevent you from doing that. I'll put that in.
Your lordship will direct, my lord, this.
I'll grant injunctive from dispersing them in the meantime, but nothing in this order shall prevent you from considering this. And let there be an exercise between you, both of you. Whoever is there, they have formed an
in the event, it is held against them. It is held against, in favor of them, it's all right. In the event, it is held against them.
If it is held against them, I can dispose of the writ petition with that. But if it is held against them, even then you have to evict them by due process of law. I'll put that in my order.
Your lordship,
I can dispose of the writ petition by doing that.
Your lordship kindly dispose of it.
But without doing that, without due process of law, you cannot.
If your lordship's view, my submission is
specific view.
My submission, your lordship kindly record, these they cannot be, since they are not existing.
No, I'll also record that it's a public project. There's a drive going on which will be stalled. Generally, injunctions are not granted regarding public projects. Those provisions are there. I'll definitely. Learned counsel for the petitioner contends that the petitioners are stall owners and vendors, occupying a particular portion outside the railway station at Chandannagar. Full stop. Next para. It is argued that the petitioner association represents several such vendors and hawkers who are in occupation of the said property since 1985. Full stop. Next para.
That is disputed.
No, everything is disputed. Learned counsel places reliance on annexure P3 at page 31 of the writ petition, which is a purported communication, purported internal communication dated April 11, 2005, whereby it was indicated by the divisional engineer 3, Howrah to the assistant engineer at Bandel that the railway land for commercial purpose on lease/license basis is not possible as per Railway Board circular. Full stop. However, the railway land may be leased/licensed out for development of planned shopping complex through cooperative society amongst the existing shopkeepers as per Railway Board circular. It is argued that in terms of the same, the petitioner cooperative society was formed. However, the railway authorities are seeking to evict the petitioners without evict the members of the petitioner without taking recourse to due process of law. Next para. Learned counsel appearing for the respondent for the railway authorities submits that the internal communication relied on by the petitioner only commented about the existing shopkeepers. However, the petitioner society represents encroachers, who are not the existing shopkeepers at the relevant point of time. That apart, it is submitted that no injunction may be granted in respect of a public project, since the railway authorities are implementing a central project under the name of Amrit Bharat Station Scheme for development / modernization of stations of the Eastern Railway. It is submitted that the rank trespassers and encroachers who are squatting over properties belonging to the Eastern Railway are being driven out by the railway authorities. Next para. Upon a perusal of the materials, it transpires that the petitioner association and its members have given several representations to the petitioners, representation to the railway authorities, lastly on June 2, 2023, within bracket annexure P10 at page 77 of the writ petition, bracket close, Next para. It is well settled that even unlawful occupiers of a property are required to be evicted by following due process of law. Next para. The Eastern Railway is not a favored litigant and cannot drive out encroachers / occupants of railway property without resorting to due process of law. It is also settled that there are specific laws for eviction of unlawful occupants of public property. Next para. In any event, learned counsel for the railway authorities submits that the railway authorities have no qualms, QALMS, in considering the representation given by the petitioner. Next para. Hence, WPA 19791 of 2023 is disposed of by directing the respondent authorities to consider and dispose of the representation dated June 2, 2023, annexed at page 77 of the writ petition, upon giving a hearing to the petitioner cooperative society and its members. Next para. The said disposal shall be in accordance with law. While so disposing of, the respondent authorities shall ascertain as to who are the actual occupiers of the property in question and members of the cooperative society in question. Next para. In the event the outcome of the consideration is that the railway authorities seek to evict the petitioner and its members, the respondent authorities shall only be permitted to do so by taking recourse to due process of law, under the available relevant statute in that regard. No arrest to cause urgency.
The stay of the
This is the notice.
this is the notice that they have issued that on 26th October they are going to demolish the stalls.
Page 36 is an eviction. Page 36,
Page 36 was the subject matter of challenge. Thereafter they have issued this.
It is made clear that prior to such consideration, it is made clear together. In the event the respondent authorities have given any notice or acted in terms of the decision to drive out the petitioner and its members without due process of law, such action of the railway authorities stands set aside by this order. Full stop. However, nothing in this order shall prevent the railway authorities to evict the petitioner and or its members in due process of law.
Your lordship kindly produce one there. It is written there in the last line. The action will be taken as per extent rules. Your lordship in the
Extent law.
extent
Rules will not do. Rules, your rules will not. There's a tendency, Mr. Bhattacharya, of the railway authorities in certain cases we have seen. You also must be knowing that they are in the Railway Act provide certain provisions, but that is for people who have entered into the railway platform, not for people who are squatting there or holding stalls there or some people like that. You tend to use, the railway authorities tend to use that provisions of the Act to evict people who are actually in possession by setting up stalls also. But that is not applicable to them. Criminal action is available for them, and other actions are there for people who come into the railway platforms.
In any event, your lordship as director let the railway authority decide the issue. But I think
Yes.
35, 36.
your lordship kindly specified the time limit by which the representation.
So do it, it's your problem now, because unless you do it, you cannot evict them.
35 millet, I am paying 1 day accommodation millet. Only 1 day accommodation.
This matter has been stopped long back.
I know I am not disputing millet for a 1 day accommodation.
This is 20.
I have
I
some-
cannot wait single day because Miller, I did not participate single tender since 3rd of August 20.
Debarment.
Yes, this is a case of debarment. Miller.
What is your instruction? Mr. Sengupta, in every matter you are asking for time.
No, no,
Another
I
matter you...
Miller, it appears from the document itself, there are the intrinsic infirmities which cannot be cured by taking instruction. Kindly have a look at Miller, page.
No, if the debarment order is withdrawn by them, they can take instruction. Mr. Sengupta, take care of this. I mean, I'll keep it at the... tomorrow I've fixed matters at the top. What is your instruction? Why didn't you take instruction? This has been served long back.
The person concerned will come at 3:30.
3:30?
3:30 to 4. In between.
I'll keep it at the top day after tomorrow.
My lord.
At the top.
My lord.
Or it's day after tomorrow কিছু আছে? Top-এ আছে? একটা দুটো থাকলো। This will appear within the first few matters on day after tomorrow. Take instruction, Mr. Sengupta.
My lord, please
Yes.
for leave to file affidavit of service.
Everybody
What-
served.
Yes.
Everybody served?
Yes.
Yes.
Well,
Mr.
what
Kohli,
is-
you are for the
WBSCT. Respond.
Yes, what is it?
Well, what is happened, my lord, in the year 2014, the father was who was the original consumer, my father, had died. Thereafter, I intimated my father had died. But after the death of my father, my lord, no bills has been sent for the period of 5 years.
No?
No bills were sent by the company from 2015 to 19. When I went to the office, please, why not you are not issuing the bill? At a time they have issued bill, but at having amount of 2,15,000 odd, imposing LPSC when there is no payment from my side. That was under threat of by the company, of disconnection, I have been compelled to pay that amount, but they assured they will waive the LPSC amount. But what has happened in this, when in the year February 2023, bill was sent, the LPSC as well as the charge of the electricity which was consumed. But problem is the meter is defective. But that amount has not been taken.
Meter becomes defective after the client comes to you, Mr.
What is happening?
All your meters are defective.
The meter was never defective.
Presumption is that.
I'm coming, my lord.
Yes.
There are what is happening, my lord. I pray, my lord, before the RGRO, my lord.
RGRO went against you, you went to Ombudsman.
Yes.
Ombudsman also went against.
Ombudsman, I have not approached Ombudsman because, my lord,
You have made the Ombudsman a party. Why? Number 2. You made him a party.
But what is happening, my lord? Page 62 of the order passed by the RGRO.
Go before the Ombudsman. No, you have a forum.
What is the problem? After the receiving of the notice, of that matter will moved on 23. 18 they have received. On 19 in the afternoon, line has been disconnected without service of notice under section 53. Nothing. That is supplementary affidavit before your lordship. I have prepared. I have also
Supplementary, I have not yet received.
I have served. That affidavit service is there.
No, that I have not received. Maybe
No, 2013 onwards.
They will go before the ombudsman.
Yes.
My line
Let
has
him
been
approve.
disconnected.
If you don't pay, line will be disconnected. When was the RGR order passed?
My RGR order was passed, my lord, on, my lord, 10th May 2023.
So why didn't you prefer a challenge before the ombudsman?
My lord, I already in the month of August, I filed the writ petition.
Writ petition is not maintainable. They have already disconnected. It will be subject to the. I'll give a time limit for the ombudsman. If you prefer the challenge within a week, it will be decided by say 15th of December.
My lord, problem, my lord, if your lordship, my lord, direct the petitioner to pay my lord certain amount, my lord, the lines would be, because my lord, Robi crops, my lord, is coming, my lord.
It's coming?
Robi crops, my lord,
Robi crop.
Season of Robi.
This is for submersible pump. What is the due?
Yeah.
Till today, 1,09,325.
Here,
It's a 2013 onwards.
1 lakh.
Cultivator, Mr. Kole, he'll lose his crops for the coming season. So it will affect our plates also. His personal interest also.
So let him deposit 50% amount and approach the ombudsman. That's along with
Counsel
reconnection
for the
charge.
petitioner challenges an adjudication by the concerned grievance redressal officer. Full stop. Several questions are raised by the petitioner which are controverted by learned counsel for the WBSCDCL. Full stop. However, during pendency of the writ petition, the electricity connection of the petitioner has been severed. Full stop. A supplemented affidavit disclosing such fact is filed today. Full stop. Next para. Since the ombudsman is the appropriate authority to decide factual issues between the parties, it would not be appropriate for this court to usurp jurisdiction of the said authority. Full stop. Next para. Accordingly, however, keeping in view that the petitioner is a cultivator and would suffer during the coming Rabi crop season, the petitioner is granted liberty to deposit 50% of the due amount with the WBSCDCL within 3 weeks from date. Full stop. If such amount is deposited within 3 weeks, the WBSCDCL shall restore the electricity connection of the petitioner on an ad hoc basis within 48 hours thereafter. Full stop. However, such restoration of electricity connection shall be subject to the ultimate adjudication by the ombudsman.
Right.
Full stop. WPA 19942 of 2023 is disposed of in the light of the above observations with liberty to the petitioner to prefer a challenge against the order of the RGRO within a week from date. Full stop. If such challenge is preferred within a week from date, it will be deemed that the said challenge has been preferred within the statutory limitation.
My lord, problem
Only
is,
one
my lord,
thing, my lord. Restoration along
Puja, my lord, reading Puja.
restoration charge, my lord. It's a statutory. Otherwise, I
My
can
lord,
say.
my lord, Puja is my lord, very, my lord, it is a knocking door for Puja.
Yes.
Because my 7 days, my lord, if your lordship, my lord, or 15 days, my lord, I have no problem.
For what?
For my lord, filing of application before the ombudsman.
File it tomorrow.
His urgency
Will you
is
copy
there.
paste of this writ petition? You do something for your client. It can be done by day after.
My lord,
Within this week, you can definitely do
my
it.
lord, only another prayer, my lord, 50% is very much difficult, my lord, because my lord,
Law does not permit you to deposit 50% and get a reconnection also. That's I have decided that on numerous occasions.
Yes, yes.
Only because of the reason before puja you are a cultivator. It cannot be stretched to beyond a particular limit. 50% is all right.
Well, only
You have
reconnection.
defaulted, you have to pay.
Well, reconnection charge, your lordship's kindly, it's 100 rupees because I can't
charge
say
has been
because of the
imposed.
statutory, that's why
LPSC
it's the
charge.
statutory provisions.
It is
Otherwise,
not
I
an
can't say.
electric bill. It is LPSC charge. When no connection was, when no bill
ওই
was
যেখানে
sent.
বললাম না 50% যেখানে বললাম along with the requisite reconnection charges.
It's only 100 rupees. I can't say because it's the statutory, that's why.
LPSC charge.
Arey, এটা statute.
My lord.
Passover matter, item 25.
I am for the petition.
Yes.
Reply to.
This is my applicability notation. My tender apology because at that point of time.
No, no, it's-
it was not.
Lordship, reply I have also handed over.
So far, on the
Yes.
last occasion. you
That
lost
nexus matter, Lordship.
Nexus, yes.
Yes, my last occasion, you lost raised that point.
Please use the microphone, Dr. Shara. No, not that. The microphone is not. on. Yes.
But if your lordship kindly come to paragraph 6 for a moment, in my affidavit in opposition. But this is the peculiar circumstances your lordship will find that this petitioner never disclosed about his status, about her status, from when she is staying in that position. Lordship kindly come to paragraph 6. May I place it? But this, with reference to statement made in 2000, I deny and dispute the statement made in therein what are contrary to the record. I further state that the petitioner never disclosed in the said petition, that is the writ petition, from when she is staying in the premises, number such and the Watergun Street, Kolkata. I state that the petitioner with her family are living in the said premises for a long period. During such period, the petitioner and her family member derive electricity from the defaulting consumer of the said premises. At that juncture, when the meters of the defaulting consumer were in live condition, the petitioner never made an application for new connection. It transferred from record that when the meters of defaulting consumer were disconnected only thereafter, that is subsequently the petitioner made an application on 10/12/2022 for new connection. The petitioner being beneficiary of such electricity from the meter of defaulting consumer cannot circumvent the liability of outstanding dues in the same premises. Thus, if such practice is encouraged, then there would be a huge loss of revenue, not only for the company, but also for the government. The conduct of the petitioner clear-cut shows the nexus with the defaulting consumer. I put out down the regulation, lordship, regulation 46, clause 13.9 of the West Bengal, lordship probably got the clause for regulation 46, clause 13.9 of the West Bengal electricity regulation may dated such and such, the intending consumer liable to clear the outstanding dues on pro rata basis. I will place that regulation. For this reason,
Dr. Shahara, who was the previous defaulting consumer?
But their name has been given in the letter, in the petitioner, lordship.
Page number 11, Lordship.
And the petitioner, even after in the reply, also never disclosed the status, lordship. Never given the card from when she is staying there. That goes to show the adverse inference can be drawn.
She's a newly married wife.
Newly married wife, the petitioner who is staying there, lordship.
Wife of one Imtiaz.
Imtiaz. And from when they are staying there,
Imtiaz is not one of the consumers.
No,
Imtiaz is not the consumer, he's the beneficiary of the electricity where there was a defaulting consumer, lordship. And on that basis, my lordship knows that even the beneficiary is also can be stated to be the consumer. Because at that juncture, lordship kindly appreciate the gamut of the situation. Because at that point of time, the petitioner's husband never applied for the new connection, lordship. He was staying there for a long period. After this outstanding dues.
Got it. Mr. Halde, what do you say?
Lordship.
Pretty obvious. You got married. Your husband through you made the application, but he was enjoying from the defaulting meter.
Lordship, we have
So there's
never consumed from these meters.
You have never. Your husband has.
Never.
He was residing there.
Lordship,
there is no meter in his name.
As per my instruction, there was an electric connection in the name of the petitioner's father-in-law. After disconnection.
What is the name of father-in-law? Abdul Wahid?
No. The name is not here.
Your husband was there. He had no independent meter. So he must have.
No, my husband has no connection with these three people.
He was without electricity for so long.
Yes, we have stated that.
Where?
In the reply.
Said that your husband was without electricity.
I am without electricity. I have.
You have been married recently. How could you be with electricity?
No, not recently.
When?
Almost 4 or 5 years.
Newlywed.
Almost
5 years.
3 to 4 years. We are married.
There is clear nexus, Mr.
Lordship, we have no connection with these three people.
Pay the arrear amount, get the electricity connection. Learned counsel for the petitioner submits. At the outset, learned counsel appearing for the CSC Limited files his affidavit in opposition and relying on the same argues that the petitioner's application for electricity connection was dated December 10, 2022, immediately after the defaulting connections were severed. Next para. It is obvious that the petitioner had nexus with the defaulting meters. Next para.
Learned counsel appearing for the petitioner by placing reliance on the affidavit in reply filed by the petitioner today submits that the petitioner is a newlywed wife at the premises and had no connection or nexus with the defaulting meters. First up, next para, it transpires upon query of court that the petitioner has been married to the to her husband, comma, who is a resident of the premises, comma, about 4 or 5 years back. First up, next para. Thus, comma, it is evident that since the petitioner's husband did not have any electricity meter in his name in the premises, comma, he must have been using electricity from one of the 3 defaulting meters specifically named by the CSC Limited, full stop. Thus, comma, the oblique manner in which the petitioner has been made instrumental to make an application for electricity connection, comma, which will be enjoyed by not only her husband, but probably by all the other residents, comma, cannot but be deprecated. Full stop. Next para, in any event, comma, sufficient nexus has been proved by the CSC Limited for the petitioner to be saddled with the additional costs, comma, apart from the connection charges, comma, regarding the dues which are pending in respect of the defaulting meters. Full stop. Hence, comma, WPA 10803 of 2023 is disposed of by granting liberty to the petitioner to clear all outstanding dues as well as pay the new connection charges for getting an electricity supply to the premises in her name. No orders to cause urgency.
Great.
Pass over matter item 30.
30, my lord. I beg to appear for the petitioner. The respondent was there. This is that matter admitted amount.
Mr. Prasad is there, yes.
This is the affidavit of service, my lord.
Page 54 is the admitted amount accord.
Yes, my lord.
Mr. Prasad, page 54, please come to there.
That is their reply.
Now it is, the fact is that Malot, it is the Jela Purishad. Now Malota, Jela Purishad, what the Malota, as per my instruction, they are having a separate set of lawyers. Now Malota, apps, it is admitted Malot, let that be released.
They did the work for the Jela Purishad.
Malot, yes, the work has been Malota given to them by the Jela Purishad itself. Accordingly, he had executed the work and Malot, the bill was raised, and this was the Malot RTI reply, wherefrom it appears Malot, this is the admitted claim.
Jela Purishad is a party, my lord.
I was going to ask that. They have been duly served.
Yes, ma'am.
You are for the state only.
Only state, Malot.
Despite service, none appears for the other respondents than the state. Full stop, next para, affidavit of service filed to be kept on record. Full stop, next para. The petitioner worked for the concerned Zilla Parishad. Full stop, subsequently upon the petitioner's query under the Right to Information Act, comma, the SPIO within bracket State Public Information Officer, bracket closed, comma, Malda Zilla Parishad intimated that the total outstanding dues towards the work done by the petitioner was rupees 17,35,000 oblique dash. Full stop, next para. However, comma, till date, the said amount has not been cleared by the said respondents. Full stop, next para. Learned counsel for the state submits that the Zilla Parishad is represented by a different set of counsel. Full stop. Upon hearing learned counsel for the parties, comma, it is clear that vide the information supplied on February 8, 2022 by the Malda Zilla Parishad as annexed at page 54 of the writ petition, comma, the Zilla Parishad clearly admitted the dues of the petitioner to be rupees 17,35,000. Full stop. Hence, comma, no factual question is required to be adjudicated on merits upon taking evidence, comma, in view of such specific admission of the employer. Full stop, next para. Accordingly, WPA 14715 of 2023 is allowed, comma, thereby directing
Respondent number 6, the secretary.
the respondent number 6
And 5.
directing the respondent numbers 5 and 6 to disburse the amount of rupees 17,35,000 to the petitioner within 4 weeks from date, comma, in lieu of work done by the petitioner, full stop. Next para, the respondent number 1 shall ensure that the due funds are released in favor of the concerned Zilla Parishad for the purpose of paying the petitioner. No rest to cause urgency.
My lord, in
Grateful.
that event, I am only making one prayer, my lord. Can it be 6 weeks?
6 weeks, not 4, 6.
And my lord, on instruction, I am submitting that my lord Jela Purish is represented by the separate setup.
Everything is on instruction.
Grateful. Great.
You know, it's direct knowledge. Whether you are representing the
One-
Zilla Parishad,
no,
this cannot be on instruction.
I am good.
Mr. Prasad, this cannot be on instruction.
I am good.
Yes.
38.
Yes. What is the matter?
My lord, this is my matter. My
All have been
application,
served.
my lord. All have been served, my lord. Only
Lord,
two
I appear
parties.
for the respondent.
Right.
My lord, I expect, my lord, a point of maintainability will be raised by my learned friend, my lord, because I am challenging, my lord, SABYASACHI action by this writ petition, my lord. I will, my lord, meet that point, my lord,
Not
first.
DRT2.
Not DRT2, my lord, DRT3, my lord. I am meeting that point head on, my lord.
Yes.
My lord, here, my lord, my only ground for coming before my lord and not before the honorable, my lord, the learned DRT is that, my lord, the only notice that has been served upon my clients, and I'm stating this on instruction and on oath, my lord, is appearing at page 45, my lord, which is, my lord, a notice that was pasted outside the scheduled property, my lord, indicating, my lord, not any date of service of any 13-2 notice, not any amount due to the bank, and only stating that a order under section 14 has been passed by the Learned District Magistrate, my lord. This is the only document that I have been served. Therefore, my lord, the only reason I haven't been able to approach the DRT, my lord is aware under the DRT rules, my lord, to file an application under section 17, I must know the demand amount. That is the only reason I've come, my lord. I must also point out before my lord a subsequent fact after filing of this petition, my lord, 2 dates. 12th August 2023 is the date of this, my lord, this notice that has been pasted outside my scheduled property. I come to know of the SABYASACHI action taken by the bank, my lord, on this date. Subsequently, I come before my lord and file the writ petition on the 21st of August 2023, my lord. And my lord, subsequently, I have been served with, my lord, a notice of an advocate of the bank, my lord. May I just hand up? I haven't had the opportunity, my lord, to form a supplementary affidavit. It is the bank's letter. I'm handing over a copy to my learned friend. My lord, wherein, my lord, they've indicated for the first time, my lord, will take page 2. They've indicated for the first time the demanded amount. This amount was not known to me. My lord, now
They
I
say
am
that
aware.
14/12/2021 13/4 was issued.
Yes, they say so, my lord. I'll, my lord, indicate why they have this contention and why, my lord, I am saying I haven't been served, my lord. The loan is of 2009.
You are the borrower.
I am the borrower, my lord. Admittedly, I am not
Yes.
disputing this.
Yes.
Loan is of 2009, my lord. Subsequently, my lord, I've been making AMI installment payments, my lord. Around April 2021, my lord, I approached the bank and I've annexed the email correspondence in that regard to, my lord, forward me the amortization schedule and
What
the
was
final.
the date again?
My lord, April 2021 and what I've
Very well.
annexed
Yes,
the
before
entire
this, before 34.
before 34th, my lord. So April 2021, my lord, I write to them seeking the amortization schedule and the amount that is due and payable by me to the bank. They, my lord, forward an amortization schedule which does not take into account the entire payable, my lord, the EMIs that I have paid between 2009 and 14. And my lord, I'll show from
Now
there.
prefer a challenge under section 6.
I will, my lord, do that, my lord. I'm just indicating one further fact, my lord, is that, my lord, here the only dispute between the parties is in respect of non-consideration of the EMIs I have paid between 2009 and 14. My client is, my lord, ready and willing to pay whatever is due and payable, my lord. If and the bank can consider my objections, and my lord, I've written and they've acknowledged the fact.
Where are the objections you have annexed?
My lord, it starts on page 60, my lord. These are emails. My lord, one more fact may I just indicate, my lord. During the COVID-19 pandemic, my lord, my client was in Bhubaneswar. Even though the address in the loan agreement, I'm sure my learned friend will point out, address is in Calcutta. But I have been stuck in Bhubaneswar during the pandemic, my lord. The 13/4, 13/2 notices, my lord, will note are of 2021, my lord, in the document that I've my lord, handed up. It's of September 2021 and December 2021. At that point of time, I was in Bhubaneswar. The bank, I've written to them repeatedly, my lord, asking them to provide me with a contact in the Bhubaneswar branch, my lord, so that I can approach them and, my lord, I can get the exact amount that is due and payable. They acknowledge this. May I just point out one page, my lord, page 58, where they acknowledge the fact that I am in Bhubaneswar. My lord, page
No,
50.
your EMIs have not been considered means your payments.
My EMI, my lord, the payments that I have made, the deposits that I have made
Those are
from
not considered in
2009
the-
to 14, they do not,
Those are not calculated.
they are not calculated. And they say, my lord, that is also on record. They say that their servers and my lord, their records till to October 2014 are missing. There's a technical glitch. That is what they say. And I repeatedly request them to give in, my lord, provide me with
Also,
the
you can
actual
move
account.
you have to move the DRT
My
immediately.
lord, I'll have to do that.
Give
My
them
lord.
some protection.
My lord will kindly do that. My lord.
My lord, firstly,
My lord, till after.
my lord, there is no document which is missing.
Hmm.
My lord, in our reply, my lord, we stated that we had a change in software in 2015.
Yes.
Therefore, any document pre 2015, we will not be able to provide it. My lord, insofar as the 6-year installments not being considered,
Hmm.
my lord will kindly take up page 58.
58 years.
My lord, at the bottom, this is our reply to their email. Dear sir, we are in receipt of your email and we wish to inform you as below. Your loan account was sanctioned for 240 months at floating rate structure. However, the rate of interest is linked to a reference rate, and any modification in the reference rate impacts the rate of interest on the loan. Repayment of loan is as per the sanctioned terms and conditions of the loan. And my lord, this is important. Whenever there is increase or decrease in our reference rate, it impacts the rate of interest of the loan amount. EMI of the loan is not changed, keeping your convenience in view, and hence the effect is given on the tenure of the loan. Any increase, decrease in our reference rate and leading to changes in rate of interest is intimated through emails and letters. Letters had been sent at the office, at the premises, which are the secured asset. You may increase the EMI of your loan account and reinstate the tenure. The earlier loan was for 240 months, 20 years. My lord, if your lordship kindly takes up the loan letter, initial loan letter.
Page 19. Page 19, my lord.
My lord, at page 19, my lord, the rate of interest is 9.75%.
So according to you, the reference rates were conveyed to them.
My lord, after COVID, my lord, the interest rates have increased rapidly. And therefore, in order to ensure that the borrower is not burdened with additional EMI, my lord, the tenure of the loan is increased. My lord, the loans, the EMIs that they have paid, my lord, has been duly accounted for. But to ensure that the borrower is not burdened with additional payments, the tenure of the loan has been increased. My lord, all of this has been taken into consideration. And my lord, there is nothing amiss that my learned friend state. My lord, insofar as the writ is concerned, my lord, I am backed by judgments of the Supreme Court, my lord, clearly not maintainable. My lord, the notice that my learned friend referred to page 45.
Self-imposed restriction from OC Krishnan onwards. You are PNB?
Yes, my lord, I am PNB.
Because in your bank's case, OC Krishnan. Yes.
My lord, this is not the first time that letters have been sent. My learned friend stated that he's been staying in Bhubaneswar. My lord, COVID happened in March 2020. My lord, letters subsequent to that, 2021, August, September.
In August, September, my lord.
August, September 21.
Yes.
COVID, this
And-
moratoriums are continuing. And all
My
this.
lord,
The
kindly.
moratoriums were continuing, but he being a lockdown, he
Oh,
being
he could not have
forced-
been locked up there. Right.
he could not have been locked up, my lord, the premises.
My lord, only, my lord, just to counter the point of service, may I just page 58, which my learned friend referred to, my lord, there itself, they tell us the address of the Bhubaneswar branch, who I can approach. So they
Emails
acknowledge-
also. They refer to emails also.
By email, they did not
cannot
serve.
be.
My lord, the 13-2 notice, my lord, I'm submitting on instruction. There is no email service of the 13-2 notice or 13-4. Let my learned friend show. There is no email service. They were aware that I was in Bhubaneswar
I'll
in
give them 3
2021.
weeks to move these
My lord.
section 17. Without going into the prima facie case even, I'll make that clear in my order. This will not operate as a prima facie adjudication on anything. The petitioner contends that the petitioner, upon coming to know of a notice under section 14 of the Surface Act 2002, learned about a purported proceeding having been taken out by the bank under section 13 within bracket 4 of the said act. First up, it is contended that prior thereto, no notice was served to the petitioner. First up, the petitioner was locked up in, it was not locked up, it was stuck up in Bhubaneswar during the lockdown period, for which the letters addressed to the petitioners could not reach the petitioner. First up, it is contended that the bank fully knew of the said fact. First up, next para, that apart, the EMI amounts paid by the petitioner were not considered by the bank, and the bank admits that its records are missing prior to October 2014. Full sub next para. Learned counsel appearing for the bank controverts all the allegations made by the petitioner. Full stop. Insofar as the address at Bhubaneswar is concerned, comma, it is contended that at each juncture, comma, the bank duly notified the changes in the reference rates to the petitioner by email and by letters, full stop. Moreover, comma, the lockdown period was long over, comma, in 2021, comma, when certain communications were also made, full stop. That apart, comma, the argument as to the EMI amounts having not been considered is belied by the communications made by the bank, full stop, by placing reliance on the communication by email annexed at page 58 of the writ petition, comma, learned counsel for the bank reiterates that the loan account was sanctioned for 240 months at floating rate structure, full stop. However, comma, the rate of interest was linked to the reference rate and any modification in the same impacted the rate of interest of the loan, full stop. The increase stroke decrease in the reference rates were duly notified to the petitioner by email stroke letters, full stop. Next para. As such, comma, there is no irregularity or infirmity in the procedure adopted by the bank, full stop. Next para. Factual disputes are involved between the parties, full stop. However, comma, this court is not the appropriate forum for adjudicating such issues on merits, full stop. The court seeks to impose a self-imposed restriction by not entertaining the writ petition under Article 226 of the Constitution of India, since the petitioner has an equally efficacious alternative remedy in the form of a challenge under Section 17 of the SABYASACHI Act 2002 before the appropriate tribunal, full stop. However, comma, in order to give a short breather to the petitioner to move the DRT, comma, the respondent bank is restrained from taking any coercive action against the petitioner during for a period of 3 weeks from date, comma, within which the petitioner would be at liberty to approach the concerned Debts Recovery Tribunal with a challenge under Section 17 of the SABYASACHI Act, full stop. If such a challenge is preferred by the petitioner, comma, the tribunal shall consider the same in accordance with law and as well as any interim order which may be sought by the petitioner. For sub next para, it is, comma, however, comma, made clear that this court has not gone into the merits of the contentions of the parties at all, and the ad hoc protection given to the petitioner is, comma, as the name suggests, comma, merely an ad hoc arrangement to enable the petitioner to prefer a formal challenge before the appropriate forum, and is not a commentary on the respective rights and contentions of the parties. WPA 20464 of 2023 is disposed of with the above observation.
Since affidavits have not been
Since affidavits have not been invited, comma, it is deemed that none of the allegations made in the writ petition are admitted by the respondents. Affidavit service filed to be kept on. Thank you.
39.
On previous
Yes.
occasion, Honorable Court directed to amend.
Let's come closer to the microphone.
On previous occasion, Honorable Court directed to amend the cause title by putting the name of the complainant private as private respondent.
You have served on the complaint?
Malad, I have served. Malad, on Friday, on
Friday
last Friday, Malad, because there is a transfer brief. I have to get no objection. And
last Friday they may not have received.
Malad, this is a track report. Only they received. Malad.
Received.
Only received.
Lordship, in this matter, I am for appearing for respondent number 5, Malad.
Yes.
This is medical negligence, Malad. I will file Malad affidavit. Short affidavit, Malad.
This is
Malad,
being moved for the first time.
Yes, this is first time, Malad. No, first before Honorable Justice Rajesh.
Party,
Rajesh brought.
later on, they made party and submit.
Malad, this is a story of an unfortunate doctor, Malad.
No. You have been imposed with a fine. You are the doctor. You treated.
Yes.
You are facing the fine.
Facing the final, this punishment, my lord. This is for suspension for the period of 6 months by medical council, my lord.
6 months is over already.
My lord, in December it will be over, my lord. In the meantime, he has many philanthropic activities and charitable for charitable purpose. He is restrained for doing the same.
I cannot prevent them from using affidavit in opposition. How can I?
My lord, then
I mean, this is a factual issue. That's why.
Yes, my lord.
What is your ground? I mean,
my lord, first ground is No death certificate is there. No postmortem is there. At
No,
the
suspension, if I find a prima facie case, I can postpone the suspension
Yes, ma'am.
subject to outcome of the writ petition. Suppose ultimately I decide against him, then the suspension can start operation from then.
Yes.
I can stay it for the time being.
Without affidavit.
That can be done.
At
definitely
the,
can.
at the time of her death, she was not under the treatment of the petitioner, my lord. She was admitted in Apollo Grange.
Show me especially from the
My lord, she was admitted in Apollo Granges Hospital.
Not a 46, kindly come. The appellate authority. So now I am not finding any depending the state. Statement.
You are the state.
No, I am for the council.
Council.
I guess my order, they preferred appeal. Appeal of the authority's order is under challenge before losses.
You cannot have any direct say in the matter.
My lord,
You cannot should not defend your own order. Yes.
Madam, this is a page.
Show me something palpable so that I.
Yes, madam. Page 51, madam. The final hearing held on last para 16. Final hearing held on 6/6/2002 at the office of the West Bengal Medical Council. The council observed that Dr. Samar Bandyopadhyay had misled the penal and ethical cases committee as well as the council about his attachment with Apollo Granges Hospital, as would be evident from the deposition of Dr. Joy Basu before the concerned committee. He could not absolve himself of his responsibility on being portrayed as.
This is page.
Madam, page 51, madam.
51.
51. Since he had used without being MD, Dr. Banerjee should have restricted himself within the domain of holder of a degree in general medicine and not to include other super specialties. The patient in question was treated by him with an antidepressant drugs for more than 6 months on the ground of marital disharmony. How he could arrive the conclusion beyond his, he should have preferred the patient to psychiatrist even if he was.
You are a psychiatrist.
No, no, my lord.
You are not a psychiatrist.
No, he's a neurologist.
Achha.
Well, on the other hand, no determinative test like CT scan, MRI of brain was advised to find out the root cause. This proved a failure of judgment of doctor on the part of doctor as a patient.
A neurologist, why did you treat her for depression?
Well, later on, she died in Apollo Granges Hospital. Not
Maybe,
under,
but due to your medication.
No, my lord, at the time of her treatment, she was depressed, mentally depressed for her marital disharmony, as stated by her.
She died of what? Brain
Died
tumor.
of brain tumor.
Brain tumor is related to antidepressant drugs.
No, my lord.
What is the link between brain tumor and antidepressant drugs? He treated with antidepressant
Because
and you died of brain tumor.
Before Apollo Granges Hospital.
Why should he pay up?
Kindly.
But on 3 forum,
Order the short
file the case.
short affidavit, my lord.
Short affidavit, long affidavit, whatever you like, I'll give you.
I-
But why
I
should I
want
stay
to-
this order?
Trying to give my lord.
That does not mean that the court cannot pass any interim order,
No, my
sir.
lord. How-
Prima facie satisfy me on this.
Not only the consideration that not being a specialist in a subject, just claiming that I am a specialist.
It has to be linked with the death.
Well, MD internal medicine. At that time, internal medicine covered all the branches. My lord.
A specialist on a subject not possessing.
My lord, in 1980s,
A non-specialist may very well prescribe a medicine. For that, why should he be penalized?
Claiming the specialist.
So for that, you have to show that the patient deteriorated.
That not the violation of the etiquette rules under the MCI.
No, ma'am.
There's just
She died of he or she. She died of brain tumor, and you are penalizing somebody who treated her with antidepressant for 6 months. This is ridiculous. What are you saying?
3 forum, the case was initiated, my lord.
What
in
nexus is
criminal,
there between
criminal court,
antidepressant and
in consumer forum, and in medical council, my lord. 3 forum, the case was initiated against the petitioner, my lord. For reason
today
based on
morning
to
I
them.
have got the my lord, the copy, my lord. I have not go through it, my lord.
Don't go through it. Go through it only at the time of filing opposition, but I'll stay the order.
Well, he is a renowned physician, my lord.
Yeah, that may be. But even
Dr.
then,
Samar Banerjee.
Reason order is from 53 of the appellate authority.
Appellate authority just uphold the order of the medical.
if you are citing something, please cite that provision.
It is a 7.20 of the regulation Indian Medical Council Professional Conduct Etiquette and Ethics Regulation 2002. 7.20.
The 6 month suspension is the only punishment given. No fine.
No, I have no other authority. I can only impose re-registration for either for limited period or this is.
Revert from practice.
You're the medical council.
Yes, and there is a provision of appeal also before the National Commission.
They have not taken that.
No,
Appellate
Section
authority
30
is
is the, after new act, section 30, first appeal, second appeal. There's a two appeal provisions before the national.
We prefer only first appeal.
No, no, yeah, alternate remedy under.
Yes, why didn't you prefer an appeal?
My lord, an appeal under 26 of Bengal Medical already filed, my lord, and that order was already challenged, my lord. Appellate authorities order challenged.
They preferred an appeal under section 26 under the Bengal Medical. Now after the enactment of.
Yes, what do you say regarding interim orders? How to defend this? She was not under his treatment at the relevant point of time. And there is no direct nexus between his treatment for secondary depression and the demise.
It is complete separate issue.
Today only, my lord.
No.
I'll go through it, my lord.
But
Today morning I have got the brief, my lord.
That's your problem. You have got the brief today morning. When did you serve a copy? When did you serve copy?
On Friday, on Saturday received. Saturday it was received, my lord. This is the track report, my lord.
Learned counsel for the petitioner contends that the authorities below have acted without jurisdiction in imposing suspension for 6 months from practice against the petitioner. Full stop, next para. It is contended that the patient was suffering from brain tumor, which had no connection with the medication given by the petitioner. Full stop. It is further contended that even as per the impugned decisions, the patient met her demise at a point of time when the petitioner was not treating her. Full stop, next para. Learned counsel for the medical council places reliance on clause 7.20 relating to misconduct, of the Indian Medical Council within bracket professional conduct, etiquette and ethics, bracket close, regulations, 2002. Full stop. The said provision stipulates that a physician shall not claim to be specialist unless he has a special qualification in that branch. Full stop. The allegation against the petitioner is that the petitioner, being a neurologist, administered antidepressant drugs to the patient for a certain period of time. Full stop. Next para. However, even if the petitioner was a neurologist and administered antidepressants, such act per se does not indicate that the petitioner claimed himself to be a specialist in a field in which he did not have any special qualification. Full stop. Next para. That apart, the petitioner has made out a strong prima facie case as to the authorities below having acted palpably without jurisdiction in handing out a suspension to the petitioner, even in the absence of any direct nexus between the petitioner's administration of antidepressant to the patient and her demise, keeping in view the fact that the patient was also suffering from brain tumor. Full stop. Next para. Moreover, the petitioner was not under the treatment of the patient was not under the treatment of the petitioner at the relevant point of time when she met her demise. Full stop. Since such arguable questions have been raised, the writ petition is required to be heard on merits. Full stop. The respondent shall file their affidavits in opposition within November 30, 2023. Reply, if any, shall be filed by December 8, 2023. The matter be listed for hearing on December 12, 2023. Full stop. There shall be stay of operation of the suspension of the petitioner as of today till disposal of the writ petition. Full stop. It is made clear that
Such stay of operation shall be subject to the outcome of the writ petition, and in the event the writ petition ultimately fails, comma, the suspension shall be deemed to stand postponed till the date of disposal of the writ petition. Full stop.
May I?
Urgent certificate could be.
File your
It is,
response.
it is not a question of suspension, it is a removal of name,
Removal of
name from the, our race.
সাসপেনশনটা যেখানে বলেছি সেখানে রিমুভাল অফ নেম করে
My lord, all the parties act to website copy, my lord.
Yes,
Because urgent certificate copy is not.
council will act
Okay.
ensure that the respondent does
Deeply, deeply, please.
file your affidavit of service
Yes, ma'am.
during the course of the day. By tomorrow do it, try to do it by today. একটা লাইন অ্যাড করে দেবেন, leave is granted to the petitioner to file affidavit of service by tomorrow, but do it today.
Deeply.
40 for the petitioner.
Yes, what is it?
But this is my lord the admission,
This is that matter.
that matter.
Yes, what is it?
My lord kindly
Mr.
comes,
Bhomike was there. Yes.
my lord kindly comes to my lord page 19. My lord that was the rejection.
What was rejected?
My lord, I am the MBBS and my lord the completed my lord the diploma course in radiology that was uploaded in the my lord, medical council certificate. My lord
Yes.
kindly comes to page 18 first. Page 18, my lord will find qualification, basic qualification MBBS and additional DMRD, Calcutta University 2001. And my lord, in previous page 17, my lord, that is also recognized, my lord, the certificate issued by the NRS Medical College. My lord, since this is a recognized course, my lord, that has been my lord, uploaded by the Medical Council of West Bengal Medical Council. Now, my lord, being an eligible candidate, I my lord, filled up the form and my lord, I appeared in that examination for my lord, the for that course.
What was the course?
My lord, the course, my lord, the post diploma centralized entrance test, my lord, provides the diploma in radiologist, my lord, that is the higher. This
Where do I get the name of the? Oh, acha, acha.
DNB PD.
DNB PDC. It is very yes.
Now,
Then-
my lord, in the third paragraph, my lord, the grounds of
page 19.
Page 19, third paragraph. You have failed to submit additional qualification registration certificate issued by MMC/MCI or additional qualification registration certificate issued by the State Medical Council along with Indian Medical Register IMR certificate issued by the MMC in support of the recognition of your PG diploma qualification. Lord, I have uploaded all this.
Where are those? You have annexed.
Yes, yes, Malad. Now, in reply, after getting this, Malad, my email reply at page 20.
Yes.
Page 20, Malad, I have stated that this is a recognized course. Malad, until now, this is a recognized course. Malad, that cannot be uploaded by the medical council. Malad, they are not accepting this is a recognized course. Now, in this similar issue, Malad, some doctors from the Mumbai moved the writ petition before the Bombay High Court. Now, they are, I am that recognized, but kindly comes to I have annexed that order of that writ petition on page 25.
Yes, 25.
This is that issue. They are the point was raised. They did not complete their course from the recognized university. That the honorable courts held, that is that recognition is there. And the diploma in medical page 26. In point number C, the 4.1 has been quoted. The criteria for this 2 years diploma course in so far the appearing for the entrance examination, that was fulfilled by the writ petitioner of that writ
The
petition.
requirement was that the diploma had to be recognized.
Recognized.
You see, it's recognized.
This is
And
recognized.
it was never mentioned that a QRC or IMR certificate are required.
Yes, yes.
And for that recognition, you are relying on page 17
Page 17
and 18.
Page 18.
Very good.
And the page 16 also, the page 15 certificate is also there.
Now, my lord, on the basis of this.
You had to have a certificate in radiology.
Yes, my lord, the diploma in medical radiologist diagnosis. This is the course, my lord, mark sheet, my lord, at page 16. Now, my lord, my instruction, my lord, on the basis of this certificate and this qualification, some doctors are, my lord, that I have stated in my email reply also.
So you were not allowed to sit for the examination.
I was allowed, but my lord, they rejected my candidature on that ground.
Yes, what do you say?
Your
You are for the,
Your Lordship, in this matter, I am appearing on behalf of the respondent number 2 and 3.
what they? Medical Council?
Your Lordship, I am.
My lord, National Board of Examination, they are, my lord, they rejected. My lord, that is the answering respondent.
Yes, what,
Learned senior who is appearing in this matter is not well today, Your Lordship. So I
what
am
can be
therefore
done?
not this way.
After the matter is over, you can't say that. I've heard him. You move the matter. What is your stand? You are for the National Medical Council. Medical Commission. Yes, what is your instruction?
So I don't have any instruction.
After the matter is substantially heard, an adjournment is sought on behalf of respondent numbers 2 and 3. FUSAB has a last chance to the respondent numbers 2 and 3 to contest the matter, the same is adjourned till day after tomorrow when it will be placed fairly at the top of the list within the first 4 matters. চারটে ম্যাটারের মধ্যে রেখে টপের চারটের মধ্যে বোধহয় দুটো আছে আগে। Please ensure that on that date.
Yes, yes.
Yes, next.
41. I am for the petitioner.
We
I kindly come to page 13. That's my caste certificate issued in the year 2018.
Right.
By the my lord SDO Jhargram, Shodor Jhargram. My name is Mamoni Bagol at that point of time. Bagol is my surname. I was considered as within the caste of Mahar, MAHAR. The fourth line.
Yes, got it.
Which was recognized as scheduled caste. The next page, that's a caste certificate of 2017 issued in favor of another person by the self-same authority having Bogol. The next one also the same, that is of 2020.
Same surname, same caste.
Same surname.
Right.
Now, confusion arose, my lord, in 2023, page 20. The authority was of the view, page 20, my lord, kindly have a look, dated 16th of February 2023. The persons having surname of Ahir, Gop, Bogol, Gola, Ghosh, Khilari, paragraph number 1.
Yes.
Roman 1. Whether they belongs to Mahar or not, that becomes a question.
Achha.
Now, this SDO Jharkhand, my lord, he referred the issue before the higher authority. That's the Joint Commissioner of Reservation. With the recommendation, page 21, last paragraph. Kindly have a look. Last but one paragraph. Under such circumstances, I like to request you to kindly arrange for a field investigation. This is pending. This is pending. No intimation thereafter. Now, the petitioner has been elected as a Panchayat member and has been elected as a Pradhan thereafter. Now, I have been served with a notification, a no show cause notice at page, my lord, 18. 18 with a direction to deposit my certificate, and 19, that's a show cause why my caste certificate should not be cancelled. But I have no answer.
What happened in this matter, my lord?
Because February 2023, that talks about 818. The last paragraph, if your lordships kindly have a look, point number 7 at page 21.
818 people were issued certificates.
Yes, with these surnames. Now, whether that will exist or that would be, my lord, cancelled, let that decision be taken.
The proceedings
No, no, it's do you say that this inquiry has to be completed first?
Yes, yes.
Yes, what do you say?
My lord, 2 complaints have been received that, my lord, fraudulently he has got, my lord, caste certificate, and, my lord, SDO.
Do this field investigation and then.
Yes, my lord, SDO, my lord, directed the BDO to conduct an inquiry. Joint BDO conduct an inquiry.
They are talking about, my lord, inquiry against
If
me.
I am not allowed to speak, my lord.
You're not allowing
I'm
to
sorry.
speak.
Extremely sorry. My lord, the inquiry report was
Take a
submitted.
seat between the 2 chairs. Yes.
Inquiry report was submitted, my lord, and the inquiry report is clearly against him.
in terms of statutory.
That is an inquiry regarding his show cause, the show cause given to him.
Inquiry regarding his caste certificate.
Caste
identification,
certificate.
Yes.
But what about this? Unless
But
there
I
is
am
a
coming
field-
to that. I am coming to that. Thereafter, my lord, he has been, my lord, proceedings has been initiated in terms of the statutory rules. In terms of the statutory rules, my lord, he is required to deposit his, my lord, scheduled caste certificate and also to give a reply to the show cause notice. Twice show cause notices was given to him. Not on show cause notice and opportunity of hearing also awarded to him. Because in this writ petition, he has suppressed the 2 notices were given to him for attending a hearing.
After this show cause?
Yes. Milord, on 10th October, Milord, he has been asked to appear and prove his identification regarding his caste certificate. And he didn't appear. He didn't reply to the show cause notice. On 16th, Milord, today he speaks for his appearance and for attending the hearing with a show cause notice. Today she didn't turn up. And Milord, relating to the Milord, the last annexure which has been placed before your lordship, this is a clarification prayed from the Milord backward class secretary, Milord, whether the such demand from one representation made from Bakura, whether what can be done in respect of those community. That it has got nothing to do with this. But if your lordship kindly takes my instruction with it.
Show cause does not indicate it. So I mean, why? Because these things are there. You have not taken into consideration page 20 this document.
Yes, Milord, your lordship kindly takes Milord page 27 and 28. These 2 show cause, these 2 Milord notice.
Please give a copy to him also.
Yes.
Show cause note in 19 says this Mahar problem.
It only indicates that
Yes.
Page 19,
Milord, let him.
Page 19, the first line.
Milord, page
Where is
27.
So what will be the answer? I mean, you have asked findings which indicated that you actually belong to Bagal caste and not to Mahar caste.
Yes. Milord, he has to appear
the
before,
question
he
before
has to
February.
give reply. He has to appear before the Milord inquiry committee, Milord, before the SDO for hearing. Your lordship kindly takes page 27 of my report.
This is a notice of hearing, yes.
Notice of hearing. Therefore, hearing from bottom, second bottom.
Yes.
Yeah, hearing is now scheduled on such and such in the office chamber understand hearing, which is directly attend along with the evidence, in support of our caste identity, failing which will prove our ineligibility to opposing any certificate. This is issued in terms of the sub-rule 4A of the West Bengal such and such act, Milord. And
Yes, why don't you participate there and take
next
also
page 28.
I have challenged that show cause notice before lordship, the first show cause notice. They said,
But he has to
why should
appear.
I-
He has to appear.
they said,
Why should you interfere at the show cause?
they said Mahar and Bogol. I say,
He has to prove.
I say 18% were supplied with this
Take these
certificate.
points in the hearing.
Yes.
Kindly allow me, Malord. Kindly.
I think that
Grant
today
that
is the
liberty,
next
it's a
for hearing.
actual thing.
Yes, well, kindly grant that liberty, but one thing I must indicate, my lord, till now, this page 20, that has not been disposed of by the authority. And it relates to my
He has
area.
to appear before the hearing.
It's to my area by the self-same SDO. It nobody other.
No, there is one other aspect also. Suppose 818 wrong certificates were given.
Then
That
that
does
is-
not justify
No,
that.
no, then that is to be, my lord, rejected, cancel. I have no, I'm one of them.
I'll direct them to, at the hearing, I'll direct them to consider this also.
Yes, ma'am.
And you will be at liberty to take other
Yes, ma'am.
points. Learned counsel for the petitioner contends that the petitioner was issued a caste certificate, a scheduled caste certificate, push-up, by placing reliance on several similar certificates annexed to the writ petition, comma. It is argued that the surname of the petitioner is Bagal, BAGAL, and the caste under which the petitioner falls is Mahar, MAHAR, push-up. Several such people were issued similar certificates, push-up. Learned counsel also places reliance on a communication dated February 16, 2023, comma, when a similar question arose, comma, where the subdivisional officer, comma, Jhargram Sodor wrote to the Joint Commissioner for Reservation and ex officio Joint Secretary, comma, BCW Department asking for a field investigation of the community of Jhargram Sodor subdivision by CRI personnel so that it may be clarified and ascertained whether these people within bracket certificate holders as well as other members of the community bracket close are actually Mahar by caste or not. Next para, the surname Bagal was also included in the said communication. It is argued that before such field inquiry or field investigation being done, comma, a show cause notice was issued to the petitioner directing the petitioner to submit her caste certificate and to participate in hearing. Full stop, next para. Learned counsel argues that unless the field investigation is concluded, comma, the said show cause notice is ought to be set aside. Full stop, next para. Learned counsel for the respondent authorities submits that several notices of hearing have been given subsequently to the petitioner.
Field inquiry has already been made by the joint video.
It is further argued that a field
On the basis of 2 complaints.
a field inquiry has already been made on the basis of 2 complaints. Full stop, next para. It is contended that the petitioner is seeking to avoid the hearing. Full stop,
Statutory requirement
next
is
para.
not to, my lord.
Learned upon hearing learned counsel for the parties, comma, it transpires that there is a dispute as to whether the field investigation, as pointed out by learned counsel for the petitioner, has actually been conducted by the respondent authorities. Full stop, be that as it may, comma, all the issues raised by the petitioner in the present writ petition can also be raised by the petitioner before the appropriate authorities in the hearing for which the petitioner has already been notified by the authorities. Full stop, next para. It would not be appropriate for this court to usurp the jurisdiction of the said authority under this statute. Full stop, next para. Accordingly, WPA 20975 of 2023 is disposed of by directing the respondent authorities to give a further date of hearing and give a prior notice thereof to the petitioner for the purpose of ascertaining whether the caste certificate of the petitioner will be cancelled or not. Full stop, next para. It is made clear that prior to such hearing being given to the petitioner, comma, the respondent authorities shall furnish copies of all documents, comma, including inquiry report, stroke, field investigation report, comma, if any, comma, to the petitioner to enable the petitioner to properly contest the said proceeding. Full stop, next para. Upon such copies being furnished and hearing being given, comma, the respondent authorities shall decide on such issue in accordance with law without being prejudiced in any manner by any of the findings made herein. Full stop. It is expected that such exercise shall be concluded at the earliest, comma, preferably within the month of December 2023.
My lord, one more thing, my lord, he would, my lord, respond to the show cause notice, my lord. He would respond.
No, he's bound by this order. Full stop. No arrest to cause certain certificates, but he will have to give all copies of the reports to them,
Yes,
so that he can contest properly.
lordship.
Affidavit of service be kept on it. Attract a line at
42.
42, my lord, I beg to appear for the petitioner.
For the state, my lord.
My lord, I have
Led by
served upon
Mr.
the respondents. My lord, this is a good service. My lord.
Yes.
My lord, in short, the matter is that there are 2 companies. One is MS Intelligent Solution and another is MS SM Enterprises. Now, according to the respondent bank, the prayer before your lordship or prayer of the petitioner before your lordship of defreezing the 2 bank accounts, which belongs to SM Enterprise. Now, my lord, what is the relation between these 2 companies? My lord, petitioner, who is the guarantor of Intelligent Solution, is also a proprietor of SM Enterprises. Now, my lord,
you are proprietor of both.
No, I am the proprietor of only SM Enterprises.
And
there, my lord, my mother is the proprietor. Now, my lord, what has happened? The mother, being a proprietor of Intelligent Solution, applied for loan and subsequently availed the cash credit facility. Now, father was the guarantor of that loan account. Subsequently, after demise of my father in the year 2020, my lord, I, being a only child, was inducted as a guarantor of that cash credit facility. Now, my lord, subsequently, what has happened? To the tune of rupee 19 lakhs has been taken out from that account and thereafter transferred to the account of the proprietor. Now, my lord, the bank
regarding intelligence.
That is Intelligent Solution.
You proved your intelligence.
No, my lord, whatever be the case, my lord, my submission before your lordship is that thereafter, my lord,
your children are not guarantors in any of the.
No, only one child, my lord, being a petitioner.
Your children? The next generation is
No,
not yet, yes.
Thereafter, my lord, what has happened? The bank authority, in order to secure to get back that 19 lakhs, freezing the bank account of the other companies, where I am the proprietor of that company.
So. It is not a company, it's a sole proprietorship.
Yes, my lord, but
Rightly so.
my lord, how can that be? My lord, I was the guarantor of that intelligent solution. Let them do whatever they want with respect of that, because they have proceeded under section 13.
You are guaranteed your liability is coextensive with the borrower.
My lord, in respect of that,
your liability
solution.
Yes.
But the bank account which has been frozen, my lord, that is in respect of SM Enterprises.
That is also your property.
My lord,
Sole proprietorship, there is no difference between sole proprietorship and you. It's not a separate
my lord, kindly come to page 69. My lord, 73. The letter which has been issued by the bank. Yes. My lord, third paragraph. Please be informed that from the said account of MS Intelligent Solution, where mother is the proprietor and I was the guarantor of that credit facility which was available in respect of that company, wherein you are a guarantor, it has been found diversion of public money to own account of proprietor, that is so and so. Money is not even been transferred in my account. That is in my mother's account. Now, my lord, thereafter, which is an offense, and also another current account maintaining with another bank account without permission and NOC. My lord, I am governed by their notification, where it has been stated that where the credit facility is up to 5 CR, less than 5 CR, I don't want to obtain any permission from them. If it is above 5 CR, then I have to. I have annexed that notification as well. Now, my lord, that despite various letter and notice served to you also, you haven't returned back the said amount of 19 lakhs. Now, my lord, that fund was diverged from the intelligent solution. Now, whatever they want to do, my lord, they can very well do with the intelligent solution. But where I am a sole proprietor, where no nexus between these two firms, they are, my lord, they are freeze my account, where I would not even paying my statutory liabilities towards PF of my employees. They have proceeded against that company by declaring NPA, by declaring the account is non-performing asset. Then 13.2. My lord, one more thing, my lord, the bank how surreptitiously acted, my lord. Kindly see the notice date, my lord, in the top, 14/7/2023. Now, my lord, kindly take page 77. The notice was posted on 1st August, and I received it on 2nd August. 77, my lord, kindly see. And each and every notice where they have mentioned page 77, my lord.
Yes.
My lord, kindly see the next date when the item has been booked.
It was posted from Ultadanga, you received in Belaghatta.
Yes, my lord. However, the
Might very well
notice
have been
date
given
is,
by hand.
my lord, the notice date is showing 14th September, 14th July.
Right.
They have waited for 15 days to posted the same. And my lord, each and every letter where they are claiming, my lord, the account of intelligent solution was
But the guarantor of intelligence, sole proprietorship is not a distinct entity from the proprietor.
My lord, even for, my lord, subject to correction.
Proprietorship is you.
So, no, my lord, I have annexed that documents where mother was the proprietor of that.
Your sole proprietorship and you are not different entities.
Yes, in respect of, my lord, SM Enterprise.
SM Enterprise.
Yes, they have.
You are the guarantor. Your liability is coextensive with your mother regarding the other.
How can that be, my lord? They have freezed my bank account in SM Enterprise.
Guarantor's assets.
My lord, even if I, my lord, subject to
Ask Mr.
correction.
Kormakar, he will agree. He's agreeing already because his matter is there, which has nothing in it.
My lord,
He's agreeing.
My lord, kindly consider one thing, my lord, subject to correction, my lord. The entire allegation with respect to intelligent solution, even if they want to proceed,
understood.
my lord, they can very well proceed with that. Over there, I was guarantor. They have served notice
But
under
there you
section
are
30.
guarantor. Therefore,
Yes.
and this is SM is your asset. So guarantor's assets are also liable to be frozen. Why not?
My lord, that is, my lord, they are bound to get back that that money or
You
whatever.
have to give back them, give back the money.
My
get
lord,
it
that is in respect of, my lord.
No,
My
no.
lord, kindly consider, my lord, that is in respect of intelligent solution. But how far, my lord, the SM Enterprise would be involved in this case? Then, my lord, whatever the notice they have issued in respect of 13.2 of SARFAESI Act, that was issued to the in respect of, my lord, intelligent solution. Now, my lord, only because I am a child of my mother proprietorship.
And not a suckling baby, child.
My lord, I am child, sole child, my lord. After, my lord, demise of my father, I was inducted as a guarantor.
Child
My lord,
of your
I have
mother,
liability, my
mature
lord.
for the
But,
bank.
my lord, if they frozen my bank account in order to recover that amount, my lord, then how I am going to
One
pay?
of the very few cases where the bank has acted correctly.
My lord, kindly consider one thing, my
Which
lord.
bank?
My lord, Bank of Baroda. My lord, kindly consider, my
No
lord,
interference.
even if the 19 lakhs I have to deposit, my lord, where from my bank accounts in respect of different farm, where different
You're repeating,
proprietors.
I've heard you, but not convinced.
My lord, kindly consider, my lord, that.
Considered, fully considered, only after consideration.
Left.
Learned counsel for the petitioner contends that the petitioner is the sole proprietorship. Sorry, the petitioner is the sole proprietor of one Messrs. SM Enterprise. Full stop. Next para. The petitioner was also named as a guarantor in the cash credit account of one Messrs. Intelligent Solution, which is the sole proprietorship of the petitioner's mother. Full stop. Next para. Due to an alleged default on the part of the petitioner's mother with regard to Messrs. Intelligent Solution by purported diversification of public money, the petitioner's account has also been frozen by the respondent bank. Full stop. It is argued that the petitioner ' sole proprietorship firm Messrs. SM Enterprise has no connection whatsoever with the said cash credit account of Messrs. Intelligent, and as such, the notice given for freezing the petitioner's bank account is required to be set aside. Full stop. Heard learned counsel for the parties. Full stop. Next para. In law, there is no distinction between a sole proprietorship concern and the sole proprietor thereof, with regard to juristic entities. Full stop. The sole proprietorship concern of the petitioner, namely Messrs. SM Enterprise and its cash credit account, are part of the assets of the petitioner himself. Full stop. Since the petitioner is a guarantor with regard to the cash credit account of Messrs. Intelligent Solution, which is the allegedly defaulting proprietorship firm, the petitioner's liability with the borrower there is coextensive. Full stop. Hence, the petitioner's assets and accounts can very well be the subject matter of action by the bank for recovery of amount from Messrs. Intelligent Solution, where the petitioner is a guarantor. Full stop. Thus, I do not find any illegality or irregularity in the petitioner's in the account of Messrs. SM Enterprise, the sole proprietorship of the petitioner being frozen by the bank. Full stop. Hence, there is no scope of interference. Accordingly, WPA 21059 of 2023 is dismissed on contest without any orders to cost. Urgent certified copies. Affidavit of service filed today be kept on. Sorry, Mr. Poti. Well argued, but bad matter. Yes. What? Oh, yeah. Audience. Sure.
My lord, may I have the liberty to mention a matter on the original side?
Yes.
My lord, there is this matter, item number 38, which has been, my lord, in the list, my lord, shown as top for tomorrow. My lord, tomorrow I will be, my lord, I am not coming to court for, my lord, attending another matter, my lord. Instead of tomorrow, I am the petitioner. I have not, my lord, been favored with any interim order. It is after affidavits.
Which for the other
The
side?
respondent had mentioned the matter. I don't know, my lord, somehow the advocate on record was not there when he mentioned upon notice. It can be heard, my lord, immediately after vacation. This is after affidavits.
Keep it on Wednesday also, my lord, if you are there.
No, I am there on Wednesday, but since it's a hearing matter, might consume, my lord, take some time. I was praying, my lord, I
They
am
are
the
not
petitioner.
enjoying any interim order.
No.
So what's the
No,
difficulty?
my lord, they are not enjoying any interim order, but my lord, they are indebted of 13 crore rupees of the bank, my lord. Just
My lord,
because of
they-
this writ, my lord, they are not paying that to the bank without any.
My lord, the issue is very simple in this.
15 minutes.
If there is no interim order there, then what is the difficulty?
My lord,
Reopening the lordship may fix it. I'll do it.
my lord, I have advised my client not to take any steps since the writ is.
It has already been fixed at the top, so let it.
My lord, then, my lord, instead of tomorrow, only Wednesday, my lord.
Wait.
Kindly.
18th করে দাও।
May I have your lordship's kind
18th.
indulgence to
18th, great.
mention on appellate side matter?
Appellate side, no.
Your Lordship, it was mentioned thrice last week. Your Lordship had kept it in the upgraded list, but it is in item number 73. My Lord, kindly fixes it tomorrow in the.
Not like
top of
this.
the
No,
list.
no,
Your
no.
Lordship, the bankers are already sending the valuer.
No, at this point of time, no. You should have mentioned in the morning then.
Lordship, I was waiting for the list to call out as it is already.
Do it
listed.
tomorrow. Mention it tomorrow in the morning.
May I have
my lord's kind leave to mention a matter?
She's first.
My lord.
Yes.
My Lord, my item number is 45, my Lord.
Which list? Original side.
Appellate side list, my Lord.
Appellate side don't mention now. Mention
No,
tomorrow.
my Lord, we are waiting for the call of the list, my Lord.
That
Just
is the duty of an
43.
advocate. I waited for long times when I was an
Yes,
advocate.
my Lord.
My matters were almost never called on. So that's a practice you have to build.
Yes, my Lord, I totally agree.
Yes.
May I have my lord's kind leave to mention an original side matter? My lord, it is listed as item 23 today. But there's an urgency in the matter. My lord, the difficulty is the sale may be confirmed, my lord, any day. We do not know whether the sale has happened. My lord, the petitioners before your lordship, my lord, are the owners of a property. And my lord,
Tomorrow
yes,
at the top.
tomorrow at the time, very deeply.
Item 38 goes to day
But
after
item
tomorrow.
23.
So item 38 has gone the day after tomorrow.
My lord.
It was mentioned. So your
Very grateful,
your
my lord.
matter enters that.
Very
slot.
deeply obliged. my lord.
You may inform your other side. Who is
We
there?
will. We
So
will.
that you are appearing for the other side.
My lord, we will inform the other side. my lord. It's my lord, the Union Bank. We'll give them
No,
notice.
please. Without notice, you are mentioning. But
Without notice, my lord.
if they object, then I won't take up tomorrow.
Indeed, my
I
lord.
mean, it will appear tomorrow at the top.
Indeed, my lord. We'll do.
Yes,
Yes,
please.
deeply obliged.
May I mention item number 17 in today's list, my lord, daily list, my lord. This is my urgencies, my lord. I have not taken any loan, but I've been served with the loan recall notice and this is mistaken identity by the bank, my lord. And in subsequently, I have been declared as willful defaulter for the loan which I have never ever taken, my lord.
What
So
is
they,
the urgency?
so they were going to take my property. They have sent me that they initiated against me the
You have
proceeding.
come up against a willful defaulter declaration.
Yes, willful defaulter, and that for a loan which I have never taken, mistaken identity of the.
That is not such an urgent matter.
No, but this is my very urgent. Your lordship, actually, this in respect of my loan, I have not
Give a
committed.
notice mentioned tomorrow. I'll fix it to day after tomorrow then at the top.
But
Give a notice mention tomorrow that you will mention it. I give a notice today that you will mention tomorrow.
well, I will give the notice to opposite party by email, my lord.
Receiver mail, but he has to be present tomorrow.
My lord.
In both of your presence, I'll fix the matter day after tomorrow or the day after that at the top.
My lord, I'm grateful to your lordship.
Call this.
Ordinance matter. For judgment, item number 1.
The four writ petitions are allowed, directing the exponent therein to disburse the sums respectively due under the said two schemes in question to the petitioners in each of the writ petitions at the earliest, positively within December 31st. Made clear, observations made herein are restricted to the entitlement of the petitioners to the subsidies under the schemes in question and shall not create any special legal right, equity or immunity in favor of the petitioners, which the petitioners do not otherwise have in law. This is because of the other pending proceedings.
Very grateful.
There were two schemes, 4 matters.
Two schemes for matter. Lord, in one matter there were two schemes. The other matter there was one scheme.
Yes,
But
yes.
grateful.
Court application, item number 5.
Right.
Vishwambar Sharon versus Punjab National Bank.
Yes, Vishwambar Sharan.
My Lord, I'm-
Lord, may it please your lordship, Lord, I'm very sorry and I apologize for not being able to come before your lordship. I'm having a little bit of a medical problem, Lord.
No, Mr. Sen, after the latest circular of the Supreme Court, you need not apologize. If you'd come physically, then you should apologize.
Lord,
No.
Lord, for your lordship's convenience, Lord, so that Lord, I do not repeat.
It's all right,
Lord,
absolutely.
Lord,
Yes.
Lord, I have prepared a short note. I just indicate the broad points from the short note, Lord, so that I don't take up unnecessary amount of your lordship's time. Lord, if my junior can hand over the note to your lordship, it seems unnecessarily long, Lord, but I'll just indicate to your lordship the broader points, Lord. Most of it I've already covered.
Right.
Lordship remembers, Lord, the challenge to the challenge in the writ petition is limited to a complaint of 18th of June 2021, which we say is an information. Lord, I've shown your lordship section 154 of the Criminal Procedure Code, which says that on an information given in writing or otherwise, the investigating officer, if he is of the view that a cognizable offense is made out, he is bound to register an FIR. Now, Lord, the challenge is only to the complaint and not to the FIR. Your lordship remembers CBI has not been made a party.
Right.
Now, Lord, there's one aspect of the matter which I had forgotten to Lord submit on the previous occasion. First is, Lord, if your lordship would be pleased to, if my junior can hand over a code of criminal procedure, there's the section 154 in my respectful submission is very cautiously drafted.
Yes.
And I would beseech your lordship to compare section 154 with section 41 of the code, section 154, your lordship has already seen, uses the expression information only. It does not qualify the word information. Now, my lord, if your lordship is pleased to take section 41, and my lord, if your lordship kindly take section 41, subsection 1B, B for Bombay, my lord.
Yes, please. Yes.
Your lordship will find that the complaint, a similar sort of complaint, but when arrest is intended to be made, lordship sees the word complaint has been qualified by reasonable complaint.
Yes.
Or thereafter, your lordship will find credible information.
Right.
Likewise, my lord, in subsection BA, the expression uses credible information.
Right.
Lord, please also see subsection G.
Yes.
Of the same section, it uses the words reasonable complaint.
Right.
In section 154, it is only information.
Hmm.
Now, Lord, the purpose of Lord making this submission for your lordship's consideration is that a citizen is duty bound as soon as he has information, whether it be reasonable or credible or something on which reliance can be placed, to pass it on to the investigating agency. This is a statutory duty. Your lordship will find that in section 39 of the code. Lord, please for a moment see section 39.
Yes. 39. Right.
Now, Lord, section 39, your lordship will find, gives certain sections under which, my lord, it is a statutory duty to give the information. Every person aware of the commission of or of the intention of any other person to commit any offense punishable under any of the following sections of the Indian Penal Code shall, in the absence of any reasonable excuse, the burden of proving which excuse shall lie upon the person so aware, forthwith give information to the nearest magistrate or police officer of such commission of its intention. Now, Lord, the sections here which are enumerated in section 39 include section 120 capital B and section 409.
Yes.
Your lordship will find 120B and 409 are those sections which are specifically enumerated.
120B is not there, bro.
It's part of Roman 1. 121. I'm sorry, 120B is not there. Lord, 409 is there at Roman 8.
Right, right. 409.
Now, Lord, in the judgment, Lord, which I had intended to show your lordship, but I didn't have the time, which is Bhajan Lal. Several aspects are taken care of, including the fact that if in the information there are cognizable offenses and non-cognizable offenses made out, then, my lord, the police officer, in this case the CBI, is to treat the entire compendium of offenses as cognizable and proceed accordingly. Now, my lord, so far as the statutory duty under section 39, even in respect of section 409 is concerned, Lord, this has been recognized in the judgment of Lalita Kumari. I'll indicate to your lordship the paragraph. Lord, if your lordship takes paragraph, my note, Lord, I just Lord, proceed along with the note so that it becomes convenient for your lordship, Lord.
It is absolutely.
Lord, in paragraph 3, I've indicated section 41. And Lord, my respectful submission that it's not required to be reasonable or credible, but mere information. Paragraph 4, my lord, I've mentioned about section 39, and I've mentioned Lalita Kumari. Of the paragraphs that I've mentioned there, paragraph 56 of the 4 paragraphs I've mentioned, paragraph 56 is the paragraph which deals with the statutory duty cast on the citizen.
Right.
Now this statutory duty is also reiterated in another judgment which I've mentioned in paragraph 5, which is State of Gujarat versus Anirudh Singh, which really reiterates the same thing, but I've just given the citation in paragraph 5 for your lordship's consideration. 1997, volume 6, Supreme Court cases 514.
Yes.
Now, Lord, if I may take your lordship to Lalita Kumari for a moment, so that, Lord, I can complete this aspect of the submission. And Lord, if your lordship is pleased to come to paragraph 56 of Lalita Kumari, I think my junior will have handed over a copy.
He has. 56, yes.
56. Lord, it starts with the words, in view of the above.
Right.
In view of the above, we are satisfied that section 154(1) of the code does not have any ambiguity in this regard and is in clear terms. it is relevant to mention that section 39 of the code casts a statutory duty on every person to inform about commission of certain offences, which include offences covered by section such and such. So this statutory duty is what the Punjab National Bank has performed. No more and no less. And after performance of its statutory duties, its role has ceased in the matter. It is now no more than a de facto complainant. Now, on the basis of the information, the CBI has arrived at its own conclusion that cognizable offences has made out. It has registered an FIR. The fact that the FIR is a part of the writ petition shows that the accused is aware of the lodging of the FIR or the registration of the FIR. Additional Superintendent of Police has been appointed as investigating officer. So the wheels of the criminal law have been set in motion. Now, insofar as this is concerned, in Lalita Kumari, your lordship will find, since I am on Lalita Kumari, I may just complete this aspect and go on to the other aspects. If your lordship sees, paragraph 99, I had made a submission on the previous occasion that the FIR is not really an encyclopedia, nor is the informant required to know all details or furnish all details. Your lordship will find that there are several judgments, but in this judgment in paragraph 99, in Lalita Kumari, this has been mentioned once more.
Right.
The extract is from Tapan Kumar Singh. If your lordship considers this portion, it is well settled that a first information report is not an encyclopedia which must disclose all facts and details relating to the offence reported. An informant may lodge a report about the commission of an offence, though he may not know the name of the victim or his assailant. He may not even know how the occurrence took place. A first informant need not necessarily be an eyewitness so as to be able to disclose in great details all aspects of the offence committed. What is of significance is that the information given must disclose commission of a cognizable offence, and the information so lodged must provide a basis for the police officer to suspect the commission of a cognizable offence. At this stage, it is enough if the police officer, on the basis of the information given, suspects the commission of a cognizable offence, and not that he must be convinced or satisfied that a cognizable offence has been committed. If he has reasons to suspect on the basis of information received that a cognizable offence may have been committed, he is bound to record the information and conduct an investigation. At this stage, it is not necessary for him to satisfy himself about the truthfulness of the information. It is only after complete investigation that he may be able to report on the truthfulness or otherwise of the information. Similarly, even if the information does not furnish all the details, he must find out those details in the course of investigation and collect all the necessary evidence. The information given disclosing the commission of a cognizable offence only sets in motion the investigating machinery with a view to collect all necessary evidence and thereafter to take action in accordance with law. The true test is whether the information furnished provides a reason to suspect the commission of an offence, which the police officer concerned is empowered under section 156 of the code to investigate. Now, then it continues what is that it has no option if it does. Now, this is in relation to the submission made by my learned friend that, see, I'm only challenging the information and not the registration of the FIR. Now, if the information only gives or discloses some aspects or certain ingredients of a cognizable offence, it may not lead to culpability. It may not by itself lead to the accused being held to be liable, but merely gives information which enables the investigating officer to set in motion the criminal offence so as to collect further evidence.
Mr. Shen, do you say that suppose in the present case, the complaint is withdrawn or set aside, I'll not go to that extent, withdrawn or set aside, whatever. The FIR still remains and the investigation has to proceed irrespective of the complaint not being there.
Yes,
so whatever happens to the complaint, that becomes irrelevant once an FIR is lodged and investigation is commenced.
Lord, in my respectful submission, it is only in the case of compoundable offences
exactly
the complaint can be withdrawn.
Right.
Now,
Yes, right. Very
here,
good.
in fact, I cannot withdraw it.
No, you cannot.
If a court sets aside the complaint without touching the FIR, the
You can
FIR
say-
record, the FIR is the basis for the criminal motion to be set in action. Now, my lord, insofar as Bhajan Lal is concerned, I would like to submit for your lordship's consideration that Bhajan Lal is important for three aspects of the matter. Lord, if your lordship has been kind enough to consider Bhajan Lal, the judgment of Bhajan Lal, Lord, just 2 or 3 paragraphs, if I may trouble your lordship with. The first is, Lord, the most important paragraphs, that's paragraphs 102 and 103, which are usually relied on by all of us. These lay down the tests. Lord, 102 is at page 378 of the report, Lord.
Right. Got it. Yes.
Now, Lord, in Bhajan Lal, it is not the information which was under challenge, but it was the criminal proceedings which had been set in motion that was under challenge. There also, Lord, if your lordship takes 102 and the tests in the subparagraphs, Lord, if I may place this for your lordship's consideration, where the allegations made in the first information report or the complaint, even if they are taken at face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused. Here, in my respectful submission, no argument has been made that take the complaint at its face value, accept it in its entirety. Even then, no cognizable offense is made out in the nature of Order 7, Rule 11. Whatever may have been the result of the other proceedings under other different statutes with result to one of the documents which have been considered, which is the transaction audit report or the forensic audit report. If your lordship takes the complaint which is annexed to the writ petition, it is not the argument, and your lordship will also find that taken at its face value and, my lord, accepted in its entirety, as it is, as it stands. Lord, this is not the, Lord, case made out, and this is not the case argued. Then, Lord, please take 2, where the allegations in the first information report and other materials, if any, accompanying the first information report, do not disclose a cognizable offense, justifying investigation by police officers. So we move on to the first information report and the materials accompanying the first information report. 3 is when uncontroverted allegations in the first information report and the evidence collected in support of the same do not disclose any offense. We've not yet come to the stages of 2 to 7 yet. 4 is where the allegations in the FIR do not constitute a cognizable offense. There is no challenge to the FIR here. 5 is where the allegations in the FIR or complaint are so absurd or inherently improbable, on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused. Now, this case has not been argued that it is so absurd or inherently improbable. Then, 6, where there is an express legal bar engrafted in any of the provisions of the code or the concerned act under which criminal proceeding is instituted, to the institution and continuance of the proceedings, and or where there is specific provision in the code or the concerned act providing efficacious redressal for the grievance of the aggrieved party. Look, this case is also not made out. Where criminal proceeding is manifestly attended with a mala fide, or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private or personal grudge. Now, this case is also not made out. So, not at best, perhaps, the case could have fallen within 1 or 5, 6, and 7, and in my respectful submission, none of these cases are made out. Now, please take 103 for a moment. We also give a note of caution to the effect that the power of quashing a criminal proceeding should be exercised very sparingly and with circumspection, and that too in the rarest of rare cases. And the court will not be justified in embarking upon an inquiry as to the reliability or genuineness or otherwise of the allegations made in the FIR or the complaint. Similarly, an inquiry or an embarking, your lordship being called upon to embark upon such an inquiry, as your lordship has been done in this case, Lord, is something which Lord, the Supreme Court has said is possibly Lord, not mandated. And the extraordinary or inherent powers do not confer an arbitrary jurisdiction of the court to act according to its whims or caprice. Now, Lord, why I mentioned Bhajanlal is usually cited in the criminal jurisdictions under section 482. But if you're when Lord trying to Lord invoke the court's jurisdiction under 482, but if your lordship has a look at 102, paragraph 102, and if your lordship sees Lord the first sentence itself, in paragraph 102,
26.
Yes, Lord. 226 or both are governed by these tests, 226 and 482. Lord, this is one aspect of the matter. The second aspect of the matter, Lord, is Lord paragraph 34, Lord, which I had mentioned for your lordship's consideration, that where there are more than one cognizable offences and non-cognizable offences intertwined together. Paragraph 34 at page 355.
Right.
In this connection, it may be noted that though a police officer cannot investigate a non-cognizable offence on his own, as in the case of cognizable offence, he can investigate a non-cognizable offence under the order of a magistrate having power, etc. Further, under the newly introduced subsection 4 to section 155, where a case relates to two offences of which at least one is cognizable, the case shall be deemed to be a cognizable case, notwithstanding that the other offences are non-cognizable, and therefore under such circumstances the police officer can investigate such offences with the same powers as he has while investigating a cognizable offence. So it was my statutory duty, the moment there are offences, including an offence under section 409, to report it to the police. I given the information to the police. Lord, it's not an encyclopedia. I've given what I knew on the basis of facts available with me. Now it is up to Lord, the CBI to Lord, now act and to complete the investigation or not complete the investigation. Lord, it is possible that the CBI may not complete the investigation at all and may not continue at all. Lord, this is also permissible. So my respectful, I just indicate to your lordship the paragraph where from where I say this. But my respectful submission is that today, merely by issuing the information or giving the information to the police, no legal right or no legally justifiable right, which is a condition precedent for invoking the writ jurisdiction, Lord, has been transgressed. If my learned friend stops at the information and does not extend the charge or the challenge in the writ petition to the FIR, which he cannot do because CBI is not impleaded, then Lord, no legally justifiable right has been infringed, which would enable Lord, your lordship's jurisdiction to be invoked. Lord, this is the second aspect, Lord, which I wanted to submit. Now, Lord, that it is entirely within the CBI, domain of the CBI, the moment I have, Lord, put the information in its quarters, and it may decide not to continue with the investigation at all. But for a moment, Lord, please have a look at Lalita Kumari once more. Lord, I'll just indicate a lordship one paragraph, paragraph 111 of Lalita Kumari. Lord, 111 is at page 58.
Yes.
Besides, the court gives power to the police to close a matter both before and after investigation. A police officer can foreclose an FIR before an investigation under section 157 of the code if it appears to him that there is no sufficient ground to investigate the same. The section itself states that the police officer can start investigation when he has reason to suspect the commission of an offence. Therefore, the requirement of launching an investigation under section 157 of the code are higher than the requirement under section 154 of the code. The police officer can also in a given case investigate the matter and then file a final report under section 173 of the code seeking closure of the matter. Therefore, the police is not liable to launch an investigation in any FIR which is mandatorily registered on receiving information. So, my lord, subject to, my lord, the first test of Bhajan Lal, that the complaint on the face of it, accepted in its entirety, does not make out a cognizable offense. Subject to that, Lord, there is no legally justifiable right in the writ petitioner to invoke the writ jurisdictions. To that extent, if the FIR is not challenged, and Lord, steps taken by CBI in respect of the FIR is not challenged, then the writ petition is premature. Now, Lord, I've covered Lord, till page 3 of my note. Lord, although my arguments seem to be traveling from one direction to the other, but I have more or less taken it in sequence till page 3. Lord, in paragraph 9 of my note in page 3, I've also pointed out what are the eventualities or situations may arise when a final report is filed. Because even then, the options are not closed, and the magistrate may close the matter, may accept the report, may disagree with the report, may direct further investigation. Lord, these various contingencies I've enumerated in paragraph 9. So, Lord, at any stage, even at stage of section 173, when the report is filed with the magistrate, there are various eventualities which may arise, and I've indicated at page 4 the judgment from which I've set out this portion. This is 2004 7 SCC page 768.
Yes.
And in paragraph 10, I've indicated that my submission for your lordship's consideration that no judicially enforceable right has been infringed. Now, Lord, I've also covered Bhajan Lal, which takes up to paragraph 13.
Yes.
Now, Lord, the next portion that I would like to take your lordship to are the reliefs which have been claimed. If your lordship is kind enough to take the prayers of the writ petition. Now, Lord, the prayers start at page 20.7.
Yes.
Your lordship will find the challenges are to the complaint of 18 June 2021 alone, initially, but they're couched in such a manner that decisions taken pursuant thereto are also being assailed. Now, decisions taken pursuant thereto are taken by CBI. CBI is not a party. So, these prayers, in the way they have been framed in each of the prayers right up to prayer D, are all relating to not only the complaint, but actions taken in pursuance of the complaint. The complaint has been worked out. There is nothing further that the complainant is required to do except give evidence if required as a de facto complainant, as and when he is called. But the challenge, it appears to have been made in a couched fashion or in a circuitous fashion, really to the action taken by CBI, which are the actions taken after the information has reached the CBI. Now, these reliefs perhaps today your lordship would not hear, or not, it is not open to the writ petitioner to seek these prayers. Lord, 2 interim orders have been sought from your lordship. That's prayers F and G. Lord, if your lordship please takes page 29.
Yes.
The first prayer F is restraining the respondents from giving effect or further effect to the complaint of 18th of June. Now, Lord, the respondent is Punjab National Bank. It has submitted the FIR. The complaint or the information itself is that the only purpose of the complaint is to provide information to the police in terms of section 154. It has been acted on, it has been worked out. There is nothing further for Punjab National Bank to do, or there is nothing that can be restrained insofar as Punjab National Bank is concerned. So, Lord, prayer F today is really an infructuous prayer. Now, Lord, take prayer G, Lord, for a moment kindly at page 30. The first portion of prayer G is really to direct Punjab National Bank to communicate the orders of NCLT, the order of NCLAT, the order of your lordship in the lookout circular matter, and the order of the Committee for Identification of Willful Defaulters to the CBI.
Yes.
Now, Lord, this prayer, Lord, is not a prayer which my learned friend can or should have sought from your lordship, because once investigation is initiated by CBI, this Criminal Procedure Code has sufficient provisions under which statements can be recorded, documents can be produced before the investigating officers. It is open to the accused, open to the witness. It is open to the de facto complainant, to all concerned, to furnish particulars and statements to the CBI. My learned friends' clients can very well do the same. Court's mandate for that is not required. And in any event, Lord, it is up to the CBI to seek documents or the persons concerned to make over documents. There is no requirement for the writ court to be invoked for this purpose, for the purpose of making over these orders. Lord, please take the next portion. After your lordship comes to Committee for Identification of Willful Default to the Central Bureau of Investigation, thereafter, Lord,
Yes.
requesting them not to take any step or further steps based on the purported complaint of 18 June 2021. This is really a clever couching of an order of injunction against a person who is not a party to the proceeding. So it is invoking your lordship's jurisdiction and requesting your lordship to call upon CBI not to take further action. Lord, in the absence of CBI, without hearing them, and in the way the writ petition has been framed, these interim orders today, Lord, or at all, Lord, in my respectful submission, cannot be passed.
Right.
Lord, in my respectful submission, based on the frame of the writ petition, Lord, perhaps no relief can be granted by your lordship. Lord, I've taken your lordship in this fashion, covering till page 6, where your lordship will find, Lord, in paragraph 17, I've dealt with the interim orders and why they ought not to be passed. Lord, paragraph 16, that it is not open to the petitioners to frame the reliefs in the manner that they have done. Now, Lord, the next portion that I've dealt with in the note are with regard to the 4 sets of proceedings, which I had made detailed submissions on the previous day. The first set of proceedings are before the NCLT, which I've covered in page 7 of my note, Lord, which I've dealt on the previous occasion. At page 8, Lord, I've dealt with the proceedings under the RBI Master Circular.
No, I think it's page 9 respectively, not 7.
Lord, oh, Lord, my side, the setting of my note is possibly different. Lord, if your lordship kindly takes paragraph 21.
Yes, 9 and 10, pages 9 and 10, you're right.
Paragraph 21A is, Lord, with regard to the NCLT proceedings. B is with regard to the RBI Master Circular with regard to the willful defaulters. C is with regard to the Delhi High Court proceedings. And D is with regard to, Lord, your lordship's judgment on the Lookout Circular.
Yes.
Lord, paragraph 22, Lord, are my respectful submissions in respect of these matters. Lord, if I may just place this paragraph for your lordship's consideration, Lord, to obviate, Lord, the time which I'm taking from your lordship. A, in my respectful submission, A, none of the orders passed in the aforesaid proceedings hold, and no conclusion was arrived at in any of the aforesaid proceedings that no ingredient exists and that no offences are made out against the accused within the meaning of sections 120B, 409, 420, and 477. This was not, Lord, the ambit of the inquiry in any of the earlier proceedings. So, Lord, this aspect, whether ingredients under these sections of CRPC are made out or not, was never considered. B is, Lord, really a fallout of A, that the scope of the diverse proceedings, which I have enumerated in paragraph 22, is completely different from the scope of inquiry before the criminal court, Lord, in terms of the investigation to be carried out. C, Lord, is a submission which I had already made earlier, that whatever may be the orders passed by the different fora, the substratum, that is, Lord, the forensic audit report, has not been set aside or quashed or invalidated. That still remains. Lord, D, my respectful submission is, Lord, ignore the forensic audit report. Even that apart, only, Lord, please take the complaint at its face value, and Lord, please accept it as it stands, as a standalone document, accepting it to be true and correct. Cognizable offences would appear to have been made out. Nothing further thereafter is required. Lord, in E, Lord, I've said that steps, in fact, have already been taken. This is something I mentioned in the passing, but I had not indicated, Lord, in details. Lord, on the basis of a special investigation conducted by Punjab National Bank and its report of 26th of May 2017, this, your lordship, will find in page 9 of 10 of the complaint. I've indicated the page number of the writ petition. Lord, the incumbent in charge of the Punjab National Bank has already been charge sheeted for a major penalty. Lord, on the basis of this very, Lord, these facts set out in the complaint, the charge sheet has already been issued, Lord, and according to the bank, this is, Lord, one of the ingredients which show that there is, Lord, criminal breach of trust, fraud, misappropriation in connivance with public officials. Now, Lord, finally, and my last point, Lord, is that my learned friend has been harping on the forensic audit report. But the forensic audit report is not the only document which shall be taken into consideration or will be taken or ought to be taken into consideration by the investigating agency, unlike in the other proceedings, where that was the only document relied upon by the parties. Here, the statute mandates that the CBI, during its investigation, must conduct its own investigation, collect further evidence, and make out its own case as to whether offense has been made out or not. It may be that today the CBI has been indicated one particular document in the complaint, that is the transaction audit report or the FAR. In the course of its investigation, 10 further documents may come to light. There may surface various other pieces of evidence which may go to substantiate or demolish the complaint. Similar, the mere fact that the transaction audit report was considered by different other fora and has been held to be insufficient and inadequate to alone charge the accused with culpability is not, in my respectful submission, enough to say that by that reason alone criminal proceedings will also fail. Because at this stage of the criminal proceedings, the intention is not to charge him with liability, but to only indicate that there are matters and facts which lead to the existence of cognizable offenses. Lord, this is, Lord, what I've indicated in my note for your Lordship's consideration. One last aspect of the matter, which was, Lord, argued by my learned friend himself, that, Lord, in the master circular itself, there is a provision under which parallel criminal proceedings can also be conducted. Your Lordship has seen and perhaps noted that page 48 of the writ petition. So, Lord, there is a recognition in the master circular itself that the proceedings for, Lord, identification of a willful defaulter does not mean that other parallel proceedings or simultaneous proceedings cannot be conducted. And here, Lord, at page 48, under the heading criminal action by banks and financial institutions, Lord, in fact, the banks have been advised to seriously and promptly consider initiating criminal action. Lord, page 48 of, Lord, your Lordship's brief, Lord. If your Lordship kindly takes the fourth line, banks and financial institutions have been advised to seriously and promptly consider initiating criminal actions against willful defaulters or wrong certification by borrowers, whether considered necessary based on facts and circumstances of each case. So that discretion has been conferred on the banks.
But that is probably, that presupposes one has to be a willful defaulter.
Absolutely, right? Absolutely. Your Lordship is absolutely correct. What I'm submitting is the mere fact that one has been held to be a willful defaulter. Even then, that is not the only, Lord, proceedings which the bank would have done. In this case, we have not classified him as a willful defaulter. But there is no bar in initiating proceedings under different statutes based on the same set of facts. Lord, in conclusion, Lord, Lordship remembers when I had started my submissions, I had indicated a judgment where different sets of proceedings had been commenced against a particular gentleman. In fact, the judgment, Lord, I have not indicated in my note, is the judgment of Molay Kumar Ganguly versus Dr. Sukumar Mukherjee. This is reported in 2009, volume 9, Supreme Court cases, page 221. 2009, volume 9, SCC, page 221. Here your Lordship will find in paragraph 4 of the judgment that criminal complaint was lodged by Dr. Kunal Shah. In paragraph 5, your Lordship will find that proceedings were launched under the National Consumer Disputes Redressal Commission, under the Consumer Disputes Act. And your Lordship will find in paragraph 6 that proceedings were instituted before the West Bengal Medical Council also. Same set of facts, 3 statutes, three fora were available to the complainant, each of which conducted its own independent inquiry based upon the scope permitted by the statute. The matters all culminated before the Honorable Supreme Court. Supreme Court ultimately held that no, he is not liable under the Criminal Procedure Code, although the Supreme Court found the doctors to be medically negligent, but not to the extent of having mens rea.
That is always there, Mr. Shani. You are right.
Yes. And so far as consumer forum proceedings were concerned, they were found to be guilty, and the consumer forum was directed, National Commission was directed to assess the compensation, and that was assessed thereafter. So no, there is never any bar to initiation of proceedings under different statutes in the same set of facts, gives rise to different causes of action under different statutes. In my respectful submission, this particular writ petition perhaps has no legs to stand on. My respectful submission is for your lordship to kindly dismiss the writ petition. But I am very grateful to your lordship.
Thank you. Yes. Yes, sure. The reply.
Hearing my learned friend, my lord, I was confused, my lord, whether I am hearing a public prosecutor oppose a section 482.
It's interesting, Mr. Shane arguing, this court listening, you are countering on Criminal Procedure Code. Interesting.
My lord, first is, my lord, so in essence, if I have been able to appreciate my learned friend's submission, it is like this. The bank has made a complaint. Thereafter, the bank has no duty. It is for the investigating authority to find out whether the complaint is correct or not, even after 2.5 years, even after all the facts are non-existent. Bank has, in its discharge of its obligations, statutory obligations, done its job. Bank's responsibility is over. And the FIR can exist independently. I am not joining issue FIR can exist independently. In my opening argument, Lordship asked me a query. I said, if this is quashed, we will deal with the FIR. Whether the FIR will have legs to stand or not, that will be a question. We will deal with that. Now, the first is the Lalita Kumari principle, which was argued. Entire argument of my learned friend is based on the Lalita Kumari principle. The Lalita Kumari principle is the simple reason why all the more it should be struck down. Kindly takes Lalita Kumari. What is the Lalita Kumari principle? That any information you receive, FIR has to be lodged at the earliest. And here we are talking of a complaint of 21 and an FIR of 23. And in these 2 years, the 3 facts constituting the cause of action is non-existent. The bank goes and report. I shall show that. First, let me deal with the Lalita Kumari principle. My learned friend relied upon paragraph 56 and 99. Kindly first see, my lord, paragraph 93. I just read on from paragraph 93. I'll come back to paragraph 56. And I'll also show, my lord, this subterfuge of, my lord, incorporating that I have taken steps against my own employee. But, my lord, no name is disclosed to the CBI. And kindly bear in mind, this is not being made simultaneously to the local police station. This is being filed to the CBI because of the RBI circular on fraud, because it is over 30 million. What is the significance? I'll come. So you are lodging the complaint pursuant to a circular, but the corresponding obligation which both the circulars provide, that you have to act in a transparent manner and let it not, the provisions be abused, that, my lord, I am shunning my duty. I'll come to that. My lord, Lalita Kumari principle, my lord, kindly come to para 93. In fact, my lord, Lalita Kumari is saying in commercial offense, before registering a FIR, you have to make a preliminary inquiry. And my lord, if these information would have been furnished to CBI, in preliminary inquiry only this would have been thrown out. FIR wouldn't have seen the light of the day. My lord, kindly sees, my lord, para 93 starts just before 93, significance and compelling reasons for registration of FIR at the earliest. This is how Lalita Kumari principle starts, at the earliest. What we are discussing here is, my lord, absolutely in departure from Lalita Kumari principle. After 2.5 years, I have shown your lordship the reason given by CBI. And my lord, 93 is saying, the object sought to be achieved by registering the earliest information as FIR is inter alia twofold. One, that the criminal process is set to motion and is well documented from the very start. And second, that earliest information received in relation to commission of cognizable offense is recorded so that there cannot be any embellishment later. And here, my lord, the FIR is coming in after 2.5 years on the basis of facts which are no longer in existence. There is, in a sense, embellishment, but my lord, not later, but my lord, the facts reported are now in the nature of an embellishment because it no longer exists. It is contrary to para 93. Second, my lord, kindly sees, my lord, para 94. Principles of democracy and liberty demand a regular and efficient check on police powers. One way of keeping check on authorities with such powers is by documenting every action of theirs. Accordingly, under the code, actions of the police are provided to be written and documented. For example, in case of arrest, my lord, 41B was placed by my learned friend, arrest memo according so and so. Then, my lord, para 95 is, my lord, requirement to maintain the records. Then all this is para 96. The underpinnings of compulsory registration of FIR is not only to ensure transparency in criminal justice delivery system, but also to ensure judicial oversight. 157 deploys the word forthwith. Well, Lalita Kumari principle is on the word forthwith, and the entire thing is as early as possible. Here, my lord, this is happening 2.5 years when the cause of action is non-existent. Second kind of FIR, which could be registered by the police itself on any information received or other than by way of informant. The registration of FIR either on the basis of information furnished under 154 or otherwise under 157 is obligatory. Obligation to register has inherent advantages. My lord, A, B, C, my lord, we have seen. Kindly see D. Swift investigation, so and so, rule of law. D. It leads to less manipulation in criminal cases and lessens incidents of antedated FIR or deliberately delayed FIR. This is one of the mischief which Lalita Kumari principle tries to protect, and exactly we are dealing with this. My learned friend, I'll come to Bhajan Lal. This is exactly what the bank is trying to achieve indirectly, what it could not directly. Private and malafide motive, I'll come to that later. It is in fact covered by one of the Bhajan Lal principles. So, my lord, Lalita Kumari, my lord, the entire, and my lord, it is in this context, if lordship reads paragraph 99, which was relayed by my learned friend, it makes perfect sense. I can understand all these submissions are being made in 2021 when the facts on record stand as it is. I would have been thrown out. CBI, my lord, doesn't conduct any investigation in 21, but my lord, forget CBI. I am not on the roll of CBI. My lord, I have a statutory duty, and my lord, I join issue. The statutory duty which was exercised by the bank is not under section 39, but it is under the two RBI circulars, my lord. Just, my lord, quickly I refer to page 43, 47 and 48. My learned friend referred to it. Kindly see, this is the duty. That is why, my lord, kindly first come to page 43. I had shown your lordship. Just quickly, I'll. My lord, 42, I had shown your lordship, my lord, the penal measure in B. Lenders may initiate criminal proceedings. And then, my lord, at 43, just above para 2.6 or clause 2.6, it would be imperative on the part of the bank and financial institution to put in place a transparent mechanism for the entire process so that penal provisions are not misused and the scope of discretionary powers are kept to the barest minimum. It should also be ensured solitary or isolated incidents is not made the basis for him. So discretionary power, barest minimum. And my lord, in line with this, kindly now come to page 47. Lord, why these two words, criminal, and I show from the letter also, criminal breach of trust or cheating are the words copied from the RBI circular. Kindly see page 47. 4.1a, and that is why in the list of dates I showed that first they classified me as a willful defaulter in the identification committee in May 21, and in June, my lord, this complaint was lodged. A is saying it is essential that offences of breach of trust or cheating construed to have been committed in the case of loans should be clearly defined under the existing statutes governing the banks, providing for criminal action in all cases where borrowers divert the fund with malafide intention. And it's a case of diversion of funds in willful default. That is why they make offense of breach of trust and cheating. And this is, my lord, to be read with. And my lord, now kindly see page 48, which my learned friend read. So criminal breach of trust and cheating is mentioned in 47. 48 is, my lord, sections 403, 415 are therefore advised to seriously, promptly consider initiating criminal action. But this is not independent. I join issue. This is that if you come to a finding he is a willful defaulter, you better ensure that criminal actions are also taken of criminal breach of trust and cheating. Because, my lord, it has similar ingredients. I don't say identical. I'll show, my lord, the provision. I was checking up the criminal procedure code. Cheating is, my lord, misappropriation of the property at the first instance. But willful default is, my lord, slightly different. It is while repaying, I have the ability to pay, but instead of paying to the bank, I am diverting it to somebody else. And may I kindly see the second paragraph of page 40, the same page 48. It should be ensured that penal provisions are used effectively and determinedly, but after careful consideration and due caution. Towards this end, banks are advised to put in place a transparent mechanism with approval. And my lord, the entire argument proceeds on the premise, I have reported it, it is for the CBI to do. I am not going to even help the CBI by saying, look, I had reported the fact 2.5 years ago. These facts are no longer existent. You find it out yourself. This is the sum and substance of the argument.
Mr. Chaudhary, you can also inform the CBI.
No, my lord, there is a difference. My lord, in the interregnum, my lord, my harassment continues.
Because the moment an FIR is registered, the complaint loses relevance in the sense that the complaint.
Correct, my lord.
I
I accept, my lord. I am not, my lord. My learned friend conceded that FIR will exist independently. So, my lord, I proceed on the premise FIR exists independently.
Even if you get a relief here.
No, but the question is, my lord, if the FIR exists independently, can this complaint be quashed as on date? In my respectful submission, yes, because the cause of action is no longer existing.
What will be the effect? What is the effective?
Lord, I will take steps, my lord. After the quashing here, I will take steps so far as dealing with the FIR is concerned, either under 482 or under in the magistrate court, wherever permissible. But
Quashing of the complaint, can that be a ground? Now, can you recall the FIR on that or set aside?
Lord, that is, my lord, for the criminal court to decide. My lord, I am also conscious.
What is the date of registration of the FIR?
My lord, it is in 2023 post the Delhi High Court order. 18th August 2023. My lord, what I am on is, it has been admitted that they have given the information pursuant to a statutory duty. The statutory duty is, my lord, in a bank, it is prescribed by RBI circulars. And moment, my lord, the ingredients of RBI circular are absent. That is, I am myself saying that willful defaulter proceedings, I am withdrawing it. It is not falling. Is it also not my corresponding statutory obligation to inform CBI, look, I had discharged my duty. I am not going to, I have myself withdrawn it. But you are at, and let us say even nonetheless, by this time, the CBI might say, no, I have found other ingredients of fraud. I am going to do it. I can still understand. This is where, my lord, it's a breach of statutory duty. Not only a breach, my lord, but it is violative of Article 14. I am not discharging. I am using it that I am using that, all right. I may have failed here, but you get harassed by CBI. All these arguments, my lord, are absolutely correct if it would have been made in 2021, when, my lord, The complaint is standing as it is. Nobody has investigated. Now there is, on the face of it, they are also saying these are not existent.
No, what will you gain even if the complaint is set aside?
Well, if the complaint is set aside, we'll just have the set aside order before CBI let it decide. This is number one. CBI, in the meantime, if it has independent, well, submissions are being made, investigating authority can find other facts. I don't know. I am saying criminal breach of trust and cheating on facts A, B, and C. But today I am forced to admit A, B, and C are no longer in existence. So what?
Like in a civil proceeding, Mr. Chaudhary, in a criminal proceeding, the investigating agency can fish out.
Yes.
Can find.
I am conscious of the, my lord, in rem principle. In rem principle. That, my lord, if a cognizable offense is made, it is against the state.
Against the state.
I understand that. But here, my lord, the allegation is cognizable offense has been made specifically because of A, B, and C. My lord, submission was made. Even if you ignore the forensic audit, there are independent findings of my internal. Their internal investigation don't have a word to say about me. There is a reference to a suspended employee of
Not theirs. Mr. Shane probably indicated that even if the FIR is not there, CBI can investigate on other materials also.
Let CBI investigate it on their employee. Name has not been disclosed by the bank. FIR says unknown public servant.
Even if it is not there.
And my lord, I am not saying, my lord, that they can't, the CBI can't investigate the employee of the bank.
This complaint.
Or even on the basis of this complaint, I am not saying that. But if the complaint goes, my lord, what will happen to CBI FIR, my lord? It's for me, whether my prayers are infructuous or not. My lord, infructuous reliefs are, my lord, decided from the perspective of the petitioner, not from the perspective of a respondent. The respondent cannot say this prayer has become infructuous.
From the perspective of law also, if I
absolutely, my lord, absolutely. My lord, if in law, my lord, a relief is either permissible or not permissible, my lord, that's first law. So that is axiomatic.
So if it merges in the FIR, I mean, now the complaint.
No, my lord, I join issue here.
Explain that.
I join issue here. Merger would have happened if Lalita Kumari principle would have been followed. That is, information given, FIR lodged immediately, no question of embellishment and anti-dating.
Kumari is a guideline, cannot invalidate the merger.
I am following the Lalita Kumari guideline only.
Suppose that
and
is
not, the two
most proximate, then also it cannot vitiate the entire FIR for that.
No. Once, my lord, it is non-proximate, my lord, just as in civil proceedings, my lord, the range of suspicion and the range of abuse comes in. My lord, Lalita Kumari is guarding against two facts. Number one, why immediate FIR? So that you rule out embellishment.
Should be guideline, but if it is not followed.
Why immediate? Because if more delay, the more you can antedate things and you can put in facts like that. Well, here it is a different kind of embellishment. In the sense, it's the reverse of that. I don't say you have to embellish facts over there. But knowingly the facts are non-existent, I keep my mouth shut.
No embellishment. Here it was denuded. The
denuded. Absolutely. It is no longer existent. And but I have shown your lordship the Lalita Kumari paragraphs.
Yes.
My lord, I am on statutory obligation. So my lord, this was as per the master circular on willful default. Master circular on willful default by RBI. We had also relied upon the fraud circular by RBI.
Since Mr. Trivedi is here, you can also add the CBI and we can just hear out the CBI also. I mean, I can quash the FIR also.
Yes. Lordship want. But my lord, I must be candid. But I must be candid, my lord. I am happy. I am happy with the quashing of the complaint. My lord, I must be candid. If the complaint is quashed, my lord, the CBI will do nothing. Because CBI is proceeding on the self-same documents, my lord, which have been mentioned. And that is why, my lord, kindly see, I can understand simultaneously with this, they are going to the local police station and lodging a complaint, my lord, either under 154 or otherwise. Why go to the CBI? It is because of this circular. And it is admitted, public sector banks, 30 million above up to 250 million to CBI to be lodged with anti-corruption branch of CBI, where staff involvement is there. And my lord, they are admitting that I have lodged it in terms of this circular.
Yes.
So I admit it is in terms of this circular. But then when the ingredients of this circular is no longer there, I cannot turn around and say, no, I have done it independently under 39. This is the first fallacy. So, my lord, I have dealt with the Lalita Kumari principle. Now kindly take the next decision, Bhajan Lal ratio. Let kindly come to paragraph 102. Yes, paragraph 102.
Yes.
But I'll read the last principle first and come back to clause 1. Kindly come to my lord, clause 7 in paragraph 102. Where a criminal proceeding is manifestly attended with malafide and where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. Now, my lord, this is one of the ingredients. Let kindly visualize if the same complaint would have been filed today with exact words that was there in 2021, it is filed in 2023. Would it fall under this clause 7? It would have, because the facts are non-existent, it is only maliciously done. Here the maliciousness is here, knowing the facts are no longer existent, the bank doesn't go and inform the police. It's like this, my lord, I report a murder, and after in between 2 years, my lord, the person who is alleged to be dead, my lord, is dining with me, but I don't go and inform the police. And after 2 years, my lord, the accused is arrested. Now kindly come back to clause 1. Where the allegations made in the first information report or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused. My lord, if today these allegations would have come and the bank would have said, yes, I have this allegation, but I am withdrawing the proceedings.
These are grounds for challenge of the first information.
I am, my lord,
I am complaint, you have to take it on the date when it was
lodged. Firstly, my lord, that's my lord, my first distinction. We are not now on the FIR. We are on a step preceding that. My lord, today I am saying if the complaint
was right when it was filed, but today this applies to the FIR.
Absolutely. So if the
challenging the
so
FIR
if the complaint, my lord, let us assume the complaint is right when it was filed.
Yes.
Lalita Kumari principle says if FIR would have been drawn as per the principle, my lord, I had nothing to say. Now, my lord, the FIR is coming at a belated stage.
Right.
In the interregnum, my lord, this writ petition is raising the question when a statutory obligation has been cast by the RBI circular to initiate criminal proceedings on the basis of these facts.
These are very good grounds for challenging the FIR, Mr. Shah.
No, my lord, that's a separate issue, my lord, at the cost of repetition.
All these apply to the FIR.
Correct.
Arguably.
Correct. Because, my lord, this is being relied upon by the complainant. It is like this, my lord. I am saying that I had lodged a complaint 2 years back. At that time, it was perhaps true, but today it is no longer true. Therefore, I don't take responsibility. It is for the authority to go and find it out. I am not going to tell the authority I have withdrawn the proceedings. I am not going to inform the authority the fraud thing has been quashed. I am not going to say that the LOC has been quashed. Now, my lord, in this context, kindly just see one line of the complaint. One line of the complaint, page 68.
Complaint has become irrelevant, Mr. Chaudhary, on many scores.
My lord.
Complaint has become irrelevant on many scores now.
No, my lord, complaint is proceeding on the basis that
willful defaulter not
lord,
there, fraud not there.
My lord, the two wording, criminal, breach of trust, and this has been used, cheating, has only been used in the context of RBI circular fraud. I shall show that.
Yes.
And that is why if the FSI report is no longer there and that willful is no longer, kindly see, my lord, after the tabulation. Complainant bank has declared the account as fraud.
Page
68.
68, I'm sorry. Yes. Complainant bank.
Complainant bank has declared the account as fraud for a sum of 356.55 crore and reported the same to RBI on 11 June 2019 for criminal misappropriation, criminal breach of trust and diversion of fund. So this criminal misappropriation, breach of trust and diversion is the reporting done. The reporting is now quashed, no longer there. And just one para thereafter, it is therefore requested to register FIR in the matter. Now, my lord, kindly comes back to the Bhajanlal judgment, my lord. Before 102, one paragraph I want to show your lordship, paragraph 98, where, my lord, the Scindia case has been referred to.
Yes.
Well, this is paragraph, para 7 of the Scindia case is being quoted. And of course, well, this is pertaining to quashing. But well, kindly see what is the principle. Because these principles have been relied here, I am just responding. The legal position is well settled that when a prosecution at the initial stage is asked to be quashed, the test to be applied by the court is as to whether the uncontroverted allegations as made prima facie establish the offense. It is also for the court to take into consideration any special features which appear in a particular case to consider whether it is expedient and it is in the interest of justice to permit a prosecution to continue. This is so on the basis that the court cannot be utilized for any oblique purpose, and where in the opinion of the court, chances of an ultimate conviction is bleak, and therefore no useful purpose is likely to be served by allowing a criminal prosecution to continue. The court may, while taking into consideration the special facts of a case, also quash the proceedings, even though it may be at preliminary stage. Now, Willard, this is vis-a-vis, I am still in the complaint stage. Now, Willard, kindly visualize if the complaint would have been made as on 2023, whether it would disclose any offense. Answer is no. So what, my lord, the essence of the submission is, when I had made the complaint, it was true. So therefore, it should remain as it is, though the ingredients mentioned therein no longer exist. This is where the malafide comes, and this is where clause 7. It is simply because of the malafide intent of the bank, my lord, they have not withdrawn the proceedings. And my lord, now kindly come back once to the Lalita Kumari one. So far as what is, my lord, commercial aspect, my lord, how it is to be dealt with. Kindly come to the Lalita Kumari decision. Kindly see, my lord, 2 paragraphs. Kindly come to 117. Para 117. Well, this is vis-a-vis the involvement of the provisions of the Prevention of Corruption Act and, my lord, involvement of a public servant. Because, my lord, a twist is being given to the case that this is unique because my own officers are also involved. And independently, this FIR can exist. But I am not on FIR, I am on the complaint. Kindly see, my lord, what Lalita Kumari is saying vis-a-vis this. In the context of offences relating to corruption, this court in Sirajuddin expressed the need for a preliminary inquiry before proceeding against public servant. Similarly, in Tapan Singh, this court has validated a preliminary inquiry prior to registering an FIR only on the ground that at the time of first information is received, the same does not disclose a cognizable offence. Therefore, in view of various counterclaims regarding registration or non-registration, what is necessary is only that the information given to the police must disclose the commission of a cognizable offence. In such a situation, registration of an FIR is mandatory. However, if no cognizable offence is made out in the information given, then the FIR need not be registered immediately, and perhaps the police can conduct a sort of preliminary verification or inquiry for the limited purpose of ascertaining as to whether a cognizable offence has been committed. But if the information given clearly mentions the commission of a cognizable offence, there is no other option but to register an FIR. Well, today, if the information would have been given to police, identical facts, this is there, but we have withdrawn this LOC proceeding is no longer there, it is null. But nonetheless, we feel that they might have committed an offense of fraud or cheating. The CBI or police would have conducted a preliminary investigation because prima facie it would have not constituted any cognizable offense. And in this context, kindly see the conclusions, para 120. I rely upon clause 6. Others are really a summary of what I have just now read. Now kindly see clause 6, 126. As to what type and in which cases preliminary inquiry is to be conducted will depend on the facts, circumstances of each case. The category of cases in which preliminary inquiry may be made are matrimonial, then kindly see B, commercial offenses. C, medical negligence cases. My learned friend cited the Dr. Kunal Shah case. In the event the bank would have informed CBI, look, this is the position today. I am open to the fact that nonetheless the FIR can exist, but the CBI would be compelled to make a preliminary inquiry before lodging the FIR because it's a commercial offense and simply on these facts no cognizable offense is made out.
Aren't all these challenges to the FIR, Mr. Chaudhary?
It may be.
Everything is a challenge to the FIR, whatever you are arguing now.
No, FIR.
There are very good grounds of challenge.
FIR challenge,
Once the complaint was just the genesis of the FIR.
My lord, I am on a point, my lord, this writ petition, why is challenging the complaint? Because, my lord, this is only in respect of the Malafide Act of the bank, because the FIR has come in only in 2023. My lord, there could have been two situations, kindly visualize.
The lodging of the FIR in registering of the FIR in 2023 is itself a violation of Lalita Kumar.
Well, that's an independent cause of action which I have. But kindly visualize the situation as on today when I am arguing the FIR is no longer there, only the complaint is there.
The difficulty is, Mr. Chaudhary, otherwise you have got a very good case definitely, but the right to lodge a complaint, I mean, it must be an extreme case when the complaint is set aside. If a citizen or an entity, they are precluded from making a complaint even.
Well, I am not
that
saying
complaint is yes on the
that is why I have not asked for setting aside of complaint. What is falling from your lordship is absolutely correct.
You are asking for quashing of the complaint and ancillary things.
Well, my answer is what is fallen from your lordship is a perfectly valid question, my lord. Had I made this writ petition in 2021? And the second part of my reply is, my lord, kindly visualize the situation. Forget the principles of merger and all that. I'll show it is not a question of merger. Kindly visualize the situation. CBI has not even today lodged an FIR.
Complaint does not change color. Mr. Chaudhary, complaint was lodged on a particular date.
Exactly.
That is the cut-off date we have to look into.
Complaint,
on that date, it was valid. Now, the registration of the FIR subsequently may be incorrect because on that date the allegations in the complaint are no longer subsisting.
My lord, I am conscious of the fact complaint doesn't change color. That is why
complaint was correct when it was filed. I mean, correct means the facts were there.
The ingredients were there. That is exactly what I want. My lord, kindly visualize. CBI has not yet lodged an FIR.
No, but you are challenging the complaint here.
Yes, I am challenging the complaint, saying that it is no longer valid as on today. Well, it's like this.
Valid for what purpose? For lodging of the FIR, there cannot be any other purpose.
Forget FIR, my lord, it is just because I would have been guilty of suppression of fact if I would have not mentioned the FIR. I have mentioned this FIR. I have not asked for any relief qua the FIR.
You are appearing for?
I complain and information, two different things. I think that is some misconception.
You are for whom?
I am not for this. There is academic discussion. So Supreme Court very categorically said complaint has to be treated as under section 200 before the magistrate.
Right.
When a police report, that is called purely information, not complaint.
Thank
you.
My lord, I have mentioned the FIR only because of the fact I am not accused of suppression. Lordship had asked me
this. No, Mr. Shane has argued on FIR elaborately. I mean, now the FIR has been registered after this.
That is what I am on. So, my lord, the entire submission of Mr. Sen is vis-a-vis or quay the FIR. What the CBI would do, nothing to do with their complaint. Not a single word has been said that what I had said still holds good. That is not the submission. Neither has my submission been refuted that all these facts are no longer in existence. That will not. The response is, it may not be in existence today, but CBI can find out new facts.
Today I lodge a complaint, Mr.
Yes.
Chaudhary. That complaint contains certain allegations which might have been an apprehension, might have been
Right.
correct on that date. That complaint remains the same complaint even after so many years. But the thing which you can challenge is that complaint does not remain relevant now because of the happenings in between.
Right.
So FIR cannot be lodged. But the complaint, when it was lodged, it is still today the same complaint.
This is where
But it's a question of setting it
This
aside.
is where I join issue, my lord, vis-a-vis a complaint by a private citizen and, my lord, an authority within the meaning of Article 12, who is lodging the complaint pursuant to statutory circulars, where, my lord, transparency and not being abused is, my lord, also mentioned over there. Kindly, my lord, the distinctive feature over here is this is not simplicity reporting of information under section 39. This is being done by the two circulars. I have shown your lordship the provision. That is why directly before CBI, because of the circular relating to fraud, and, my lord, this criminal breach of trust, and, my lord, these expressions are, my lord, verbatim reproduction from willful defaulter.
Right.
So, and that is why in the opening argument, I furnished a list of dates. In May 21, they first declare me a willful defaulter. Then in June, they report me in terms of the circular. But then they are forced to drop the willful defaulter proceeding, but they don't report to the CBI saying that I have myself dropped the willful defaulter proceeding.
Right.
And, my lord, kindly, my lord, do not link the FIR with the writ petition in any way, because, my lord, let us assume the FIR was not existent today. My lord, if I ask the question, could I have still filed the writ petition and say, well, look, they have kept this complaint still alive without informing it is no longer, there is no cause of action surviving vis-a-vis the complaint. My lord, in my respectful submission, I could have come. And, my lord, this approaching the court is delinked with FIR. Conversely, my lord, if lordship quashes it, the CBI can still continue the proceedings. I accept, I am ad idem with my learned friend in this. If they have any other independent findings, my lord, in the meantime, they can still say, well, I have found out new facets of fraud, I'll continue. But, my lord, this is quay only the bank. And the fact that, my lord, they have, the CBI complaint is there only to avoid any allegation of suppression. I have ensured that instead of attacking the complaint in 2021, I have attacked the cause of action of the complaint, and each of the cause of action have been quashed. And after that, my lord, I have come and I am attacking the complaint, saying these, as on this date, my lord, the cause of action is illusory, as on today. As on the date, my lord, it was correct. My lord, the second aspect, my lord,
Other matters are released. I mean.
my lord, an argument was advanced that no legal right of mine has been infringed if the investigation goes on. This is the argument advanced, that this proceeding should be dismissed because no legal right of the writ petitioner has been infringed merely on an investigation. The CBI may still choose not to proceed further. This is the sum and substance of the argument. But I have twofold submissions to make apropos that. Well, the first infringement of my legal right is under the RBI circulars, which permits me to challenge the civil proceedings in the manner envisaged thereat, and if it is successfully done, casts a corresponding obligation on the bank to discharge with full transparency its obligations. I have shown your lordship the provision. So while initiating the criminal proceedings, I fall back on the willful defaulter circular or the fraud circular. But when these two are no longer in existence, I don't go and inform the police or the CBI, these are no longer in existence. And then say that still then the accused, I am the accused. I don't have a right to challenge it. My lord, with respect, my lord, this is squarely hit not only Article 14, but also Article 21. My right to life is, my lord, to live with dignity. And over here, my lord, after I have been successful in getting these charges against me set aside, my lord, why will the bank not inform to the police that what I had told you 2 years back is no longer in existence? They are only to inform. They are not to say, advise the CBI, you quash the FIR. I am not saying that. And it is this lack of, my lord, corresponding obligation which their bank has not performed, my lord, which the writ court should interfere to protect my right, my lord, violation of Article 14 and 21. And my lord, prayer G has already been shown to your lordship. Why should I have to come and seek a prayer G, my lord? Is it not obligatory or not implied in the RBI circular itself that you should act with full transparency and you ensure it is not abused? I initiate all these proceedings. When I fail in that, I keep quiet. Let the CBI go and harass him. Why? This is where, my lord, the malafide is coming. Article 14 is getting attracted. The silence of the bank, my lord, here is attracting Article 14. In not reporting to the authority that what I had told you 2 years back is no longer in existence. And my lord, if prayer G is granted, my lord, if I put the question in the reverse way, what prejudice can the bank suffer? That bank is directed to inform the CBI that this is no longer there. I have withdrawn myself. This is the letter. LOC proceedings are no longer there. So, my lord, I join issue, my lord, that no right has been violated because, my lord, my rights have been violated and this statutory obligation is vis-a-vis, my lord, the RBI circular. And, my lord, my second submission is that here the bank is not simpliciter under the actions of the bank is not to be judged simpliciter under section 39 of the CRPC, but, my lord, it is to be judged vis-a-vis the RBI circulars on the basis of which it had initiated. And, my lord, at the cost of repetition, my lord, if they have any independent fact, they can. Now, my lord, apropos the forensic audit report, just 1 minute, my lord, one document, and I shall finish. Well, kindly come to page 180. Because, my lord, there are 3 parts in the written note. The submission is, well, that has been set aside. It is only for the purpose of IBC. The audit report can exist independently. Then, my lord, in LOC, well, that has been set aside, but these are only for the purpose of this can exist independently. Fraud, that has been set aside, but bank submission is that all this can nonetheless exist independently. My lord, let us deal with that. Let kindly see, my lord, 118. Yes. This is the finding of NCLT. This is a quote from the auditor's report. 7th line, my lord, in the quoted portion. We did not independently verify the accuracy, reliability, genuineness of the information provided by them or from the independent.
That is in all the.
Hence, my lord, kindly see. The content of this report should not form the sole basis for any decision as to a potential course of action without independent confirmation of its finding, nor should it be relied upon as a preferred advice on assets liabilities in question for which the company.
Mr. Chaudhary, forensic audit reports cannot be the sole basis of any declaration. Willful default.
I am obliged.
Willful default or fraud, nothing.
Kindly.
All the reports contain this, and each and every of the reports, they cannot be the sole basis at all.
Other than the forensic audit report in the complaint.
In this case, no, nothing.
And that is why, my lord, they withdrew the willful defaulter proceeding because they did not have anything. Well, all these allegations that I have transferred from company A to company B and everything, my lord, it's identical over here. And on that basis, you are asking CBI to initiate a complaint. Well, those are my respectful submissions. Does lordship want that we also file a written note? My lord, I have answered it, my lord, it is there.
But very deeply obliged to your lordship, Lord. I think the learned PP had better be careful. Mr. Chaudhary is a worthy alternative. Mr. Shashwata Gopal Mukherjee, learned public
My learned
prosecutor,
friend now wants to shift me to the other side.
should be very careful now. Very deeply obliged to your lordship, Lord.
Counsel for parties, hard learned counsel for the parties, written notes of arguments filed by the petitioner be kept on record. Full stop. View of-
Filed by the respondent.
I'm sorry, by the respondents be kept on record. Full stop. In view of elaborate and extensive oral arguments, comma, no further written notes of arguments need be filed by the petitioner. Full stop. The matter is reserved for judgment.
Great.
Oh. तो चले जाओ.
The next matter.
Next matter on the next day.
My lord, may I mention item number 26, my lord, the interim order is expiring on 19th.
5 minutes after I rise, mention it.
Item number 8 and 9, my lord, we were challenging the willful defaulters, the identification committee report. My lord. Thereafter, my lord, they have submitted the review committee has furnished their report. My lord. We have challenged that.
Is mentioned tomorrow morning at 3 p.m. when I take up the original set matters.
My lord.
Give a notice to the other side.
My lord, the other side is there. I'll mention tomorrow.
My matter will be the first matter.
Your matter last.
My lord, so
No,
we have
it is
filed.
item number 2.
So we have filed 2 other writ petitions. My lord, challenging the review
Take up
committee order.
tomorrow. Why the panic?
No, we've just filed it, my lord. So if my lord desire, my lord, that we hand over the number of writ petitions to my lord's bench officers, my lord.
Which one?
8 and 9. 8 and 9. Because that was with regard to the identification committee order. my lord.
What are these? I don't understand.
Review committee orders, they have also been challenged, my lord.
Oh, আচ্ছা আচ্ছা এই দুটো কানেক্টেড
The
তাহলে
review
7 and 8
committee
এর সঙ্গে চলে যাবে. This has to be tagged with 7.
Yes. I'm so grateful.
See you, Richard.